of the Triennial Review. It is 8 a.m. Welcome to the commissioners, the parties, and members of the public. Pam, do you want to take roll call?
Yes, I will. Good morning, commissioners. Let me begin with Commissioner Candelaria. Are you present? Commissioner Certain.
Here.
Commissioner Dominguez.
Present.
Commissioner McWilliams.
I'm here.
Commissioner Modi.
Present.
Good morning. Commissioner Musharafi. Commissioner Patton.
Here.
Commissioner Rader.
Here.
Commissioner Cipher. Commissioner Thompson.
Here.
Did I hear somebody say here? Commissioner Timmons. Commissioner Vigil.
Here.
Vice Chair Wade.
Here.
Chair Stringer.
I'm here.
Thank you. Let me run through this one more time. I don't believe Commissioner Candelaria is here, or Commissioner Musharafi. Commissioner Cipher, have you joined us? Commissioner Thompson, have you joined us?
Yes, I'm here.
Thank you, Commissioner. Commissioner Timmons. Okay. Mr. Hearing Officer, Madam Chair, you have a quorum of the board.
Thank you. It is my understanding that we have two members of the public who wish to make comment. Is that correct?
Yes, I was contacted yesterday by Teresa Seamster. I think she already spoke. And this morning, Frere Marie, are you with us?
Yes, I am.
Very good. If you would turn your camera on and speak up.
Good morning. Can you see me?
Yes. Before you make your comment, the court reporter is going to swear you in, and then you will have up to 5 minutes to make a general comment.
Would you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Would you please speak up, and would you please state and spell your full name?
Yes. It is Frere A. Marie, F-R-E-Y-R, initial A, Marie, M-A-R-I-E.
Thank you. And Mr. Hearing Officer, would you please mute your microphone? Thank you.
I want to voice that I am in support of the comments made by Communities for Clean Water. I affirm that the Commission should adopt a definition of climate change that identifies human activities as a major cause of climate change and specify combating climate change as a purpose of the regulations. I affirm the adoption of a contaminants of emerging concern definition that clearly gives NMED the authority to monitor CECs. I support adding Pfas to the CEC definition as an example of CECs. Pfas are substances that are a group of man-made chemicals that research has shown to affect reproductive health, increase the risk of some cancers, affect childhood development, increase cholesterol levels, weaken immune system, and interfere with the body's hormones. There has been exceedances of these chemicals at LANO contaminated sites. Due to these reproductive harms, it is important to center those most impacted, and this includes Indigenous pregnant people, and an Indigenous pregnant person should be that standard for measuring the impacts of these chemicals. I affirm the opposition to LANO's proposal to weaken HHO criteria because the fish we catch in our rivers.
Excuse me, I've lost your audio.
I'll reread the last paragraph. I affirm the opposition to LANO's proposal to weaken HHO criteria. because the fish we catch in our rivers, streams, and reservoirs and lakes must be kept safe to eat. I affirm that New Mexico should not cede its authority to identify and regulate toxic pollutants based on an outdated federal list of toxic pollutants. I affirm this proposal would prevent effective monitoring of PCBs and Pfas. I object that the U.S. Department of Energy and LANO are spending taxpayer dollars to fight state efforts to protect waters from persistent harmful pollutants. I also would like to state that it is not the working class who are causing climate change, but those with wealth, in addition to state working in collaboration with corporations regarding resource extraction, particularly in rural, low-income, and tribal communities. These corporations and leasing agreements should, without a doubt, include accountability for environmental cleanup beyond minimum regulation, but to the maximum of environmental health. There needs to be particular accountability when water is harmed through extractive efforts, and accountability to any and all cleanup to restore the health of the water system. Intermittent and ephemeral streams should be included in waters with environmental protections, in addition to aquifers and groundwaters, and must have stringent environmental health standards in the event of spills, accidents, or releases. Public land should not be leased for extractive efforts for coal and fossil fuels. Public land should only be used for renewables that do not consume or poison water. The statement is here to affirm again the CCW comments and to emphasize that climate change is human caused and must be identified as such in any and all statements that pertain to water quality issues. And the NMED should have the authority to monitor and hold parties responsible for using and introducing said contaminants of emerging concern. It is clear that LANO and a mining association are opposing adding a CEC definition and monitoring because they do not want to be held accountable. LANO and a mining association's comments that oppose the adding of a CEC definition should be disregarded and treated as highly suspect, as they are some of the polluters that have released these contaminants in the environment and have sites that have yet to be cleaned up. Thank you for your time.
Thank you. Pam, do we have another public member who has not already made a comment?
No, we do not have any more.
Okay. Okay, let's proceed to the day's procedural discussion before we actually start taking testimony. My records show that yesterday we left off on issue number 5. The department's witnesses testified, but were not cross-examined by the commission, which we will do. I have 2 witnesses where the parties have requested being taken out of order. I'm not sure of the actual hours they are both available. So CCW, what hours today is your witness named Sanchez available?
Thank you, Mr. Hearing Officer. Kathy Sanchez is here right now, and I believe she is going to be available all day. So we have some flexibility.
Wonderful. Thank you, sir. Amigos Bravos, what hours is your witness, Dr. DeWitt, available?
She's available after 9:30 our time, and we were suggesting that she go earlier rather than later since she's addressing subjects that have already been discussed.
Okay. All right. I will accommodate those. Are there any issues before I continue with my issues from any members of the commission before we begin? Are there any issues from any parties that we need to deal with before we begin?
Mr. Hearing Officer?
Yes, Mr. Rose.
Yeah, just one housekeeping issue that we didn't get to yesterday, and that's the department presented, and I think offered, and you admitted their Exhibit 139, which references a UAA, which I understand is in the record of this proceeding. I think it's their Exhibit 9. The letter that ED Exhibit 139 references a request from the department. wanted to see whether the department had planned to make the request part of the record as well.
Department?
Mr. Hearing Officer, I'm going to have to check with my witnesses and see if that's available, but we'll do that during the next break.
Okay, Mr. Rose, we'll come back to that, but, and I have it highlighted, so we'll deal with that. It is in evidence, though. I did ask all the parties yesterday if there was any objection, and I think what you're referring to is the rule of completeness. So for context, you would like to have the request as part of it, and that is understandable. So we will deal with that. Are there any other issues? Yeah, you're welcome, Mr. Rose. Are there any other issues from any party before I continue? Okay, we are on day 4, and we have proceeded a little bit over half of the testimony. Now, the parties agreed in the scheduling order to a maximum summary of 30 minutes and then to stand for cross-examination. I don't believe that reading from a pre-filed technical testimony is a summary, and I am going to be watching for parties to be using that time for summary to focus on a summary that is understandable for the public, as this is a public hearing and public participation is critical. So that's number one. And number two, I am going to be limiting cross-examination to questions that elicit fact and not legal conclusions, as I mentioned yesterday. So with that, I am going to turn over the hearing to any commissioner who wants to cross-examine the witnesses that the department put on yesterday, which were Ms. Fulham, Ms. Lemon, and Ms. Aranda.
Mr. Hearing Officer, this is Commissioner Patton.
Please.
Thank you. I have just a couple of questions. I believe it's for Ms. Aranda, and it's related to the existing use analysis that was discussed yesterday, and then I think it's 20.6.4.103. Is Ms. Aranda there? Okay. So in the, I think it's exhibit 56, there's a mention of perennial reaches and tributaries of the Rio Grande and Socorro and Sierra counties. And it basically says that it's going to remove those reaches because there's not sufficient data. But then it has an exception of 6 different creeks: the Rio Salado, Percha, Alamosa, Abo Arroyo, Los Animas Creek, and Palomas Creek. And then it goes on in what's proposed in Exhibit 110. There's a paragraph under 20.6.4.103, kind of I don't know, an addendum to the proposed rule, which only lists 5 of those creeks, and it does not include Los Animas Creek. And so I guess the question I have is, was that a decision to not include Los Animas Creek in that paragraph, as well as withdrawing it and putting it in a new section under 20.6.4.112, I believe, or where would it fall, I guess is the question.
Are you talking about Las Animas Creek?
Yes, ma'am.
From what I understand, we took all the segments from that section, the 103 section, and took out any creek that wasn't included. So that would mean that, let me see if Las Animas had data, because So Las Animas had data, therefore it stays in 103. Does that clarify? That's why it wasn't excluded.
So
Am I making sense?
maybe, so do you see this is Exhibit 110, 20.6.4.103. And
Okay.
at the end of that proposed section, there's a new addition of a note. And it includes 5 of those 6 streams that I mentioned previously. And it says those 5 streams are being moved over into section 112 because they're perennial reaches of the Rio Grande between Caballo Reservoir and Elephant Butte. And then it lists those 5.
Yeah,
And those 5 had data for
correct.
the existing use analysis. But Las Animas Creek also had data in the existing use analysis, and it's not included in 112. And so I guess I'm trying to figure out, is it still going to be part of 103, or should it be listed in 112 because it had data for the existing use analysis?
Yeah, I see the issue. So it seems that 112 would need to include Las Animas Creek in order to be.
Okay. Thank you,
So-
Mr. Hearing Officer. That's all I have.
Thank you, Commissioner Patton. Are there any other commissioners with cross-examination questions? Mr. Dominguez?
Yes, sir. Thank you, Mr. Hearing Officer. A follow-up question from something that was brought up yesterday during cross-examination, and I'll take a stab at this question. If it's too far off base, I'm sure Mr. Verheul will rein me back in. So I'll open the question to whoever within the panel wants to take a stab at it. But it was brought to light yesterday about timing of the finalization of the EUA. And if I understood correctly, that was finalized in May of 2021. So the question is, when the original petition was submitted in August, was the preliminary data far enough along in the EUA to base the proposal on, or was the proposal that was submitted in August what was hoping to be achieved out of the EUA? Did that question make sense? And I'll open it up to whoever on the panel wants to take a stab.
Commissioner Dominguez, Mr. Hearing Officer, Madam Chair, thank you for the question. I think that it's a good question, and it's good to clarify. These analyses, whether for any designated use, take an enormous amount of time and energy and resources. We did have a draft that was being internally reviewed. So we did have the preliminary data, but there was a lot of checks and balances to make sure that it was ready for public consumption. So we did have enough preliminary data to think that we would be able to fulfill the demonstration in August. And that's why we put it in the petition.
Okay, thank you for that clarification, because you can probably understand from a public view standpoint that almost looks a little bit fishy from surface value, that it's the cart before the horse. So just wanting to really get that clarified on the record. So that's helpful. Thank you. Mr. Hearing Officer, that's all the questions I have.
Thank you, Commissioner Dominguez. Are there any other commissioners with questions for the 3 department witnesses?
Mr. Hearing Officer, this is Commissioner Thompson.
Yes, Commissioner Thompson.
I have questions for Ms. Aranda on your testimony, which is NMED Exhibit 3 on page 13 of your testimony. It appears that you're recommending that the designated use for section of the Rio Grande, that would be 20.6.4.103, should be primary contact. However, Exhibit 110, 20.6.4.103 is still listed as secondary contact. Is that an oversight, a mistake, or did I miss something?
No, I agree with you. It was a editing mistake. 103 remains secondary. 112 has been moved, and that one is primary. So you are correct.
Okay, thank you. The other concern, it's a little bit more substantive. On the same page of your testimony, that's Exhibit 3, page 13, you are discussing the designation of the Rio Felix. That's section 20.6.4.206, I believe.
Yes.
And I'm a little bit troubled in Exhibit 10, in Exhibit 110, excuse me, the Rio, it now reads, and this is section 20.6.4.206, Pecos River Basin. It now reads, perennial reaches of the Rio Felix and perennial reaches of tributaries to the Rio Hondo downstream of Bonnie Canyon, excluding North Spring River. And so as I read your testimony in the exhibit, you want to designate Rio Felix as primary contact and the rest of the reaches identified in the same section as secondary contact. Is that correct?
So the perennial reaches of Rio Felix are gonna remain secondary.
Okay. And what about the other tributaries to the Rio Hondo downstream of Bonnie Canyon? Will they be secondary or primary contact?
So the perennial reaches of the Rio Hondo are now under 231. 20.6.4.231.
Yes, I saw that. And I guess maybe I'm just confused. I'll need to look at it some more. And I would ask that you look at it also to make sure that there's no contradictions.
I agree. Thank you.
Thank you.
I appreciate that.
That concludes my questions, Mr. Hearing Officer.
Commissioner Thompson, if you want to repose your question later today, please, at any point, we'll retake it.
Thank you.
Are there any other commissioners with questions? Are there any members of the public with questions for these 3 witnesses on these topics? Mr. Verheuel, it's my understanding that we are continuing with any redirect questions for these witnesses before we move on. Has that been done yet?
It has not, Mr. Hearing Officer. Thank you for the opportunity. I just had a very brief redirect from Ms. Aranda. And this is to clear up some of the confusion that's been sown with respect to the existing use analysis, and also to just correct a misstatement yesterday from Ms. Aranda's testimony. So, Ms. Aranda, I'm talking about the proposal to change the use from secondary contact to primary on segments 103, 116, 204, 206, and 207. And this is on page 12, or yeah, talking about the changes to those segments. You familiar with that?
Yes.
It's
But just for clarification, 103, as it was corrected from the commissioner, that would be 112.
Yes. Thank you. Okay. So on those, I think you may have misspoke yesterday. If the recreational use changes to primary, can secondary uses still occur?
Yes, all uses as described in the secondary use definition, they can still occur if the designated use changes goes from secondary to primary.
Okay, great. Is it your understanding, based on your, excuse me, participation in putting together this existing use analysis, is it your understanding that at the last triennial review, the WQCC requested water quality data to show that primary contact could be achieved, and San Juan Water Commission argued that such data would be necessary for that change?
Yes.
Okay. Ms. Aranda, on the EUA itself, Exhibit 56 on page 10, it states, and I'm just going to read this to be fast. During the hearing in October 2015, the Commission heard oral testimony on the matter, to which NMED presented field observations, website reviews, and expert testimony as evidence to support primary contact recreation was occurring. Ms. Aranda, is it your understanding that that evidence was submitted during the last triennial review?
Yes.
Okay. And my last question is, did any Surface Water Quality Bureau staff visit these sites that we're talking about to collect the data that's used in the EUA?
Yes.
Okay, thank you. Mr. Hearing Officer, I have no further redirect questions for these witnesses on these topics.
Ms. McCaleb?
I have no questions. Thank you, Mr. Hearing Officer.
You're welcome. Okay, let's proceed now to the next party with witnesses who have direct and rebuttal testimony on issue 5, and I believe that's the Department of Energy and LANL.
Mr. Hearing Officer, this is Louis Rose. We have 4 witnesses on this topic. I will be presenting 2. Ms. McIntosh, I think, will be presenting the other 2. And we're starting with Dr. Dale, who's been sworn and has already testified.
And Mr. Rose, are they going to stand for cross-examination as a panel?
We thought that might be a bit unwieldy in terms of numbers, so decided no. They'll be subject to cross individually.
Okay, please proceed.
Dr. Dale, could you give us a summary of your direct and rebuttal testimony?
Yes, I'd be glad to. Chair Stringer and members of the commission, thanks for the opportunity to present testimony today. I'll be speaking to topic 5, specifically the review and amendment of water quality standards, which includes the standards themselves, existing use, and UAAs. In my direct, I addressed, or in rebuttal testimony as well, I addressed the clarification language that NMED proposed for the 20.6.4.15, the use attainability analysis for a change or removal of designated uses. A new language that has been provided by the department is largely welcomed by LANL, and the new language requirements that are being proposed clarify for outside parties to a nice detail what is necessary for a work plan under which outside parties must attain the approval of NMED to carry out use attainability analyses. NMED adds clarifying language throughout Section 15 as to when, why, and where and how use attainability analysis may or must be performed. NMED's language we have a few suggestions that would be a benefit to this section. We recommend that the NMED, working with the Water Quality Control Commission, consider modifying the new proposed heading, and this is a quote, the mechanism to remove a designated use, and this is at 20.6.4.15b as in Bravo, and change that to quote, conducting a use attainability analysis. And the reason being is that it's not just about removal of designated uses, it may be about modifying them to a more or less stringent or strict designation. Second, NMED added the term current use, which Lannel takes to mean existing use. Because existing use is already common parlance for the UAA and elsewhere in the rule, we think that the current use should be removed or replaced with existing use if we have the interpretation correctly. And then finally, Lannel does ask, for the sake of regulatory certainty, that NMED work with the WQCC to edit the section to include a succinct review period for outside party work plans for the use attainability analysis. And the reason is that it would be consistent with what NMED is promoting for this triennial review regarding providing timelines, outside parties providing timelines for the production of a use attainability analysis from scoping all the way to presentation before the commission. I happened to work and review many work plans when I was an employee of NMED, and I do know that this is the part of the process that tends to take a while, and some of it necessarily because the department wants to carefully consider what is being proposed in the work plan. But I think a timeline would be consistent with what NMED is asking of outside parties as well. So in regard to the existing use analysis, we've heard yesterday and will hear today of this new tool to assess whether a body is able to attain a particular designated use. I think maybe the name seems to be a little bit unfortunate because, as we learned yesterday, a designated use is something we believe the water body is able to attain. But if the designated use is incorrect, there is this method to change the use or remove the use, as you know, through the UA process, which collects substantial data to support the change. Existing uses, if they are indicated, is not something that can be removed. And Lannel, in my direct testimony, stated that there was a concern that if truncated data sets or not all of the data that was available to NMED to make these sorts of evaluations are considered and either their use or non-use defended in detail, that it could lead to a scenario where an existing use, which can not be removed, is applied to the water body. So we believe that if the existing use analysis is going to be the tool by which NMED adopts existing use protections, that it at least be as stringent as the data that is collected for the use attainability analysis. I think in closing, what I want to say or make clear here is that when we reviewed work plans from outside parties, when I was an employee of NMED, we did not want the petitioners to presume outcomes. In fact, we struck language in these work plans that were suggestive that we're going to work our way to this presumed outcome. And I think, in essence, even though moving a use to a more stringent use does not require a UAA, I think the same stringency and robustness of data consideration needs to happen. And it is at the point where you arrive at a conclusion that NMED can then call this either a UAA or a EUA as appropriate to the outcome. Thank you.
Dr. Dale, were you present during the department's direct and cross-examination yesterday and this morning?
Yes.
And do you have anything to add or any comments on their testimony?
I do have one comment on the use of the EUA in regard to changing waters from secondary to primary contact. This is a subset of waters that were discussed in the 2013 Triennial Review. I think it's probably the case that at least some of them, it's been a long time, would benefit from a primary use contact. That's not in dispute. My concern is the manner in which the supporting data is being used to promote these waters to primary contact. Just because a water body can meet those criteria does not really demonstrate the use itself. So I would promote caution in utilizing just the water quality data to designate the existing use for the water body.
Do you have anything further in response to the department's proposal or the rebuttal testimony submitted by other parties?
I do not at this time.
Mr. Hearing Officer, Dr. Dale is available for cross-examination.
Are there any parties that wish to cross-examine Dr. Dale? I see Mr. Verheuel. Are there any others? Okay, Mr. Verheuel, please.
Thank you, Mr. Hearing Officer. Good morning, Dr. Dale. Dr. Dale, are existing uses the minimum requirement for protection of water quality?
The minimum meaning that there's additional protections that are not the 101A uses.
Right.
I can ask. Yeah, I think they're the minimal. I could agree with that.
Dr. Dale, do you remember on the first day that you testified in this proceeding, I asked you if you had listed out the matters that you worked on when you were at Nmed as an employee?
Yes.
And you said that in your opinion, no, you were not providing any testimony in this proceeding that was substantially related to the matters that you worked on while you were an employee at Nmed. Is that right?
Correct, although I must admit I'm not familiar with Ms. Aranda's exhibits and whether my memorandum, which addressed some of these segments, was in the record for this 2020 Triennial Review.
Do you recall if you testified as to these matters during the last Triennial Review?
I don't believe I did. I think I provided a memo to the people that did testify on behalf of primary contact water designations.
Okay, thank you, Dr. Dale. Mr. Hearing Officer, no further questions for this witness on this topic.
Okay, are there any commissioners who have cross-examination questions for this witness? Are there any members of the public who have cross-examination for Dr. Dale? Mr. Rose, is there a redirect on that one point?
No, Mr. Hearing Officer.
Would you like to call your next witness?
I would. I'd like to call Dr. Toll and excuse Dr. Dale here so we can switch. Excuse me for a moment, Mr. I'm shuffling through papers because I'm looking for something I can't quite find.
I'll take this moment to ask Ms. Jones, are there any members of the public who have signed up for comment?
I have one signed up at 5 o'clock, sir.
Thank you.
Okay, Mr. Hearing Officer, Dr. Toll, you've been previously sworn, as I understand it.
That's correct.
Have you reviewed your written direct and rebuttal testimony on item number 5 in preparation for testifying in this hearing?
It's rebuttal testimony
Only?
only, and yes, I have.
And could you briefly summarize for the commission your rebuttal testimony?
Yes, the rebuttal testimony is pertaining to section 20.6.4.10b. And my testimony is that it's inaccurate to characterize the proposed amendment to 20.6.4.10b NMAC as a clarification. The clause would substantively change, not merely clarify 20.6.4.10 NMAC.
And could you explain why you believe that it's a substantive change as opposed
Yeah.
to merely clarification?
Yeah, it's subtle. The first point is I'm just not going to talk about the current version of 20.6.4.10b because I agree that the modification provided by NMED could be adopted with amendment. And so I'm going to start with what NMED has proposed. It's a 3-sentence clause, 20.6.4.10b. I'm going to read it. NMED has proposed that it should read, it is recognized that in some cases, numeric criteria for a particular designated use may not adequately reflect the local conditions or the aquatic communities adapted to these localized conditions. In these cases, a water quality criterion may be modified to reflect the natural condition of a specific water body. When justified by sufficient data and information, a numeric water quality criterion may be adopted or modified in accordance with 20.6.4.10F and 20.6.4.10G NMAC to protect the attainable uses of the water body. The concern that was expressed in my rebuttal testimony, i.e. that this is more than a clarification, it would substantively change 20.6.4.10, could be resolved by deleting the second sentence from the proposed text. The second sentence reads, in these cases, a water quality criterion may be modified to reflect the natural conditions of a specific water body. The rationale for the concern expressed is that sentence specifies that the site-specific criterion must reflect the natural condition of the specific water body. 20.6.4.10d defines the terms under which the commission may adopt site-specific criteria. It says the commission may adopt site-specific numeric criteria applicable to all or parts of a surface water of the state based on relevant site-specific conditions. It then goes on to list those conditions. Adding another condition on commission adoption of site-specific criteria, i.e. that the site-specific criterion must reflect the natural conditions of a specific water body, substantively changes the authority of the commission when it comes to adopting site-specific criteria. And placing it outside of 20.6.4.10d creates confusion because that's where the conditions for defining site-specific criteria are defined. So this is the basis for LANL's recommendation, which I'll state for the record. LANL recommends that the commission adopts a modified version of NMED's proposed modification to 20.6.4.10b with the second sentence deleted. So it would read, it is recognized that in some cases, numeric criteria for a particular designated use may not adequately reflect the local conditions or the aquatic communities adapted to these localized conditions. When justified by sufficient data and information, a numeric water quality criterion may be adopted or modified in accordance with 20.6.4.10 F and 20.6.4.10 G NMAC to protect the attainable uses of the water body. One point of clarification here is that what is referred to in in NMED's language as 20.6.4.10F is what presently is 20.6.4.10D. They've suggested other modifications to 20.6.4.10 that have resulted in renumbering the subsections. So, so the only change that I'm recommending on behalf of Lanel to this modification is the striking of the second sentence.
And Dr. Toll, were you present and when NMED presented its direct and rebuttal testimony earlier in this proceeding and during cross-examination of their witnesses?
I was.
And is anything, first, is there anything that, with respect to that testimony, you wish to respond to?
No, there's not.
And as a result of that testimony, have you revised your position and recommended change to the standards?
Yes, I originally suggested that the revision to 20.6.4.10 be rejected. I've modified that now based on what I've heard in this hearing to suggest that it could simply be modified or amended so that the second sentence is removed.
Mr. Hearing Officer, that completes my questioning of Dr. Toll.
Is there any cross-examination from a party? Is there any cross-examination from a commissioner? From a member of the public? Mr. Rose, would you like to present your next witness?
I'm not going to be presenting. Ms. McIntosh is, and they're here, so we will change groups here and you can proceed. Thank you, Mr. Hearing Officer.
Thank you, Mr. Hearing Officer.
Thank you. Good morning, Ms. McIntosh.
Good morning, Mr. Hearing Officer.
Do we have Mr. Gallegos or Mr. Meyerhoff?
Dr. Meyerhoff is our first witness, and then Mr. Gallegos will present. And a slight revision to what Mr. Rose said, these two witnesses' testimony is sufficiently related that we will have them, or we propose to have them for efficiency sit together for cross, if that's permissible.
It definitely is. Thank you.
Very good. May we proceed?
I think Dr. Meyerhoff is already under oath, so yes, please proceed.
Thank you. Dr. Meyerhoff, did you provide pre-filed written direct or rebuttal testimony regarding NMED's proposals concerning existing use analysis?
Yes, I did.
Can you please summarize your testimony on the existing use issue?
Yes.
And Mr. Hearing Officer, we do need permission to share. We have a PowerPoint demonstrative exhibit that was previously presented. And I believe Ms. Jones needs to give us permission.
Or Ms. Corral, whoever is available.
Give me 1 second, Mr. Hearing Officer.
Yes, Ms. Corral. There you are.
You should have.
Yes, thank you.
Okay. It was set.
Dr. Meyerhoff, can you please summarize your testimony on the existing use issue? There, no, wait.
Yes.
There we go.
All right, I'm going to, next slide, please. I'm going to focus my testimony in particular on the process to evaluate existing uses. throughout my testimony, make a general statement here that the process that's been used by the department to evaluate existing uses is unclear. And the importance of being clear and having a process is an admonishment by EPA about the importance and have to have a high degree of confidence when making a finding that a use is existing. As has been testified by several others, once you establish an existing use, it cannot be removed. So EPA has gone to great lengths to provide guidance on how to do this and to be transparent and clear in your decisions. Next slide. Probably one of their key statements is in our exhibit 32, which is the so-called Smithy Letter. It was referred to yesterday. It is a letter sent to the state of Oklahoma to provide guidance, and it's also on EPA's website under their Water Quality's Handbook. In there, they emphasize what they mean by a use. So when they say the phrase existing uses are those uses actually attained, they're talking about both use, can you use the water for that function, and the water quality necessary to support the use. The EPA even went so far as to explain what they mean by use by noting that a water body may have a distinct purpose, such as can you swim in it? Can it be used for a drinking water supply? Or the function of the water, for example, as a habitat for different types of aquatic life. Ultimately, both should be looked at, and it's very important to maintain and protect the use, not the specific water quality parameters. Next slide. So in reviewing the two examples that we have of existing use analyses, one has been testified extensively yesterday, Exhibit 56, which was the review of primary contact waters and selected waters in the state, as well as there's an Exhibit 73, which focused on existing use analysis in Section 128 waters on landowner property. Our finding is that the emphasis is almost entirely on water quality. The actual analysis of can the use be attained is missing or extremely limited. Next slide. With Section 28 waters, there's a statement made that no determination could be made with regards to the current designation, which is secondary contact. Could not make a decision whether or not that was appropriate or not still at this time because there was no E. coli data available. However, the document failed to mention that there was a use attainability originally done on these waters in 2007 by the department, submitted to EPA, and it was approved by EPA for the purposes of accepting that these waters were secondary contact. That use attainability analysis includes an analysis of the flow conditions, which is appropriate to look at whether or not the use can actually be attained, in this case, swimming. And the conclusion was the waters were too low in depth and such you could not do primary contact recreation. We talked quite a bit yesterday. There was testimony about the other waters and the emphasis on water quality. I think was moved to the next slide. But we have an additional concern. Water quality is important as a factor to look at, but at the same time, it's important about how you look at the water quality. There's a statement in Nmed Exhibit 3, the testimony of Ms. Aranda, at 12 that states if the water body segment contained at least one E. coli sample result equal to or less than 410 colony-forming units per 100 milliliters, then the existing use was determined to be at least primary contact. So regardless of the size of the data set, the implication is that if you had one data point, that was sufficient to make a regulatory decision. This is a concern because the criteria that are being referenced here, which are in 264900 INMAC, as was correctly stated, are US EPA recommended criteria. And their guidance from 2012 includes three parts. It's not just the value 410, it also includes a duration and frequency of exposure. And this is consistent with other EPA criteria, especially metals, which always include these three components: magnitude, duration, and exposure. And of course, with one single sample result, you cannot evaluate duration and frequency. As part of my review then, I was curious, how does the state evaluate use attainment for other purposes? The state is required, just like any other state, to prepare an integrated report every 2 years, so-called 303D, 305B integrated report, and it relies on a methodology, which which is included in the Comprehensive Assessment Listing Methodology, or CALM. And there is a section in there about evaluating contact use support in relation to bacteriological data. And in that document, they make it clear that you must have at least 4 sample results to assess contact use support. Our position is that if that is the minimum required to make an assessment for the purposes of the Clean Water Act 305B, 303D requirements, it should at least be the minimum data threshold for an existing use analysis. So in general summary, with regards to the work that's been done so far, there is no
When I
evidence.
looked earlier, it didn't really show that the lawn seats were open.
Should I continue?
Excuse me? I think we have, somebody needs to mute.
I agree,
Dr. Meyer.
Pam, would you please mute everyone
Yeah,
except for
yes. Yeah, we're
Mr.
watching it, Mr.
Okay,
Herring.
thank you.
So Dr. Meyerhoff, you were about ready to discuss the summary regarding the secondary contact issue.
Right. So it's based on all the evidence that I've reviewed as part of this trying to review proceedings. It's clear that secondary contact remains the appropriate designated use for waters on land or property. There's been no evidence provided that what was documented in 2007 with regards to whether the use can actually be attained, or primary contact use can actually be attained, has not been provided. Next slide. So to summarize my overall testimony, both in direct and rebuttal, we propose a framework or a process that is frankly fairly simple that should be followed in every situation with regards to evaluating existing uses. First and foremost is the need for some document, we call it a work plan, that is prepared at the beginning of the process so that you bring in the stakeholders, you verify how are you going to go about doing the study. EPA talks about the need for existing use analyses to be site specific. So this is the opportunity to look at the water body in question and say, how will we go about evaluating the uses in this particular water body? Then work collectively with the stakeholders to compile existing data, collect new information to fill critical data gaps. As it's been stated by EPA, they want you to evaluate both the actual use, so there needs to be an approach for that water body to do that, as well as to look at the water quality data. Third, the process to actually analyze any of the data should be stated. How you're going to take the data you gather and evaluate it. We stated already recommend that it should be at least consistent with the CALM use attainment assessment procedures because the purpose is the same. Can a use be attained? And finally, the steps 4 and 5 are the process to bring a finding that would result in a change in uses to the commission for approval. And if that happens, of course, it must be reviewed by EPA.
Thank you, Dr. Meyerhoff. Turning to Rebuttal, did you review NMED's rebuttal testimony from Fulham regarding whether there's a process to evaluate, designate, and/or amend existing uses? And if you could advance the slides to our Rebuttal.
Yes, I did.
Does any consistent technical basis or testimony on the existing use process issues?
No, they didn't. And I'm going to refer to Exhibit 109, which is the rebuttal testimony of Ms. Fulham. And at 13 in that testimony, she states, however, the department recognizes the value of some general guidance when determining existing uses as they pertain to water quality standards and will consider inclusion of such language in the standards section of the Water Quality Management Plan, continuing planning process during the next revision. So an agreement there that a process might be appropriate. But at 72 of her testimony, statement is made that the department does have a process for amending water quality standards as outlined in the WQMP CPP, as well as a clear directive in 40 CFR 131.10I, which simply directs states to amend the designated uses to be no less than the existing use. The department does not agree that the Smithy Letter in any way requires or implies that a process specific to determining existing uses like a UAA is appropriate. Then at 74, testimony states the department disagrees that there is not a process for water quality standards amendments such as those associated with designated uses based on existing uses. The process is outlined in both state and federal regulations as well as the state's approved WQMP CPP. So it appears that it's not consistent. Is there a process or not? But the reality is EPA very strongly emphasizes a need to have a clear process. And their 2015 revision to the water quality standards rule, they make this statement that the rule provides clear expectations for when an analysis of attainability of designated uses is or is not required. Such clarity allows for better and more transparent communication among EPA, states, authorized tribes, stakeholders, and the public about the designated use revision process and the appropriate level of protection necessary to meet the purposes of the Clean Water Act. And the 2015 rule is Lanel Exhibit 31.
Did you review Ms. Fulham's rebuttal statement in NMED Exhibit 109 at page 73, characterizing the process that you just outlined, the 5-step existing use analysis process that Lanel proposes for the Commission's consideration?
Yes, I did.
And do you agree with her characterization that that 5-step proposed process is prescriptive?
No, I do not agree with that.
How do you respond to Ms. Fulham's statement that Lanel's proposed approach is not needed?
Well, first of all, the 5 steps that were shown in testimony here, and again, and both written and today, are what, again, I call a framework. We call it a stepwise process. It's very, very high level. They are basic steps that, frankly, should be included in any basic technical study done to support regulation. One, you work with the stakeholders and decide how you're going to address the particular question of interest, but collect the data, evaluate the data, and bring it before the proper authorities for review and approval if there's a finding made. That is not prescriptive. In fact, EPA does encourage, in fact, they say that you should have implementation procedures. In their 40 CFR 131.20, they state the following regarding evaluating uses that are not 101A2 uses. They state if such new information indicates that the uses specified in section 101A2 of the Act are attainable, the state shall revise its standards accordingly. Then they go on to say procedures states established for identifying and reviewing water bodies for review should be incorporated into their continuing planning process.
Do you agree that NMED has no obligation or regulatory requirement to develop a work plan for potential water quality standard amendments?
I would agree they don't have any specific requirement that says they have to do a work plan.
But do you recommend that NMED be required or third parties be required to have a work plan if amending a water quality standard?
Yes, I do.
And is Lanel recommending that the Commission adopt an existing use amendment process specifically that would require the department to develop a work plan to amend an existing use?
Yes, we are.
And why is that recommendation being made?
Well, again, our view is that the work plan is the beginning step. It's when you bring people together to identify what needs to be done. In past experience, I found when you begin stakeholder process that it should involve stakeholders, it's amazing sometimes what the stakeholders know. And you actually can potentially get some work done quickly because you bring in people with local knowledge.
Dr. Meyerhoff, did you review Ms. Fulham's rebuttal statement in NMED Exhibit 109 at page 38, where she stated that, quote, a designated use for a water may be amended, and if there is an established section in 20.6.4 NMAC that has the appropriated designated uses within the applicable geographic location, the water may be listed in that classified section of 20.6.4 NMAC?
Yes, I did.
And how do you understand that process described by Ms. Fulham would work?
Well, based on my understanding of what I read, it sounds to me that she's simply recommending that you have the opportunity or
ability to simply reclassify a water body from one section to another if she provided some parameters around that, if it makes sense. For example, in the same geography, so we might say in the same watershed.
Can you provide an example of how your understanding would work?
Certainly. Lano has proposed, for example, that the section 126 waters the description be modified to incorporate some new findings, that there is some additional, the areas that are currently identified as perennial actually have wider boundaries. So there's a little bit more perennial nature to some of those water courses, and to simply modify the description of that, of those water bodies as they are described now in section 126. This makes good sense because you're simply expanding the segment length. The same uses would apply because they're contiguous. There's no expectation the uses would be any different when they're that close together. And it meets Ms. Fulham's suggestion that it's in the same geography. They're in the same watershed. They're actually connected to one another. So that's an example where you do that. And in fact, in this case, would make them those potential additional segments of those water courses would actually have a higher level of protection.
Is it your testimony then that Lano's proposal regarding 126, the extension of 126 waters, is consistent with the process that Ms. Fulham described in the quote that I read from Nmed Exhibit 109 at 38?
Yes, I do.
Dr. Meyerhoff, have you also reviewed the NMED's Water Quality Management Plan and its appendices included in Lano exhibits as Lano Exhibit 70?
Yes.
And are you familiar with the HP flowchart presented in the Water Quality Management Plan at section 2-8? And if we may have the next slide.
Yes, I am familiar with it.
Is Ms. Fulham's described process for amending a designated use for a water reach by listing it in a nearby classified section, if that water meets the designated use, reflected anywhere on the flow chart?
No, I don't believe it is.
Would it be helpful to pull up the flow
Yes,
chart?
I think it is.
And for the record, we're showing this is the HP protocol, the Water Quality Management Plan, HP protocol, and it is in the exhibits as Lano Exhibit 70. We're looking at page from the Water Quality Management Plan, page 2-8. So is Mrs. Fulham's described process that you talked about for amending a designated use by extending it or listing it in a nearby classified section presented on this flow chart?
No, and my response is based on a review of the right side of this figure, which starts with classified water body in the upper right box. In this case, the example I gave, section 126, is a classified water. So a hydrology protocol study was done. The results, along with other information pulled together, demonstrates determinations consistent with the current NMAC segment. The answer would be no, because if they're not 126, then they would be currently in segment 128, is my understanding. So the no means now says you need to classify the water body, but it's already classified. And that essentially kind of puts you in a nowhere to go, because below that you either move it to 98 or 99, which makes no sense because we're suggesting it be 126. It has the same characteristics, and there is no UAA process necessary because it's not required in this case.
And in the instance where the box says you need to classify the water body, is there any opportunity for the commission to evaluate or adopt that decision?
No, because as you'll note throughout this figure, there was a number of dark gray boxes where it talks about a hearing before the commission. There is none on the direction from need to classify water body through the no to protect it under 98 or 99 sections. So as this is drawn, the implication is that a water body could be declassified in effect from what its current classification is and put into a different classification, 98 or 99, without going through the Water Quality Control Committee.
And do you agree with that? Do you agree with the HP flow chart regarding the amendment of a designated use in classified waters?
No, I do not, for the reasons I just stated.
We may move back to the next slide. Dr. Meyerhoff, did you review Ms. Fulham's rebuttal testimony in NMED Exhibit 109 at page 65, stating that although demonstrated previously that low flow and lack of physical access prevented recreation in and on the water where full immersion would occur, the Clean Water Act protects for the attainment of water quality to support the use wherever possible. Although it may be considered for attainment, there is no criterion for volume to preclude attainment of primary contact.
Yes, I reviewed that.
And do you agree with that statement?
No, and that would be simply because it goes against what EPA has stated in their guidance of what is necessary to evaluate a use. First and foremost, it states it was demonstrated previously, so a finding was made that low flow and lack of physical access, so the very factors that could prevent the actual use from occurring, which in this case is swimming, is not possible. But once you get to that point, then the water quality becomes less important because you can't do the use in the first place. You can still look at the water quality, yes, but you need to be able to actually use the water body for the purpose intended of the use. The last part there about there's no criterion for volume to preclude attainment of primary contact. I'm assuming volume in this context means depth or sufficient water to actually swim in. I don't understand that conclusion given EPA's clear statement that uses actually attained must look at, can you do it? Use the water for that purpose, and volume would be a key factor in being able to swim. Not to mention the EPA's bacteria criteria that they recommend to the states and being used by New Mexico and most states in the country, it considers based on full immersion. And so that's a factor in the actual use of the criteria.
Were you present for Ms. Aranda's testimony yesterday?
Yes, I was.
She testified regarding the number of samples that they relied on in E. coli testing. Do you remember that testimony?
Yes.
And what did she say?
My understanding of what she said was that they had at least, the minimum that they had was 3 samples. And I'm referring to, I think it was Exhibit 56, which is the existing use analysis for other waters in the state. So we're not talking Section 128 waters. And that they had at least 3 samples as their minimum. But her testimony, as I quoted a few minutes ago, said they could make a decision on the basis of 1.
And was her testimony consistent with Ms. Aranda's direct testimony in NMED Exhibit 3 at page 12?
No, it was not.
Do you recall generally what that testimony said?
The testimony, and it was in the slide previously, essentially said that if they had a single, I'm paraphrasing probably slightly, if they had a single value, that was sufficient to make a decision of primary contact.
Dr. Meyerhoff, do you have any additional comments regarding the existing use issues?
My last comment would simply be, again, the need for a process is critical given the nature of the designation of a water body with an existing use, given how existing use is important in the implementation of water quality standards.
Thank you, Dr. Meyerhoff. And as I indicated, Mr. Hearing Officer, at this time, we will begin with the testimony of Mr. Gallegos, and then both witnesses will sit for cross.
I don't think Mr. Gallegos has been sworn in.
Yes, he has. He testified previously on topic 1, actually.
Wonderful, thank you.
Good morning, Mr. Gallegos. Did you provide pre-filed written direct and rebuttal testimony regarding NMED's proposals concerning existing use analysis and use attainability analysis in section 20.6.4.10 NMAC and 20.6.415 NMAC?
Yes, I did.
Did you prepare is your demonstrative exhibit also addressing topic 5?
Yes, it is.
Could you please summarize LANL's current position regarding both of those provisions?
So with respect to the provision contained in 20.6.4.10, LANL has no further objections to NMED's proposals in 20.6.4.10C, and LANL supports NMED's proposal in 20.6.4.10D. We do have some recommended changes for the amendments contained in 20.6.4.10B. With respect to the use attainability analysis contained in 20.6.4.15, LANL has no further objections to NMED's proposals contained in 20.6.4.15D, but offers some additional changes to 15A in the use attainability analysis section.
And I think we were going to skip the next slide in the interest. No, sorry. At a high level, what prompted LANL to propose the amendments that you're recommending?
So two issues that drove this is that, first of all, NMED is proposing to declassify, or has purported to declassify, certain waters at LANL based strictly on the hydrology protocol 1 flow information. This is without involvement of the Water Quality Control Commission. NMED's approach is based on a flow chart that is contained in the Water Quality Management Plan, LANL Exhibit 7D. Declassification changes uses criteria without a WQCC decision, and the declassification will result in a lower aquatic life use protection. The second issue is NMED's use of the existing use analysis demonstration. This process was brought up in the joint stipulated agreement that between Amigos Bravos and NMED and LANL, and the issue that LANL has is that the process was the existing use analysis was brought up late in the process and used non-representative data with some of its findings.
So in the interest of moving ahead, we're going to skip the next series of questions, but does LANL have specific comments related to NMED's new proposed 26.4.10B?
The main issue on this slide is that we would like the Commission to consider LANL's proposal to adopt a process for determining an existing use. And much like Dr. Meyerhoff indicated before, we also have concern that the issue of supporting evidence isn't really defined or isn't really, we don't know exactly what that means. And again, no decision maker is designated in NMED's proposal. We'd also like to recommend that NMED's proposal stay as close to the intent contained in 40 CFR 131.10I, dealing with the federal provision to existing uses.
And does LANL have any other specific amendments to NMED's proposed proposal for 20.6.4.15A?
Yes, again, we agree with LANL's approach, changing the heading to 20.6.4.15A. The regulatory requirements for use attainability analysis, we think that's very descriptive. We think that the section should contain all the foundational requirements related to a UAA, and we believe that LANL's proposal on this section would do just that.
Now, turning back to the process that you and Dr. Meyerhoff have discussed, can you please put LANL's recommendations into context for the commission and then explain the 3 process framework options that LANL would like the commission to consider?
So first, with respect to, I'll start with the first process that we would like is for 15A. And again, we think that the use attainability analysis is the only area of the standards that provides for a framework or a process to deal with changes in designated uses. And while the process is to downgrade uses, we propose that the use attainability analysis process or something similar could be used for the upgrade of a designated use, and that's reflected in LANL's proposal. In the next slide, I'd just like to provide an overview of the laboratory's waters. This is a map of the laboratory. It's in yellow is the boundary of the laboratory, and in it, the reaches, the current classified reaches are marked in either red or green. The red ones represent perennial waters that are contained in water quality segment 20.6.4.126, and the green waters contain LANL waters contained in 20.6.4.128. In green, these waters are designated as ephemeral intermittent with the designated use of limited aquatic life. And in the red, they're having an aquatic life use of cold water aquatic life, and they are perennial.
And are all the waters within LANL classified?
All these waters contained within this map were classified during the 2003 Triennial review and remain the same today.
Was there a process, is the second process related to evaluation of the section 128 waters?
Yeah, so the next slide is a summary of the joint stipulated agreement that was reached between Amigos Bravos, DOE, LANL, and NMED during the last Triennial review. It was established in October 2015 in response to a petition that was filed by Amigos Bravos seeking increased protections for LANL's 128 waters. The agreement laid out a framework for the parties to share information, develop new information, and then bring those agreements and then collaborate to reach agreement, and then bring those agreements before the commission for their consideration, which is being done this week. NMEDs agreed to the petition the Water Quality Control Commission to propose these changes. Significant progress was made with this agreement, and waters, we agree that waters should be brought forth for more protective uses. There remains some concerns that we have, and I'll deal with it in the next slide. that this flow chart was shown to you earlier, showing the process that NMED is using to take some of the information that we gathered jointly in the hydrology protocol, where the hydrology was determined to be perennial, but using that information to declassify certain classified waters at LANL to unclassified status. They're doing this. They did this without any knowledge from the laboratory, from LANL, without informing LANL, without any kind of information to the public, and also without involvement of the Water Quality Control Commission, and also in direct opposition to the joint stipulated agreement. The flow chart on the right is a proposal by LANL to avoid automatic declassification using a hydrology protocol. If it doesn't fit in the segment, then the water body would need to be classified. And in the next slide, I'll show the last three boxes a little bit bigger to kind of explain that a little bit further. So once the hydrology protocol is done and it's determined that it's not appropriate in that particular segment, then we go through a process, something that is approved, a process that is approved by the Water Quality Control Commission, either through a use attainability analysis or through an existing use analysis, and work with the stakeholders and bring those proposed modifications to the Commission for their consideration.
Does LANL, just what is the third option as you're describing? Is that the 5-step process that
Yes.
Dr. Meyerhoff suggested?
Correct. So the next slide shows, again, Dr. Meyerhoff already showed this slide, and I won't repeat what he said, but these steps could provide a framework for an existing use analysis process, and LANL would certainly recommend that the Commission adopt such a process.
Now, Mr. Gallegos, did you review NMED's rebuttal testimony from Ms. Lemon and Ms. Fulham regarding their process to evaluate, designate, and modify existing uses?
Yes, I did.
Do you understand that NMED asserts that classified waters may be automatically declassified based on the hydrology protocol survey?
Yes. Yes.
Does NMED provide a consistent technical basis or support for that automatic declassification?
No, they don't. I mean, they indicate that under the flow chart that the waters can be declassified. But they also indicate that in Fulham's exhibit, NMED exhibit 109 at page 52, states that to amend any water quality standard, a demonstration is required for the Commission and EPA to base their decision. And I guess with statements like that, it seems that they understand that a process is needed and that the Commission should be involved, but the flow chart and the way that they're applying the flow chart doesn't seem to support that.
Were you present yesterday for the testimony of Ms. Fulham and Ms. Aranda?
Yes, I was.
And do you understand whether they believe that a process is needed even?
From what I recall, I think they think that the process that they have, what they have now is currently the processes that they're using, but they don't believe that anything further would be required. And I think basically in their testimony they called our process prescriptive.
Did you review NMED's rebuttal testimony from Ms. Fulham regarding whether there is a process to evaluate an existing use and whether that is needed?
Yes, I did.
Does NMED provide a consistent technical basis or testimony as to whether there is a process to evaluate, designate, or amend an existing use.
No, I don't believe that they do. Again, in Ms. Fulham's testimony on Exhibit 9, NMED's procedural framework is contained in the Water Quality Management Plan. And again, I refer back to the flowchart that they're using. Again, NMED Exhibit 109 at line 72, NMED disputes that a process specific to determining existing use like a UAA is appropriate.
Do you recall what Ms. Fulham said yesterday about NMED's use of available data for existing use analysis?
Yes, I do.
And what did she say?
As I recall, Ms. Fulham indicated that they, in doing an analysis, they try to use all available data, data and evidence that's available to them.
And is this consistent with Lionel's experience?
This has not been consistent with Lionel's experience. Lionel, in this process that was developed under the joint stipulated agreement, produced volumes of high quality data, which in many respects NMED was not willing to utilize.
Did you also hear Ms. Aranda's testimony in response to cross-examination from Ms. McCaleb from the San Juan Water Commission, where she was asking about the two EUAs that NMED presented as exhibits 56 and 73 regarding land and waters?
Yes.
Did NMED engage with the public or LANL on a work plan for the land and waters EUA?
So NMED did engage LANL and DOE with the work plan for the EUA for this demonstration.
And when was that work plan shared with LANL?
The work plan was originally shared in October of 2020, a few months after NMED's original petition had been filed.
Did LANL provide comments to that proposed work plan?
LANL provided extensive comments to the work plan in early 2021.
And were those extensive comments, did LANL agree with the work plan?
No, LANL did not agree with the work plan. LANL had substantial comments and really requested that NMED not use the existing use analysis as a process for determining uses under the joint stipulated agreement, and requested that they not do it.
Did NMED respond to any of LANL's comments?
No, they did not.
And at what time did LANL first see the Land and Waters EUA that NMED Exhibit 73?
LANL first saw the results of the existing use analysis in May of 2021 with the initial filings, NMED's filing of their amended petition.
So in the context of the triennial review?
Yes, sorry.
And does LANL believe that that was a good stakeholder process?
No, our comments that we provided in January of 2021 went to NMED, but we received no feedback and didn't understand how the analysis was going to go on until the filing of NMED's petition.
And as we'll hear later today, did LANL have concerns about some of the data used in the EUA?
Yes, we did.
Could those have been resolved had there been more stakeholder engagement, in your opinion?
Yes, those could have been resolved.
Mr. Gallegos, do you have any additional responses to the NMED rebuttal testimony regarding the process issues that you've been discussing? The next slide.
So the process here is that NMED is using asserts that classified waters at LANL are now unclassified. And this is in direct contradiction to the joint stipulated agreement. Lano is proposing additional protections by extending the reaches of 126 current 126 waters that are contiguous with extending the reaches of 128 waters into 126 that are contiguous with 126 waters. NMED or NMED's approach to this process omits the Water Quality Control Commission as a decision maker, excuse me.
And in recommending Lano's proposed approach, are there benefits that Lano can commend to the commission for adopting the work plan process and 5-step framework recommended by Lano?
Yeah, so we recommended, as we previously testified, a 5-step process that could be used to develop an existing use analysis plan or workshop process, and that classified waters at Lano should not be automatically unclassified. And Lano's approach is consistent with one NMED described process. The water quality management plan flowchart is not a binding rule, and a water quality control commission approved EUA designated use process would provide certainty.
Mr. Gallegos, after considering the NMED's written testimony and hearing the rebuttal testimony yesterday regarding existing use and UAA processes, does Lano have any modifications to its recommendations to the commission about the need and elements for an EUA process?
Yes, and is there one last slide?
No.
So we just have the 5-step process that we have recommended for changing the existing use, and we would encourage the commission to consider that.
Thank you. At this time, we tender both Dr. Meyerhoff and Mr. Gallegos for cross, and let us shift a bit. No. Oh, well, yeah, okay.
Mr. Verheuvel, while they're taking their position in front of the camera, have you decided how you want to handle the request to admit additional context to your Exhibit 139 that is in evidence?
We have, Mr. Hearing Officer. I've been provided with what it was that Mr. Rose requested, which is the exchange with EPA Region 6. And the next time I have a chance to craft an email, I'll be sending that to all the parties and to the hearing administrator. And I've marked it as NMED Exhibit 140.
Okay. So are there, okay, so I'll wait to hear if there's any objections to that admission once everyone has it. Will you let me know when you've sent it?
I'll include you on that email.
Perfect, thank you. Mr. Verheuvel, I suspect you'd like to cross-examine these two witnesses. Yes, I gathered. Are there any other, Mr. DeSalin, you would like to cross-examine? Are there any other? Yes, sir.
Yes, Mr. Crane.
Yes. And are there any others besides Ms. McCallum and Mr. DeSalin? All right, I'll put that in that order. Mr. Verheuvel, please proceed.
Thank you. I'm gonna take it out of order here. My first two questions are for Mr. Gallegos. Mr. Gallegos, you stated that you provided comments on this existing use analysis in January of 2021, but you didn't understand how it was going to be used until NMED filed its petition. Is that right?
I think I had a general understanding of how the existing use analysis was going to be used. I mean, it was going to be used, but as the results and the process and what kind of input they took from our extensive comments, we didn't understand what that was going to be until the filing of the filing of NMED's amended petition.
I'm sorry, NMED's amended petition?
As I understand, there was an original petition in August, and then the amended petition was in May.
Okay.
I have my my terminology right.
Yeah, thank you for that clarification. Mr. Gallegos, did you say that the process in the water
Excuse
quality-
me, excuse me, Mr. Verheuel. Let me just correct the record. The amended petition was filed in March. Mr. Verheuel, will you correct the date for the record?
I believe it was March 12th.
Thank you, sir.
Mr. Gallegos, did you state just a few minutes ago that the process in the water quality management plan and continuing planning process isn't binding?
I said that the flow chart wasn't binding.
Which flow chart?
The flow chart contained in the water quality management plan, continuing planning process.
Okay, so that flow chart, that's on page Roman numeral 2-8 of NMED Exhibit 64. That's part of the water quality management plan continuing planning process, right?
That's correct.
Are you aware that that document has been approved by both this commission and by EPA?
Yes.
Did Triad and DOE object to the process for aligning designated uses appropriately for waters not described in sections 101 to 899 during the last update to this document?
No, we didn't. Our waters were classified waters. They weren't undescribed waters.
But when this document, this updated document was approved by this commission last year, Triad and DOE didn't object to that, right?
That's correct.
Okay. I think my next set of questions are perhaps for Dr. Meyerhoff, but really I don't care which of you responds. Dr. Meyerhoff, were you able to review Ms. Khan's direct testimony of Rachel Khan, which was filed as Amigos Bravos Exhibit 3?
Mr. Verheuel, I believe I reviewed parts of it. I can't say I read all of it.
Okay. Answer this if you can then. Based on your review of that testimony, are you aware that designated uses have been amended based upon existing uses prior to those being proposed here?
I'm not familiar with that aspect.
Okay. Would you agree that the Smithy Letter, which we've talked about a number of times here today, recommends that all available information be considered, but that a lack of information does not preclude establishing an existing use?
Yes, I would agree. It states that.
With respect to the existing use analysis that we're talking about, did you review the data set that was provided with the existing use analysis?
Could you repeat the question, please?
There was a data set that was provided with the existing use analysis. Did you review that data set?
For which existing use analysis?
I think we're talking about NMED Exhibit 56.
56. I am reviewing the testimony of Ms. Aranda, which referenced that document. And then I went and looked at the exhibit itself. And so in reviewing the exhibit, did look through, did see the tables in there with the data, yes.
Okay, well, since you reviewed Ms. Aranda's testimony, didn't Ms. Aranda state that all of the water bodies that were proposed there had at least 3 data points that met the primary contact criteria?
She may or may not have stated that. I don't have her testimony memorized. What I was quoting was a direct statement out of her testimony indicating that 1 data point is sufficient to make the decision.
Sure, but then during her oral testimony yesterday, she stated that all the proposed water bodies had at least 3 data points. Isn't that right?
I agree, but the focus of my testimony was on if the statement is being made that 1 is sufficient, then that it suggests intent that in other existing use analyses, you might use simply 1 data point. That was the context of my testimony.
Understood. So that's a future concern. That's not a concern with the proposal here today.
It doesn't have to be, but in terms of the existing use analysis process we're proposing, it's very relevant to that.
Are states required by the Clean Water Act to amend designated uses if they are not as protective as the existing use?
No, you don't have to amend designated uses. You can.
You're not required to if they're not as protective as the existing use.
Okay, I'm sorry. It was one of those statements that I have to really think through how you said that. Yes, if the designated use is an existing use, I'm sorry. If the designated uses do not include the actual existing use, then yes, you do need to amend them.
Are you aware that water quality standards are designated uses as codified in 20.6.4 NMAC cannot be amended without petitioning this commission and following the rulemaking requirements of the State Water Quality Act, the State Rules Act, and the procedural regulations of 20.1.6 NMAC?
I will accept your read.
Okay.
That I suspect that's true. Yes.
With respect to segment 126, I'm going to ask you to read the actual language of segment 126, and you can find that in a number of places. There's a number of exhibits. Nmed Exhibit 110, for example, has the language of 126 in it. I just wonder if you could read that description, just the main part of it, not paragraphs A and B of it.
Mr. Verheul, are you suggesting that we locate that exhibit?
Yeah, Nmed Exhibit 110. If you could, I'll give you a page number. It'll be on page 30 at the very top of the page. And this is the existing description of segment 126. It's codified in the regs right now.
All right.
I would note that this is a little, I believe the question is a little bit beyond the scope of this topic and is more in the Lano water specific topic, but.
Are you making an objection?
I'll reserve until he actually asks the question, until Mr. Verheul actually asks the question.
Well, I've already asked the question. I've asked if the witness would please read the description of segment 126 as it exists today. Also, we don't need to necessarily have an argument here. My understanding was that these witnesses were testifying as to topics in topic 7, and they were doing that out of order due to witness availability. Did I get that wrong?
Yes, that's not correct. We're testifying as to topic 5, the EUA and use attainability analysis process. There was testimony regarding Lano waters as examples, but we were not testifying regarding topic 7.
Okay, well, segment 126 was specifically discussed in the oral testimony of one or both of these witnesses, so I think we're certainly within the realm. Anyway, Dr. Meyerhoff, if you've located that portion, if you could read the description of segment 126, just the first main paragraph. You can stop when you get to paragraphs A and B.
Rio Grande Basin, perennial portions of Cañon Valle from Los Alamos National Laboratory, Lano, stream gauge E256 upstream to Burning Ground Spring, Sandia Canyon from Sigma Canyon upstream to Lano, NPDES Alfal 001, Pajarito Canyon from Arroyo de la Delfe upstream into Starmer's Gulch, and Starmer's Spring and Water Canyon from Area A Canyon upstream to State Route 501.
Okay, thanks. Can you explain to me where that description, where in that description that you just read, where it says that it applies to all perennial waters within the Los Alamos National Laboratory?
It does not say that. It says the specific segments that I just read.
Okay, so it doesn't say that it applies to all perennial waters within Lano.
That is correct.
If segment 126 does not include all perennial waters within Lano, where in the state water quality standards would any other perennial waters within Lano be protected?
I believe there's a section, guess 99, that talks about perennial waters in general, but I'm not focused on that. That's not been part of my testimony, so I'm guessing on the number.
Okay, I have no further cross-examination questions for these witnesses on this topic at this time. Thank you.
Mr. DeSalen?
Thank you, Mr. Hearing Officer. I have just a few questions for Mr. Gallegos. They're mostly in point of clarification. Good morning, Mr. Gallegos. Good seeing you again. I was wondering if you could go back to your slides and bring up the map that you showed. I think it was a map of Los Alamos waters, or Los Alamos National Laboratory waters.
Okay.
That was the right one.
Thank you. Yes, that's the one. No, I don't see us. Oh, that's slide number 12. Okay, for the record. And these are your slides are sequentially numbered right all the way through.
Yes, they are.
Okay, thank you. Now, the clarification that I want to make here is there are a couple of streams there, or canyons, that seem to end at the border of Los Alamos National Laboratory and this San Ildefonso Pueblo, up at the top center there. Do you see that?
Yes, I do.
Okay, and I just want to make clear that I recognize that this map was prepared to show the waters at Los Alamos, but I just want to make clear that those two streams continue flowing to the east to the Rio Grande. Is that correct?
Yes, that's correct.
And the Rio Grande is that stream that shows flowing more or less south on the right side of the map. Is that correct?
Correct, in the darker blue color, yes.
Okay. And the boundary there that we were just talking about, and the entire boundary sort of looks like the panhandle of Texas, if I could describe it that way. That area there is San Ildefonso land. Is that correct?
That's correct.
Thank you, Mr. Gallegos. That's all the questions I have.
Ms. McCallum?
Thank you, Mr. Hearing Officer. My questions are directed to Dr. Meyerhoff. Good morning, Dr. Meyerhoff.
Morning.
You testified that an existing use is established. I'm sorry, that once an existing use is established, the anti-degradation policy prohibits the removal of that use, even if it becomes unattainable. Is that correct?
Well, I would phrase it, I'm not sure I said it that way. The general regulations, federal regulations say you cannot remove an existing use. Within the anti-degradation policy, that is important with regards to how you treat an existing use.
And is degradation of the level of water quality necessary to protect that use also prohibited?
That is correct. You cannot degrade an existing, the water quality. You must maintain and protect the use.
So would that mean that any discharge into those waters must also protect the existing use, even if that existing use is no longer attainable?
That is correct.
And you gave testimony this morning about the EPA Smithy Letter. Does the Smithy Letter that you referenced indicate that because of these anti-degradation restrictions, it's important to have a high degree of confidence when establishing an existing use?
Yes, it does.
In your opinion, is there a high degree of confidence for establishing an existing use when the department has not evaluated the actual use of the water, but only the water quality?
No, I would say I have a very low confidence, particularly when it pertains to uses that by definition require a certain amount of water. In this case, my testimony is focused on recreation, and the primary contact use is built, the definition is built around full immersion and the risk of exposure through ingestion. So that's critical to evaluating whether the use can actually be attained.
So a recreation use is one relating to how a water body is used by people.
Yes, and this in the context of recreation, yes, because it could be used for other reasons by people.
Does the Smithy letter indicate that the state should determine existing uses on a site-specific basis?
Yes, it does.
In your opinion, would a site visit provide relevant evidence about whether primary contact recreation use is occurring in a particular water body?
Yes, a site visit, I would say, is critical.
And would a site visit also provide relevant evidence about whether there are physical problems that would prevent primary contact recreation in a particular water body?
Yes, yes, it would, and that's particularly important because in EPA's handbook, where they talk about Chapter 4, they talk about now the anti-degradation policy. They do make this distinction between use actually attained physically. I mean, can you use the water body for the purpose? And when they talk about water quality, they qualify that water quality evaluation based on physical limitation.
Based on your review of NMED Exhibit 56, which is the EUA for the primary contact uses, is there any evidence that the department conducted site visits for this EUA?
I did not see it. And in fact, there's a paragraph in there describing how they looked at actual uses. And I believe the first statement, I can't quote it directly, but actually may be in my rebuttal testimony. But it says the Bureau does not go out to evaluate the existing uses. Instead, they rely on a variety of sources ranging from, I think they use the term visitor brochures, websites is mentioned, and guide to river rafting was mentioned as well. So they're using secondary sources that are not very site specific because they're often written very generally.
And were you present for Ms. Aranda's testimony this morning on redirect from Mr. Verheuvel?
Yes.
And did you hear her indicate that site visits were conducted for this EUA?
Yes, she did state that.
Is it your understanding, based on that testimony and also her testimony yesterday afternoon, that those site visits were the site visits made in connection with the collection of water quality data?
That's what my understanding, what my interpretation was of what she said. In fact, she did mention that specifically yesterday.
And is the water quality data that has been submitted in support of this EUA years old?
Yes, I believe it. I can't tell you their date ranges. I think they're provided in the document, but yes, they're not recent.
And so that data was collected before this EUA was conducted, is that correct?
I believe that is true, yes.
In your opinion, is evidence of primary contact recreation unavailable simply because the department chooses not to conduct a site visit?
No, I don't agree with that.
Do you have any concern about establishing a precedent that an existing use can be determined based solely on data showing a water body meets the water quality criteria for that use?
I have significant concerns because, again, it does not go to the purpose or the function of the water body, which EPA specifically says should be evaluated. And we're hearing in testimony is that we may not have the data for both, and EPA does provide some statement about, the state does have some discretion on data, but they also make it clear that it needs to be a decent data set. And so the expectation is is that you will look at multiple factors, multiple lines of evidence in your evaluation. So not doing it does set a precedent. And in fact, my view, in my opinion, is highly inappropriate.
Thank you, Dr. Meyerhoff. I have no further questions.
Are there any cross-examination questions by commissioners for these two witnesses?
Mr. Hearing Officer, this is Commissioner Thompson.
Yes, Commissioner Thompson.
This is a question for Dr. Meyerhoff. At the very beginning of the hearing, way back on, I guess it was Tuesday, I asked Ms. Lemon with the Environment Department whether manifestations of climate change might change designated use for a water. And she said a use attainability analysis would be required. But I believe in your testimony, you said that there are federal requirements to specifically address anti-degradation events or experience. So the example that I used when I was questioning Ms. Lemon was the impacts of climate change on water temperature. So I would like to ask, in your experience, would it be possible to degrade a segment of stream from cold water to marginal cold water, or marginal cold water to warm water? It would be a reduction in classification as a result of climate change, or does that is that prevented by the Anti-Degradation Clause?
Commissioner Thompson, that is a very interesting question. I'm going to give you my opinion. Is if you have determined, in this case, your example using cold water going to cold water to marginal cold water, marginal would be potentially a less protective use. Let's, for the purposes here, say it is, in terms it has a less protective criteria to protect that use. And if you have made it established that the cold water is an existing use, then by current regulations, then the answer is no, you cannot degrade or downgrade the use to something less. Because when the context of existing use is after November 28, 1975. And we'll assume we're talking in the future here. So climate change is something in the future. It's going to be after November 28, 1975. So unless the EPA modifies their regulations, which they certainly could do, as they're written now, I would find it not possible if the use we're talking about here is an existing use. If it's a designated use, you can do it. You can change it.
Excuse me, say that last sentence again.
Everything I said is based on the use being defined as an existing use. But if we're talking about a use being just designated, meaning it's a goal for a water body, then yes, you could downgrade the use to something less protective through a use attainability analysis because of climate change. That would be allowed. This is why the existing use question is so important. Once you say it is an existing use, it locks things in based on current regulation.
So it's as I understand your testimony, the Anti-Degradation Clause is a federal criteria, and that is not something that the commission has authority to override.
All right, let me explain. When we say Anti-Degradation Clause, when you talk about water quality standards in general, they have three basic parts. One is the use, the criteria to protect that use, and the third is the anti-degradation procedures, which is how are you going to implement the uses and criteria to be sure you don't degrade water quality. So that anti-degradation policy is the how-to document. And in the state of New Mexico, of course, that's part of your quality management plan. It is a procedure in your your overall procedures. So in there, it defines what you can do if a water body has a existing use versus it's not an existing use. Let's say it's just a goal for a water body. The evaluation is done differently for those waters. But anti-degradation, of course, applies to any activity planned for a water body. It's not just dischargers with wastewater permits. It applies to non-point sources as well. It's not often applied, but it does apply.
Yeah, it's a tough topic. Thank you very much, Mr. Hearing Officer. That concludes my questions.
Are there any other commissioners that would like to cross-examine these two witnesses? Are there any members of the public? Ms. McIntosh, are there any redirect?
Yes, thank you, Mr. Hearing Officer. Just a few questions, and I will start with Mr. Gallegos. Mr. Gallegos, do you recall when Mr. Verheuvel asked you about when you first saw the EUA document and commented on it?
Yes, I do.
I just to be clear for the record, the EUA document that is NMED Exhibit 74, you did not see until it was produced as Exhibit 74. Is that correct?
That's correct.
And the document that Lannel saw and commented on was the work plan. Is that correct?
That's correct.
So the work plan did not reflect the full content of Exhibit 74.
That's correct.
Now, Mr. Verheuvel also asked about whether NMED considers all available information in establishing a use. Is it Lannel's experience that all available information has been considered by NMED in the context of that Exhibit 74, NMED Exhibit 74 EUA?
No, not all data was considered.
Can you elaborate on that?
So the laboratory produced data using hydrology protocol, two methods, which included further evaluation of water or aquatic life or flow regime, and some of that data was not considered by the department. Certain kinds of flow data from some of our gauges was not considered. All of the data that Lannel generated pursuant to the hydrology protocol 1, where NMED was not present for, they didn't consider any of that information as well.
Did NMED provide a technical reason that that data was not considered?
I'm not sure if I'm going to get the terminology right, but they, I don't think this is a technical reason, but they didn't believe that Lannel's data had the right pedigree for them to consider it.
Just because NMED was not present?
Because they were not present, maybe one. I don't recall if there were other reasons at this point.
Does Lannel agree that there was any lack of pedigree for Lannel's data?
No, we followed NMED procedures and gathering, using both the HP1 and the HP2. NMED actually, over the course of the joint stipulated agreement since 2015, we've had 4 or 5 years, and in those first couple of years, NMED provided extensive training to Lannel employees on the use of the hydrology protocol, and we walked up and down a number of canyons applying the protocol. So we felt like we were following their procedures and doing things according to their processes.
And did NMED endeavor to consult with Lannel regarding the data quality in order to try to verify the data quality in order to use all available data?
No.
Turning to a question that Mr. Verheul asked of Dr. Meyerhoff, is LANL proposing an amendment in section 126 that would enable additional perennial waters identified either now or in the future to be added to section 126?
Yes, they are.
And is that amendment something that the commission can adopt in order to include additional perennial waters in section 126?
My understanding of these proceedings, yes, they can.
In addition, Dr. Meyerhoff, do you recall the question that Mr. Verheul asked, stating that standards cannot be, that under the New Mexico standards, the standards cannot be amended without a commission decision?
Yes, I remember that question.
Is, based on the hydrology protocol flow chart, is that an accurate statement by Mr. Verheul?
No, as I went through in my testimony on the right side of the figure.
Would it be helpful to have the figure?
We can. As I indicated during my testimony a few minutes ago, on the right side, there is, you do the hydrology protocol, evaluate the findings. If you decide that the findings from the protocol are not consistent with the current NMAX segment, you end up in a place that says need to classify the water body, but they're, in this case, the example we're talking about, they're already classified because at the top box it says it includes classified waters. And if the answer is no, for whatever reason, then it takes you without any discussion with the commission into placing the waters in either 98 or 99. So yes, 99 is perennial. And so that can't make the argument that where the commission makes decisions is missing from this figure because they've included it in the appropriate places in other decision trees. But in the flow chart on the right, on that one specifically, they have left it out, strongly suggesting, I would interpret it as a layperson, I would interpret that to mean you can make that change without the commission's approval.
And those steps where the commission decision is proposed by the flow chart, those are
I apologize for the interruption. It's always awkward on video. I'm going to object to this line of questioning on two grounds. One, we're definitely in topic 7 now. We're out of order, and I know that the statement is that we're using the LANL waters as an example, but this is really just getting 2 bites of at the apple of the LANL waters topic. And I appreciate the preview, but I think if we could just move on with topic 5, that'd be great. The second ground for my objection is that this is an impermissible collateral attack on a document that this commission and subsequently EPA have already approved, and we've already got testimony from this party that they did not object to the document, which includes this flow chart at that time.
Ms. McIntosh?
Yes, Mr. Hearing Officer, the questions that I was asking were in direct response to either statements or questions made by Mr. Verheul under this topic. This flow chart relates specifically to the manner in which existing uses are modified. So it is clearly a topic 5 topic. And if I could be permitted a little bit of latitude, I will demonstrate that this particular flow chart states on its face that it is only showing primary pathways, not all pathways, and that the collateral attack issue therefore is inapplicable.
So, Ms. McIntosh, you are asserting that this is well within topic number 5,
Correct.
that you are responding to questions that were asked on cross-examination by the department,
Yes.
and that you are not collaterally attacking this document.
Correct.
Ms. McIntosh, as long as you stay within category 5, I will permit the question. But I also will listen to another objection from Mr. Verheuel if you do collaterally attack that document.
Very good. Thank you, Mr. Hearing Officer. The question I was going to ask you, Dr. Meyerhoff, is in the process, this is a process flow diagram. So in the process of each of these, either unclassified or classified, is there a particular box that shows where the Water Quality Control Commission has an opportunity to make a decision?
Yes, there are places.
And are those shown in the kind of ovalish
Yes.
grade boxes saying regular UAA process on hearing before Water Quality Control Commission?
Yes.
And is one of those gray boxes included within that the process flow on the left-hand side for evaluating classified water bodies?
No, it is not.
And in your review of this figure that is included in the Water Quality Management Plan, did you come to understand that this diagram is illustrative as opposed and shows only primary pathways, not all pathways?
I interpret it the way it's described in the figure caption, which says primary pathways. So.
Thank you, Mr. Hearing Officer. I have no further questions.
To be fair to Mr. Verheuel, I'm going to allow him any recross on any issue you brought up on redirect. Mr. Verheuel?
Thank you, Mr. Hearing Officer. I will be brief. Mr. Gallegos, you testified that you reviewed NMED Exhibit 74 and that wasn't provided to you until such time as after January 2021. Is that what you said?
Yes, I believe that's what I said.
Do you think that EUA is actually NMED Exhibit 73, which was then refiled as Exhibit 124 with a corrected version?
Yes, I believe that's the case, yes.
Okay. And going back to when we entered into that joint stipulation, which my recollection is we did that during the actual last triennial review hearing. Do you recall why the three parties entered into that joint stipulation?
As I recall, it was a petition brought forth by Amigos Bravos seeking increased protections for Lano 128 waters. And
sorry,
the laboratory also responded to that, disagreeing basically, based on the. Go ahead. I'm sorry.
No. Please finish. I'm sorry. I jumped into a pause there.
Lionel disagreed based on the lack of evidence provided at that time.
Okay. So with respect to evidence, do you recall it being an important component of that joint stipulation that all three parties, the Environment Department, LANL, and Amigos Bravos, do you recall it being important that all three parties be present or at least have the opportunity to be present during data collection?
I don't recall that specific, that people, that parties be present, but that the parties share information and as necessary develop new information. I don't recall that the joint stipulated agreement spoke to the issue of being present.
Well, the joint stipulated agreement may not have spoken exactly to it, but my question was, do you recall that being an important part of the discussion that led to the execution of that stipulation?
I don't recall the discussion, Counselor. I recall I just recall the execution of how we proceeded,
Okay.
since 20.
Okay, great. So with respect to the execution of it, do you recall that it was actually a little bit slow going those first couple of years due to one or two parties other than LANL being unavailable to be present while that data was collected?
I apologize. Could you repeat the question?
Sure. During the first, I'm going to say 2 years of that joint stipulation being in effect, do you recall that there were some delays in data collection due to unavailability of one or more of the parties to be present during data collection?
Mr. Hearing Officer, I'm going to object to this line of questioning in the interest of time. The questions that Mr. Verheul is asking about, I covered in my in the original summary, but did not cover in redirect.
Mr. Verheul?
My recollection is that Mr. Gallegos spoke as to the joint stipulation in redirect, but if I'm misremembering that, based on your recollection, Mr. Hearing Officer, then I'll stop this line of questioning.
I have to rely on Ms. McIntosh to either accept that statement or not. Ms. McIntosh?
I did not ask about the joint stipulated agreement on redirect.
Okay, Mr. Verheul, if you're willing to accept that, then I'm going to sustain the objection. Otherwise, we can ask the court reporter to go back through his testimony.
No, I'll accept that, Mr. Hearing Officer. Okay. Thank you. I have one more question.
By all means.
And this is based on the flow chart. Is the language in 20.6.4 NMAC amended by the department based on that flow chart?
Mr. Verheul, who is that question directed to?
Either one.
Well, my understanding is the flow chart just shows the process. If there's a proposal to change 26.4 NMAC, it goes before the commission, just like we're doing here.
Okay, no further questions. Thank you.
I believe a break is in order at this time. Let's take a 15-minute break. It is 10:23. Let's say it's 10:25, and let's come back at 10:40. We're adjourned. It is 10:40 a.m. on the 16th of July. We are in issue number 5. So far, the department has presented its witnesses, and DOE and Triad have presented their witnesses. So we are now going to move on to, I think, the two witnesses that need, or I'm sorry, not the two witnesses, but I think we should call at, I'm trying to decide whether I should call one of Dr. DeWitt or finish number 5 and then call Dr. DeWitt. Amigos Bravos, it is generally your turn next, and you do have, I can't tell if Dr. Khan is part of issue number 5. Can you help me with that?
Thank you, Mr. Hearing Officer. A couple of things. Yes, Ms. Khan is part of issue 5. We presented rebuttal on issue 5, and Dr. DeWitt is available now. She's on, and we would like her to go now to deal with topics that we've already dealt with. That would be good.
Okay, and how long do you think her summary will take?
Less than half an hour.
Okay, why don't you present Dr. DeWitt now?
Hey, Mr. Hearing Officer, Dr. DeWitt has appeared before us. Here she
Dr.
is.
DeWitt, would you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Please state your name.
I am Jamie DeWitt.
What is your educational background?
I received Bachelor of Science degrees in Biology and Environmental Science from Michigan State University and Doctor of Philosophy degrees in Environmental Science and Neural Science from Indiana University in Bloomington, Indiana. I completed postdoctoral training in environmental and ecotoxicology at Indiana University in Bloomington, and I also completed postdoctoral training in immunotoxicology at the National Health and Environmental Effects Research Laboratory at the United States Environmental Protection Agency through a cooperative training agreement with the University of North Carolina at Chapel Hill. During my postdoctoral training at Indiana University, I evaluated developmental effects of polychlorinated biphenyls and dioxins on the hearts of wild birds in a project that was funded by the U.S. Fish and Wildlife Service. At the U.S. EPA, I evaluated the immunotoxicity of compounds known as organotins used in polyvinyl chloride pipes and of a compound known as perfluorooctanoic acid, or PFOA, which at the time was an emerging contaminant in drinking water supplies. PFOA is one of the contaminants I recommend be considered as a toxic pollutant under the Commission's standards.
Can you please give us an overview of your work experience?
I joined the faculty of the Department of Pharmacology and Toxicology of the Brody School of Medicine at East Carolina University in 2008 at the rank of a tenure track assistant professor. In 2015, I was promoted to associate professor, and in July of this year, 2021, I was promoted to professor. I am also an adjunct associate professor in the Department of Biological Sciences at North Carolina State University, and I became a diplomat of the American Board of Toxicology in 2017. I perform graduate teaching in general and advanced toxicology. I also teach biomedical statistics. I also give lectures to medical and dental students that focus on endocrine pharmacology as well as toxicology. I also teach and mentor students in my laboratory. I've mentored both master's and doctoral students through completion of their degrees, and currently have one doctoral student, 2 master's students, and research faculty in my lab, in addition to undergraduate students who work and perform research in my laboratory. I am a faculty member. I apologize. I am a faculty member who is also highly engaged in professional and university and community service activities. With respect to per and polyfluoroalkyl substances, I help to write or review documents from the U.S. Environmental Protection Agency, the International Agency for Research on Cancer of the World Health Organization, the U.S. National Toxicology Program, and the U.S. Agency for Toxic Substances and Disease Registry. I've also been part of advisory groups on PFAS for the states of North Carolina, Tennessee, and Michigan, and I have provided testimony on PFAS toxicity 3 times before subcommittees of the House of U.S. Representatives at the federal level. Overall, with respect to PFAS, I've co-authored 16 primary research articles, 14 review articles and commentaries, and 2 book chapters. These are all related to PFAS toxicity or immunotoxicity. I also edited one of the first comprehensive texts on the toxicity of PFAS. My total publication numbers are at about 80 total publications right now.
Is Amigos Bravos Exhibit 8 an accurate copy of your curriculum vitae?
Yes, it was at the time I submitted it.
Dr. DeWitt, you submitted direct and rebuttal testimony on behalf of Amigos Bravos in this matter, correct?
Correct.
Is your testimony in both those testimonies accurate to the best of your knowledge?
Yes, to the best of my knowledge.
Can you please summarize the opinions in your testimony?
Yes. For the Commission's consideration, I offer the following opinions. First, in my opinion, 9 individual PFAS should be treated as toxic pollutants for purposes of New Mexico surface water regulations. These 9 PFAS are identified in both my direct and rebuttal testimonies. Secondly, I support including a definition in the surface water regulations for contaminants of emerging concern, or CECs. And in my opinion, the Environment Department proposed definition of contaminants of emerging concern should include PFAS that are not already considered to be toxic pollutants by NMED as examples of contaminants of emerging concern. Third, in my opinion, NMED should have the authority to require dischargers to monitor for contaminants of emerging concern, which would establish a baseline for CECs and to require ongoing reporting and monitoring for CECs. Fourth, LANL proposes to limit sampling and analysis for purposes of compliance with standards and for certification of federal permits to EPA's sampling methods under only 40 CFR Part 136. But I'd like to point out that Part 136 doesn't include a method for sampling or analytical techniques that are specific to PFAS. The US EPA's Office of Research and Development has published sampling and analysis methods for PFAS that may be used. In my opinion, LANL's proposal to limit sampling methods to Part 136 methods would neither be protective of human nor ecological health from the effects of PFAS that are found in surface waters.
In addition to relying upon your professional expertise and experience in forming your opinions, did you provide a list of references you reviewed to reach your opinions in your direct and rebuttal testimonies?
Yes, I did.
Dr. DeWitt, what are PFAS?
As I mentioned, PFAS is an acronym that stands for per and polyfluoroalkyl substances. This comprises a class of almost 10,000 individual compounds, and in the vast majority of cases, individual PFAS are either non-degradable or they degrade to terminal products that are still PFAS. They just don't break down once they get into the environment. PFAS are used because they're chemically and thermally stable. They have properties that make them commercially useful in many different applications. They're used as surfactants or raw materials for fluoropolymers and to make nonstick, water repellent, and grease repellent coatings. They're also part of aqueous film forming foams, or AFFFs, that are used in fire suppression activities. Because PFAS have been used so extensively and because they are highly resistant to degradation, they are very persistent in the environment and widespread in the environment. Many of the PFAS that have been studied to date have the potential to bioaccumulate or move into living organisms from the environment. As a result, they're now detectable in tissues and blood of wildlife and in humans. Through the National Health and Nutrition Examination Survey, the Centers for Disease Control and Prevention does monitor for PFAS in the blood and the urine of the general US population. Through this survey, they've reported that there are detectable concentrations of one or more PFAS in the serum of over 97% of surveyed individuals. This indicates that people in the US are experiencing widespread exposure to PFAS.
In your direct testimony, you provided detailed information about the potential public health threats of PFAS. Can you please summarize those risks?
Yes, we know about PFAS and their health effects from epidemiological studies of people who have been exposed to them through their jobs or from environmental sources such as drinking water. And these studies do indicate that PFAS pose a hazard to human health. Some of these hazards I list right now. They include pregnancy-induced hypertension or preeclampsia. This is considered a disorder of the placenta, and the only cure for this is delivery of the child, which is very problematic if this occurs before the child can sustain its life outside of the mother. There have been noted increases in liver enzymes. Often when liver enzymes are increased and detectable in the blood, these indicate signs of liver disease or damage. There have been measures of increased risk of thyroid disease. The thyroid is an endocrine organ that plays very important roles in basic metabolism. There have been reports of decreased antibody responses to vaccines, which is very concerning considering that we're still fighting our way through the COVID-19 pandemic. There have also been reports of increased risks of asthma, which is another response of the immune system known as inappropriate immune stimulation. Those who suffer from seasonal allergies know exactly what I'm talking about. There's also been increased risks of decreased fertility, so it takes individuals longer to attain pregnancy. Increases in serum lipids, specifically total cholesterol and low density lipoprotein cholesterol. These can increase the risk of cardiovascular disease or stroke. And small decreases in birth weight also have been reported. When babies are born very low weight, such as less than 5 pounds, they may have increased risks for additional diseases later in life, such as neurobehavioral disorders.
What action has the U.S. Environmental Protection Agency taken with respect to PFAS?
They have taken quite a few actions. Specifically, in 2006, the US EPA launched a voluntary program known as the 2010-2015 PFOA Stewardship Program. As I mentioned, PFOA is perfluorooctanoic acid, and this program is to phase out PFOA and its higher homologs. Higher homologs are other PFAS like PFOA that have a group on them known as a carboxylic acid functional group, but have more than the 8 carbons that are in PFOA. The stewardship program also includes PFAS that could degrade to PFOA. These are known as precursor compounds, and these are the kinds that can break down into terminal end products, and one of those can be PFOA for some of the precursor compounds. This stewardship program was undertaken due to concerns that had arisen about these PFAS, including their environmental persistence, their widespread presence in the environment and in the blood of people in the US. It also arose because of concerns of the long residence time or half-life that PFOA and its higher homologs have in people, and the toxicity that had been uncovered for these compounds, including developmental and some of the other adverse health effects that I listed in epidemiological studies and in studies of experimental animals. Perfluorooctane sulfonic acid, or PFOS, another PFAS, also was phased out by its major worldwide manufacturer in the early 2000s due to its detection in the blood of people, and also due to reports of its toxicity. This stewardship program resulted in the phase out of PFOA and other long chain PFAS like PFOA by 8 US major manufacturers. I mention this because PFOA and PFOS are two of the 9 PFAS compounds that I recommend be treated as toxic pollutants. In addition, the US EPA has established a value known as a lifetime health advisory for PFOA and PFOS to protect the general public from ingestion of drinking water contaminated with these compounds. This protective value for PFOA and PFOS is based on their ability to affect babies as they develop, and this value is 70 parts per trillion. The US EPA also has conducted what are known as health risk assessments of 2 other PFAS. One is known as PFBS and the other is known as GenX. It also has established a PFAS action plan and an EPA council on PFAS.
Can PFAS be introduced into surface waters?
Oh yes, surface waters such as lakes and rivers can be contaminated by PFAS from many different sources. There can be intentional industrial releases. These can be allowable under permits or not allowable. Spills or other accidents from industrial facilities or from fire training activities can lead to PFAS infiltration into surface water. Runoff from lands that have been treated with biosolids, that is degraded human waste, that contain PFAS can lead to water contamination. Release of PFAS containing wastewater from water treatment facilities that receive water contaminated with PFAS also can lead to contaminated water. And PFAS also can be deposited into water from atmospheric deposition because we know they can get up into the atmosphere and move around the environment that way. I think living organisms then, when they consume surface water or ingest surface water or even contact surface water, can be contaminated with PFAS. The ingestion of food that has been irrigated with water contaminated PFAS also can lead to human and other living organism exposure to PFAS.
Does PFAS contamination in surface waters pose a threat to drinking water?
Absolutely, yes. The Environmental Working Group, which is a nonprofit organization, for example, evaluated PFAS occurrence data from a monitoring program under the Safe Water Drinking Act. And this program monitors for contaminants of emerging concern. And one of the monitoring events included lists of PFAS. The Environmental Working Group looked at these data and reported just last year that the drinking water of over 100 million Americans is likely contaminated with PFAS. This report from the Environmental Working Group highlighted that a major source of PFAS exposure to Americans is through drinking water, which is very often sourced from surface water sources. Community providers deliver drinking water to households, and there are multiple types of facilities that source drinking water from surface water across the nation. And surface waters, including rivers and lakes, are sources of water for these various providers.
And Dr. DeWitt, what action has the state of Colorado taken to regulate PFAS?
So Colorado is a state that has acted on PFAS because exposure to PFAS is a serious risk to public health. And there are a number of PFAS, and in the state of Colorado, there are a number of PFAS that are treated as toxic pollutants in their surface waters. The Colorado Water Quality Control Commission regulations state that, and I quote, "State surface waters shall be free from substances attributable to human-caused point source or non-point source discharge in amounts, concentrations, or combinations which are harmful to the beneficial uses or toxic to humans, animals, plants, or aquatic life." In Colorado, they established translational levels or chemical-specific values based on available toxicity data at the federal level to establish the limits for substances that are toxic. Translational levels were developed for 5 individual PFAS, including 3 that are already toxic pollutants under New Mexico groundwater regulations, and 2 additional PFAS. These translational levels were also applied to 4 PFAS that are parent constituents or precursor compounds that can degrade to PFOA or PFOS. So I identify the specific translational levels developed by Colorado for each of these 9 PFAS in my direct testimony.
Can you please explain the basis of your opinion that NMED should treat the 9 PFAS you have identified as toxic pollutants under the surface water regulations?
So I do provide a more complete basis for my opinion in my direct testimony, but I'll summarize here. So under the Commission's surface water regulations, toxic pollutants are, and I quote, those pollutants or combination of pollutants, including disease-causing agents, that after discharge and upon exposure, ingestion, inhalation, or assimilation into any organism, either directly from the environment or indirectly by ingestion through food chains, will cause death, shortened lifespans, disease, adverse behavioral changes, reproductive or physiological impairment, or disease deformations in such organisms and their offspring. End of quote. My opinion is based on accumulated toxicological data for the 9 PFAS that meet the definition and that have been summarized in documents by the US EPA, the US National Toxicology Program, the International Agency for Research on Cancer, and the US Agency for Toxic Substances and Disease Registry, on the actions of the state of Colorado to limit these 9 PFAS in its surface waters due to their toxicity, and on my own knowledge and research of the toxicological effects of these 9 PFAS and other PFAS.
In its technical testimony, LANL proposes limiting the definition of toxic pollutants to EPA's list and any constituents identified by the Commission in the future by rule. Dr. DeWitt, are any of the 9 PFAS that you have identified as toxic pollutants currently on the EPA list?
None of the 9 PFAS that I believe should be categorized as toxic pollutants under New Mexico surface water quality regulations are on the EPA list.
What explains the fact that these compounds that you as an expert believe are toxic pollutants are not on EPA's list?
The EPA really has demonstrated a commitment to collecting scientific evidence about PFAS. The scientific evidence will allow the agency to determine if individual PFAS, groups of PFAS, or even all PFAS as a class may cause significant harm to human or ecological health, even at relatively low concentrations. The EPA has demonstrated a commitment to protecting human and ecological health from PFAS by the establishment of their lifetime health advisory levels for PFOA and PFOS in drinking water, as well as the creation of health risk assessment documents for additional PFAS. Unfortunately, the EPA is often quite slow to add substances to the Clean Water Act. The last amendment to the list of pollutants was made in 1981. Numerous factors beyond the scope of my opinion very likely contribute to the lack of additional substances to the Clean Water Act. I do, however, to continue to support my testimony that New Mexico should treat the 9 PFAS I have identified as toxic pollutants, even though they're not on EPA's list.
Excuse me, Ms. Fox, there are 4 minutes left.
let's see, 15, 20, I guess 20, we have 21 minutes. We're at 21.
We picked back up at 20 minutes to 11, and it is now 6 after 11. So by my calculation, there are 4 minutes left.
She is going to be a little bit longer than that then.
Again, this is a summary, and luckily all the commissioners have looked at her direct testimony that's in writing and part of the record. So I'm asking you to summarize the rest of her testimony in the next 4 minutes. Thank you.
We also have rebuttal that's not included in that time period.
Ms. Fox, I'm asking you to summarize the rest of her testimony in the next 4 minutes. There will be cross-examination questions and redirect, and maybe you can get to some of your rebuttal in that period of time as well, but half an hour is the most time that we can take per witness for a summary of evidence that's already in full accepted into the record.
No, I understand the guideline was 30 minutes, but what I'm saying is that the rebuttal is outside that 30 minutes under the procedural order.
Okay, Ms. Fox, when I asked you how long her testimony would take, you said less than 30 minutes, and it's now almost half an hour now. So I understand what the scheduling order that I signed says, but I'm also trying to be fair to all the parties so that everyone gets their witnesses in front of the commission and in front of the public. So I'm asking you to wrap up the summary as soon as you possibly can.
Okay, thank you, Mr. Hearing Officer. I'd just like to note an objection to the time limit, and we'll move on. Dr. DeWitt, do you support adding a definition in the surface water regulations for CECs?
Yes, I do. The US EPA has a definition for the concept of emerging contaminant since the mid-1990s. They use this definition to identify chemicals and other substances that have no regulatory standard, have been detected in streams, and potentially cause deleterious effects in aquatic life at environmentally relevant concentrations. CECs, these are contaminants that may be contaminants for future regulation, depending on the accrual of scientific data that indicates that they do pose hazards to human or ecological health. So they are a serious concern because of their widespread occurrence.
Do you support adding PFAS as an example of CECs and NMED's proposed definition?
Yes, I do. PFAS are referred to in the U.S. Environmental Protection Agency information on CECs. They are referred to as CECs in their action plan.
And do you support giving NMED express authority to monitor CECs in federal permits?
I do. The only way we can obtain appropriate information on the occurrence of CECs in surface waters and to determine if they do pose a hazard to human and ecological health is to monitor for them and obtain report data on their occurrence and levels.
And do you, I'm sorry, go ahead.
I'm finished.
And do you, with respect to Lionel's proposal to limit monitoring methods to Part 136 methods in 40 CFR Part 136, what are the implications of that proposal for sampling and analysis for PFAS?
So 40 CFR 136 does not contain methods for evaluating or measuring PFAS in surface waters. However, the US EPA does have published methods for measuring PFAS in drinking water. This is known as EPA method 137.1.
Was that 537.1?
Yes, you're correct. That is 537.1.
That will end my summary. That will end Dr. DeWitt's summary of testimony, since she's not allowed any more time and she stands for cross-examination.
Are there any parties that wish to cross-examine Dr. DeWitt? These are on issues number 3 and 4 by the best of my ability to read this spreadsheet.
Mr. Hearing Officer, I have just one question for, at least I hope.
Okay, I saw Mr. DeSalen's hand first, so CCW will go first, and then Lannel will go next. Are there any others besides those two? No. Okay, Mr. DeSalen.
Thank you, Mr. Hearing Officer. Dr. DeWitt, I just want to give you the opportunity to add anything more to your testimony that you weren't able to cover.
Mr. DeSalen, that's not a valid cross-examination question, so I'm going to strike that from the record. And do you have any other questions?
No, Mr. Hearing Officer, I do not. Thank you.
Thank you, sir. Mr. Rose?
If I can unmute my microphone, I might be able to ask it. Dr. DeWitt, in your oral testimony, you stated that you opposed Lannel's proposal to limit the Water Quality Control Commission's authority or the department's authority to only use Part 136 approved methods. Do I understand you correctly?
Yes.
And when you're speaking of Lannel's proposal, are you looking at it's Lannel exhibit, I think the most recent is 57.
I do not have that exhibit in front of me at the time. So if you could read for me what you would like me to consider, that would be helpful.
And as I read it, and folks will correct me if I'm wrong, the proposed changes that Lannel's proposing to add to that section, which is 20.6.4.14, which is titled Sampling and Analysis, Lannel is proposing to add language that says 40 CFR Part 136 approved methods shall be used to determine compliance with these standards, and in Section 401 certifications under the Federal Clean Water Act. In all other cases, sampling, and then it goes on, and analytical techniques shall conform to with methods described in the following references. And so, again, is it your testimony that Lannel's proposal limits the department or the commission to only Part 136 methods in all circumstances?
It is my understanding that they limit the NMED's ability to sample for PFAS in surface waters using methods that have been approved by the US EPA for measurement of PFAS in water. And this method is US EPA method 537.1.
And Dr. DeWitt, we disagree in terms of what that section requires. So I think the testimony will accept that we're only limiting it in accordance with federal law to compliance determinations, not monitoring by the department simply for monitoring purposes. So just wanted to clarify what the basis of your opinion was. Thank you, Mr. Hearing Officer.
Ms. Fox, is there a redirect as to the question that that Mr. Rose asked?
Yes, there is, Mr. Hearing Officer.
Please.
Thank you. Dr. DeWitt, turning to page 5 of your rebuttal testimony, which is Amigos Bravos Exhibit 17. If you have that.
Just give me 1 second. Of course, that's the one document that I did not open. All right, and you said it was on page 5?
Correct. The last question on page 5 under sampling and analysis.
Yes.
The question is, currently under the commission's regulations, NMED may use various sampling methods listed in 20.6.4.14 NMAC to monitor for constituents. Triad DOE proposed to limit sampling and analysis of constituents for purposes of compliance with standards and certification of federal permits to methods approved in 40 CFR Part 136. Have you reviewed 20.6.4.16 NMAC on sampling and analysis?
Yes.
And so when you prepared your rebuttal testimony, you were familiar with the sort of nuance in Lanel's proposal that the sampling and methods would be limited to Part 136 for purposes of compliance with standards and certification of federal permits, correct?
That is how I understood it. Yes, correct.
Thank you. That's all I have, Mr. Hearing Officer.
Ms. Fox, were there subjects of Sir Rebuttal that you wanted to briefly get a summary on?
Yes, please, Mr. Hearing Officer.
And what are those subjects?
It's rebutting Ms. Judge's testimony. She provided rebuttal testimony to Dr. DeWitt's testimony.
Okay, and what was the name of the witness you said?
Nancy Judd. Her exhibit is Lanel Exhibit 65.
And which issue, which section is this in? 3 or 4?
Let's see, it would be in 3.
In 3. Okay, please take 5 minutes and let's get a summary of the Sir Rebuttal testimony to Dr. Judd in issue number 3.
Okay, thank you, Mr. Hearing Officer. Let me just take just a bit of time to see what I would like her to do. Okay. Dr. DeWitt, on page 4 of Ms. Judge's rebuttal testimony, she claims that you believe that the 3 PFAS defined as toxic pollutants in 20.6.2 NMAC should, quote, by extension, be considered toxic pollutants under 20.6.4 NMAC, the surface water regulations. Is this a fair characterization of your testimony?
No, it is not. My direct testimony is clear, I think, in my opinion, that these 3 compounds should be toxic pollutants under surface water regulations in their own right, because they do meet the definition of toxic pollutants in surface water regulations based on accumulated toxicological data and information.
And that toxic, since we're short, I'm going to cut you off a little bit there, my own witness. And are those accumulated toxicological data, is that accumulated toxicological data information set forth in your direct testimony?
Yes, in several areas within my direct testimony, it is set forth.
She states that she disagrees with Amigos, this is Ms. Judd disagrees with Amigos Bravo's proposal that you support to include PFAS as an example of CECs in the definition, claiming on page 8 of her rebuttal testimony that this proposal would expand the list of CECs to include, quote, several thousand PFAS compounds, the majority of which lack toxicity data. Do you agree with Ms. Judge's characterization of Amigos Bravo's proposal?
No, I don't. The NMED's proposed definition defines CECs as contaminants that, quote, may cause significant ecological or human health effects at low concentrations, and are, quote, generally chemical compounds that, although suspected to potentially have impacts, may not have regulatory standards, and the concentration to which impacts are observed have not been fully studied, unquote. So this is qualifying language that makes it clear that these criteria apply to compounds to be considered as CECs. PFAS, like pharmaceutical and personal care product pollutants, are examples of chemicals that are considered to be CECs. So the NMED's proposed definition is consistent with EPA statements and definitions of CECs. There are some definitions given by the EPA for CECs, and PFAS fit into those definitions.
Thank you, Dr. DeWitt. That concludes for Sir Rebuttal, Mr. Hearing Officer.
And Ms. Fox, did you have Dr. Khan next?
She is available to testify on bucket 5.
And that's the bucket we're on.
Correct.
So would you like to call her?
Thank you, Mr. Hearing Officer. I'd like to call Rachel Khan.
Oh, Rachel Khan.
Ms. Khan is sworn, and she will proceed with her PowerPoint, which has to do with her rebuttal testimony in section 5 on existing use analysis and use attainability analysis. And we did not present, Mr. Hearing Officer, any exhibits in support of this testimony, but that's the section in her rebuttal testimony that she will be going over briefly.
Ms. Fox, Mr. Hearing Officer, was the commission allowed to ask questions for Dr. DeWitt? I don't recall.
Thank you, Mr. Rose. I appreciate it. Appreciate it. Are there any commission members who want to cross-examine Dr. DeWitt? Are there any public members that want to cross-examine Dr. DeWitt? Okay, Ms. Fox, please proceed with Ms. Khan. Thank you.
Thank you for that. Ms. Khan, please proceed.
Great. Thank you, Mr. Hearing Officer, Madam Chair, members of the Commission. I will, in similar format to my previous testimony, I will now share my PowerPoint. So this portion of my testimony will focus on the existing use analysis, EUA for short, for the proposed change in designated use of secondary contact to primary contact, and as well as the use attainability analysis prepared by the Department for Non-Perennial Waters. In summary, Amigos Bravos supports NMED's proposal to apply the primary contact use to 5 waters that currently have the secondary contact use. Excuse me. Amigos Bravos also asserts that additional waters that don't currently have Clean Water Act 101A2 uses could warrant upgrading, and a more rigorous analysis should have been conducted. And finally, Amigos Bravos opposes moving classified non-perennial waters to the unclassified segment 98. So starting with the existing use analysis, the EUA for upgrading to primary contact. As I mentioned, NMED, and as NMED has presented, they have identified primary contact as an existing use in several segments that are currently protected with a secondary contact use through their existing use analysis process. Again, I think we've heard a number of times, secondary contact is not considered a Clean Water Act 101A2 use. And 40 CFR 131.2A requires states to re-examine every 3 years any waters that don't have 101A2 uses to see if a 101A2 use is attainable. In addition, EPA has established a rebuttable presumption for Section 101A2 uses. Therefore, in general, the burden is on the state to demonstrate that a water can't attain a 101A2 use, not the other way around. EPA says that you can show existing, we've heard a lot about this in the previous testimony, about how you demonstrate and show proof of an existing use. EPA in this Smithy memo that we've been discussing, as well as in the Water Quality Standards Handbook, says that you can show existing uses by demonstration of use, such as pictures or testimonials, and the or is underlined here, showing that the water quality is good enough to support the use. Having both types of information is ideal, but it is not required. EPA has left it to the best professional judgment of states. Here, NMED has determined in their best professional judgment that these 5 waters have the existing use of primary contact. I find this confusing. I find that the designated use, existing use, and attainable use, it can be, I understand it can be confusing to many people. And I found it helpful to create this diagram to distinguish between these terms. So you have the designated use, which is what applies in the standards. And per requirements, the designated use must include all existing uses. The way to determine existing uses, you can look at these 2 buckets down here. You can look at water quality data. And that data can come from anytime from 1975 to the present, or you can look at documentation of use, such as photos, testimonials, etc. Again, that information can come from any time since 1975. In addition, you have attainable uses. And this process as outlined in 131.2a. If a designated use doesn't include a 101A2 use, as I mentioned, every 3 years, they must be re-examined to see if they are attainable. And if they are attainable, they need to be added to the designated use. If waters can't meet the 101A2 use, then the highest attainable use must be included in the designated use. So I'm pointing this out because I think that it highlights how the existing use analysis that was conducted by the department, looking at this bucket over here, is not a complete process for re-examining waters, because it doesn't look at the attainable use. It doesn't look at the attainable use category in this re-examination. So it is our opinion that more than 5 should have been considered, or I realize that more than 5 were considered, but more than the number that were considered and the 5 that were ultimately determined for upgrading it should have been analyzed, and potentially there would have been more than 5. Specifically, all segments without the 101A2 uses should have been analyzed, and that includes all waters with the secondary contact and limited aquatic life uses. Both of those uses, the secondary contact and the limited aquatic life uses, are not 101A2 uses. All segments with secondary contact and limited aquatic life, so they need to be re-examined every 3 years as per 131.2. So as I mentioned, the EUA is only one aspect of re-examining waters every 3 years. States need to look at attainable uses in addition to existing uses. And they're not always the same thing. For example, an attainable use would be where the water quality is currently poor, but if BMPs, if mechanisms are put in place and are implemented, the water quality could improve to a level that the use would be attainable. And another concern with the EUA process is that it shouldn't have been focused only on water quality for looking at these waters. So we think that some of the other waters that were initially examined were inappropriately dropped off, and that there could be more, or potentially inappropriately dropped off, because there wasn't a broader look at all types of data. And then moving on to the non-perennial use attainability analysis. we think that this process was flawed, or I think this process was flawed, and this is part of Amigos Bravos's position in the Triennial Review. So NMED is proposing to move non-perennial waters that are currently protected in classified segments in the standards to the non-classified intermittent segment at 98, as they presented in Ms. Aranda's testimony. Specifically, they propose to remove these specific segments as listed here on the slide by removing non-perennial waters from these segments and placing them by default into the non-classified protections for non-perennial waters. This represents a downgrading of uses, which is why NMED prepared a use attainability analysis. And as I outlined in my testimony and here in this summary, we think that this is flawed. Specifically, the evaluation of existing uses was incomplete. So to determine, as we've heard, you can't remove an existing use from a designated, you can't remove a designated use if it's an existing use. And so the department first went about determining whether there were existing uses for these waters, because if there were, they couldn't be removed. But the way that they went about that process was concerning, because they relied on lack of data to determine that there weren't existing uses. We think this is inappropriate. Lack of water quality data should not be used as a reason to downgrade water quality standard. Lack of applicable water quality data should lead to a collection of the data before a downgrading is allowed. In addition, there wasn't a comprehensive examination of other documentation, such as pictures, testimonials, etc. I did not see in the UAA a documentation that that type of information was sought. In addition, the use attainability analysis did not adequately determine that the low flow nature of these waters was natural. To downgrade a use, it must be demonstrated that attaining the use is not feasible due to one of the 6 factors at 40 CFR 131.10G. NMED, in their use attainability analysis here, applied the factor at 131.10G2, which is when natural, ephemeral, intermittent, or low flow conditions or water levels prevent the attainment of the use. So here, NMED in their UAA identified this factor as the justification for downgrading the use. Yet there wasn't an adequate determination about whether the low flow nature of these waters was natural or not. Specifically, while NMED did look to see if diversions were contributing to the low flow conditions, they did not assess whether these low flow conditions may be a response to climate change and therefore not natural. So they looked at one part of non-natural factors, such as diversions, but didn't look at another part, such as climate change. And another concern is that the boundaries of the waters at question are unclear. It's unclear exactly what waters are being downgraded. What are the boundaries of perennial and non-perennial stretches? We're concerned, as I outlined on the first day of testimony in the climate change section of this hearing, that these boundaries are likely to change dramatically as a response to climate change, and thus waters will be automatically downgraded as perennial stretches shrink. And this is not just an issue here as part of this use attainability analysis process. This is a larger concern as well with the standards as a whole, as I had outlined on the first day of the hearing, when I showed this diagram here, which demonstrates this concern that as the climate warms and our waters, more of our waters become non-perennial, that what we have with the way that the standards are set up, with them being identified with language such as the perennial reaches of a certain water body, that with no specific boundaries identified, that we won't know, there won't be a trigger, there won't be a process to examine as these non-perennial segments shrink in nature to determine if the shrinkage is due to natural or non-natural causes. And that's what we have here. And with the lack of specific boundaries being of specific waters being moved to the segment 98 segment, it's very concerning. We don't know exactly what those waters are, or if as more waters become, as we potentially, because of climate change, have additional non-perennial waters, that those waters will automatically be shifted in the future to segment 98. So in conclusion, it is our recommendation that the Commission upgrade the 5 segments identified by NMED from secondary to primary contact. The Commission should, in addition, direct NMED to conduct a more comprehensive analysis to look at information besides water quality data to determine if more water bodies besides only the 5 identified have either existing or attainable 101A2 uses. And I think actually I'd like to point out that while I think that NMED has adequately demonstrated that there is the existing use of primary contact in these 5 segments, that even if for some reason the Commission didn't feel that the existing use had been demonstrated adequately, I think it's been demonstrated that primary contact is attainable in those waters, and therefore the designated use should be upgraded to primary contact, regardless of whether it's an existing use or not. Though again, I do think that NMED has shown that they are existing uses. In addition, we recommend that the Commission not move the non-perennial waters in the 9 classified segments at issue in the use attainability analysis to the unclassified segment 98. Again, that's because the existing uses weren't properly analyzed, the natural nature of the low flow conditions wasn't conclusively determined, and the boundaries aren't identified and they are likely to change. That concludes the summary of my direct and rebuttal testimony.
And Ms. Khan stands for cross-examination.
Thank you. Are there any parties that wish to cross-examine Ms. Khan? Mr. Verheuel, any others? Mr. Verheuel, please proceed.
Thank you. Very briefly, good morning, Ms. Khan.
Morning.
Is it your understanding regarding the UAA that you just discussed, is it your understanding that the Environment Department used the National Hydrology Data Set to develop that UAA?
Yes, I read that.
What data is contained in the National Hydrology Data Set?
I am not familiar with all the data that's contained.
Okay. Do you know what organization publishes or modifies that repository?
I'm not recalling at the moment. I am sorry.
Okay, that's great. No further questions for this witness. Thank you.
Are there any commissioners that have cross-examination questions for Ms. Khan? Are there any members of the public that have
Mr. Hearing Officer,
cross-examination?
this is Commissioner Thompson. I apologize for being slow. Ms. Khan, I'm looking at NMED Exhibit 110, and I'm having a hard time recognizing that some of these reaches have been downgraded. So, for example, I'm looking at section 20.6.4.115. It's the Rio Grande Basin, and the language says the perennial reaches of Rio Felix, perennial reaches of tributaries to the Rio Felix, except Hopewell Lake, and perennial reaches of Rio del Oso and perennial reaches of El Rito Creek above the town of El Rito. And I don't see anything in that language that identifies reaches which have been downgraded.
Yes, it is. I I hear your confusion because I went through this language quite closely as well. My understanding is that they're changing it. So it's the current language, the non-red strikeout language, is the perennial reaches of the Rio Vallecitos and its tributaries, except Hopewell Lake and perennial reaches of the Rio del Oso and perennial reaches of El Rito Creek above the town of El Rito. So I think really we need to focus on the first, the first part of that, which is the perennial reaches of the Rio Vallecitos and its tributaries. So I think that the Environment Department has been interpreting and its tributaries to include all of its tributaries, including the non-perennial and the perennial portions of those tributaries. And with their proposed amendments, they are proposing that this segment only apply to the perennial reaches of those tributaries, and that all the non-perennial reaches of those tributaries will be now placed in segment 98. So it's downgrading, which has lower protections. So it's taking it, so the 98, I'm sorry, excuse me. Currently, the non-perennial tributaries of the Rio Vallecitos are protected here under this segment. Their proposal is to take all those non-perennial tributaries and put them into 98, which has lower protections.
I see. I will need to think about that. Mr. Hearing Officer, that's my only question. Thank you.
Are there any other members of the commission that have questions for this witness?
Mr. Hearing Officer?
Yes.
This is Commissioner Cipher.
Welcome.
Thank you. Ms. Khan, if I've understood what you've said lately, are you at all interested, or what's your thoughts on LANL's recommended existing use analysis process, their 5-step process? Are you aware of that? And I'd like to hear what you have to say about that process they recommend.
Yes, I'm generally, I'm concerned about a really overly burdensome existing use analysis process. As Nmed has pointed out, I believe in their testimony, as well as in their proposed language, both maybe at 10 and 15, that to upgrade a use, you do not have to do a use attainability analysis. So a use attainability analysis is only required when you're downgrading a use. But and we've been concerned in the past that Nmed has required a process, just as rigorous a process of basically has required a use attainability analysis to upgrade a use. And we've expressed that concern in a number of different formats before this commission, including, under the Water Quality Management Plan proceeding. But and as as a response, I don't know if it's a response to us, but what the Environment Department has now done has created this separate process called the existing use analysis process. And in some ways, it feels like it's even more burdensome than the process to downgrade a use. So we're concerned where we think that there's a rebuttable presumption as presented by EPA that these 101A2 uses should apply to waters. We shouldn't be creating such a burdensome process to protect our waters at higher and appropriate standards.
Okay, I appreciate that response, but can you give me a shortened version? Do you support LANL's recommended existing use analysis process?
I think it's too burdensome in general. My testimony was not focused on this, so I have to say that I haven't spent a lot of time looking at their process at this point.
For different reasons, you seem to have similar, or rather similar concerns, and so that's why I asked the question. But thank you very much. That concludes my questions.
Thank you, Commissioner.
Thank you, Commissioner. Are there any other commissioners? Ms. Fox, are there any redirect questions for this witness that would be brief?
No, Mr. Hearing Officer.
Okay. We have a public member who would like to make a comment before we break for lunch, but by my assessment of section 5 or issue bucket number 5, we still have testimony to take from San Juan. But that's all I see. Is that correct?
San Juan does have testimony to provide, yes, Mr. Hearing Officer.
CCW or mining or Buckman, I don't see anything for you. Is that correct?
That's correct, Mr. Hearing Officer.
That's correct, Mr. Hearing Officer.
Okay, all right. Okay, so before we break for lunch, and I do think that everyone should be thinking at this point for a day to continue this hearing, because it does not look like we are going to conclude issues 6, 7, and 8 by 6 p.m. today, unless the parties are going to come to some agreement to curtail the testimony of their witnesses. That's just an aside. So do we have the member of the public? Ms. McCarthy?
Yes, Mr. Hearing Officer, Ms. McCarthy is on the call.
I see her. Ms. McCarthy, would you unmute yourself so you can be sworn in and make a public comment that is general in nature and less than 5 minutes?
Yes.
Thank you, ma'am.
Ms. McCarthy, would you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Would you state and spell your full name for me, please?
SUSANN MC capital CARTHY.
Thank you.
Hello, please leave a message after the tone.
Ms. McCarthy, can you silence that in some way?
Sorry, wait a minute. Sorry for the distraction.
Please continue.
I would like to urge you to avoid a limited definition of climate change. I would like to ask you to support standards of contaminants of CEC. We must have a strict definition of CEC so that New Mexico Environment Department can require monitoring. It would be important to add perfluoroalkyl and polyfluoroalkyl in support of adding PFAs to the definition. No toxic fishing should be permitted because as a result of LANL requesting a limitation on the number of protected waterways. And please do not limit the existing definition of toxic pollutants. This is New Mexico's right to define what is a toxic pollutant and must not be ceded to others. Thank you very much for your time.
Thank you, Ms. McCarthy. Okay, are there any issues that we need to deal with before we take our lunch break? Mr. DeSalen?
Thank you, Mr. Hearing Officer. I just want to mention that in light of the stipulation that the parties have agreed to, on the issue of significant figures, we would be willing to withdraw our witness on that issue, Mr. James Kuipers, and his testimony. So that will save a little bit of time this afternoon.
So let me make sure I understand you, Mr. DeSalen. You are talking about issue number 6, and that was a rebuttal witness for you.
That was a rebuttal witness for me. I might not be 100% sure of the number, the issue number, but I know it was in one of the bins at the end, 6, 7, or 8.
Okay, all right. And you say that you're going to be withdrawing his testimony as well?
Yes, I don't think it's necessary given
Okay.
the stipulation that the parties have entered into.
Would you provide the court reporter either now or after lunch with the exhibit number that you're withdrawing? Because I can't put my finger on it.
Sure.
Okay. Thank you, by the way. Were there any other issues that we need to deal with before we take lunch? Okay, it is 11:52. Let's come back at 1 o'clock. So maybe take an hour and 10 minutes for lunch. And the meeting is adjourned. Thank you. Halfway through the 4th day of the Triennial Review, the department is going to put on its witnesses for issue number 6, known as criteria, and which attorney will be conducting.
Mr. Hearing Officer,
Yes?
I believe San Juan Water Commission had a witness to present on topic 5.
Excuse me, what is the name of the witness?
Jane DeRose Baman.
Okay, so please proceed.
Thank you, Mr. Hearing Officer.
Mr. Hearing Officer, let me jump in and ask if we can please do a roll call of the board, of the
Please.
commission.
Thank you.
Thank you. I apologize for the interruption, guys. Beginning with Commissioner Candelaria. Commissioner Surton.
Here.
Commissioner Dominguez.
Present.
Commissioner McWilliams. Commissioner Modi. Commissioner Musharafi. Commissioner Patton. Commissioner Rader.
Here.
Commissioner Patton, did I hear you or was it a different noise?
Yes, ma'am, I'm here.
Okay, thank you. Commissioner Cipher.
Here.
Commissioner Thompson.
I'm here.
Commissioner Timmons. Commissioner Vigil.
I'm here.
Okay. Vice Chair Wade. Chair Stringer.
I'm here.
Looping back around to Commissioner McWilliams. Have you joined us? Commissioner Modi. Vice Chair Wade. Okay. Mr. Hearing Officer, Chair Stringer, you have a quorum of the board.
And Ms. McCaleb, your witness is still under oath.
Thank you, Mr. Hearing Officer. Oh, I believe Mr. DeSalen has his hand up.
I didn't see Mr. DeSalen. What can I do for you?
Thank you. I just was wondering about our witness who was taken out of order, Ms. Kathy Sanchez. When do you foresee we can put her on?
Well, according to you yesterday, she's available all day. How about if you put her on? How about you put her on this afternoon during issue number 6?
Okay, thank you, Mr. Hearing Officer. That will do.
And please keep reminding me if it's getting close to 6 o'clock, or better yet, if it's getting close to 5 o'clock and we still haven't put her on. Thank you. Ms. McCaleb?
Yes, Mr. Hearing Officer, may I proceed?
Please, thank you.
Thank you. Mr. Rose Bamman, what is the focus of your testimony this afternoon concerning topic number 5?
I will highlight the most significant points presented in my written, direct, and rebuttal testimony concerning department's proposal to add 20.6.410 subsection B NMAC concerning existing uses and the department's proposal to upgrade the recreation designated use of several streams segments from secondary contact to primary contact based on the department's existing use analysis and NMED Exhibit 56. In response to the hearing officer's request that the parties limit the oral testimony so we can finish the hearing today, I will provide general statements of my opinions with limited reference to the pertinent state and federal regulations and guidance.
And why does San Juan Water Commission care about the topic of existing uses? And why is it objecting to the proposal to upgrade the recreation designated use for several stream segments, even though those segments are not located in the San Juan River Basin?
San Juan Water Commission has participated in triennial reviews since the late 1990s on issues of concern relating to the appropriate evidence required to adopt or amend a water quality standard. Each action taken by the Water Quality Control Commission establishes precedents for future proceedings. Existing use analyses may be conducted in the future for waters in the San Juan Basin. Therefore, San Juan Water Commission wants to ensure that an appropriate framework for existing use analyses is established and that existing use determinations follow EPA guidance requiring proof of use, not just water quality, meeting the criteria for the use.
Could you please provide a synopsis of your opinions concerning the department's proposal for 20.6.4.10B NMAC?
NMED proposes to add a new subsection B of 20.6.4.10 NMAC to reflect the requirements of 40 CFR 131.10I concerning existing uses. So in layman's terms, that regulation addresses when a designated use has to be upgraded to protect an existing use. In my opinion, the proposed language creates confusion, and it would be better either to cite the federal regulation or adopt the language of the applicable regulation, 40 CFR 131.10I. The regulation focuses on uses and not water quality. If the commission decides to adopt some language for section 10B, the amended version, rather than simply cite or quote the federal regulation, it is my opinion that the language proposed by LANL is better because it focuses on designated uses and removes the references to water quality. It also captures the federal requirement that there be new evidence.
Let's move to the department's proposal to upgrade the recreation use on several stream segments from secondary to primary contact. During the last triennial, the WQCC rejected the department's proposal to upgrade the recreation use for these same segments. What is your understanding of the basis for that rejection?
The only evidence of primary contact use provided by the department during the last triennial review was anecdotal evidence that swimming might occur and anecdotal evidence of secondary contact uses. The Water Quality Control Commission rejected that anecdotal evidence and requested evidence that primary contact recreation was actually occurring. You could see page 23 of my testimony. The Water Quality Control Commission did not request water quality data. The issue of water quality was never addressed in the context of proving the existing recreation use. The department's technical memo, pertinence portion of this transcript, and pertinent technical testimony filed by NMED and San Juan Water Commission during the last triennial are attached to my rebuttal testimony. Historically, the Water Quality Control Commission has relied on evidence of actual use, such as photographs of someone swimming in the water.
What is your opinion of the existing use analysis produced by the department for this triennial?
Although extensive, it does not provide sufficient credible scientific evidence or other information that primary contact is an existing use attained in these sections. By definition, primary contact recreation use requires prolonged or intimate contact, human contact with the water, involving a considerable risk of ingesting enough water to pose a significant health hazard. Examples are swimming and certain cultural or religious activities. That's from 20.6.47P5, directly out of the definition of primary contact. The department has provided no evidence of primary contact use. Instead, the department relies solely on old water quality data concerning pH and E. coli. The existing use analysis concludes that primary contact is an existing use because the criteria assigned to that use have been met at least once since November 1975. However, EPA guidance stresses the proof of actual primary contact use by humans is critical. Nmed Exhibit 62, which Ms. Fulham relied on in her written testimony, is a 2008 EPA letter to the State of Oklahoma Water Resources Board that gives guidance about establishing existing uses. The parties refer to the guidance as the Smithy Letter. The letter states that an existing use is actually attained if both the use and the water quality necessary to support that use have been achieved. I urge the commissioners to read the letter, the Smithy Letter, and its attachment in its entirety. The Smithy Letter also states that an existing use evaluation should be made based on site-specific conditions. The department did not conduct a site visit to these segments for this existing use analysis. The Smithy Letter also indicates that suitable water quality is not enough to prove an existing use if, quote, there are physical problems which prevent the use regardless of water quality, end quote. Again, the department conducted no site visits to determine whether physical problems prevent primary contact use. I provided photos of the Rio Hondo, which I believe show primary contact use is not possible in at least a portion of that segment. There is no evidence that the department conducted a site visit for this existing use analysis. Ms. Saranda's oral testimony indicates the department conducted site visits to collect water quality data. That water quality data was collected years ago. It is not appropriate for the department to choose not to conduct a site visit to determine whether primary contact use is occurring or whether it is even possible given site conditions. Choosing not to do so does not make evidence of primary contact use unavailable, as the department contends. Also, 40 CFR Section 131.20 requires that the Water Quality Control Commission evaluate, quote, any new information that has become available, end quote, since the last training review concerning the existing recreational use. I don't agree that the reviewing old water quality data and choosing to present it to the commission for the first time meets the federal requirement of new evidence. The department has presented no evidence that the secondary contact use was assigned by the Water Quality Control Commission in 1988 based on water quality data. For all of these reasons, the Water Quality Control Commission should require proof that swimming or other primary contact activities are occurring before upgrading these sections to the primary contact designated use. As the Smithy Letter states, it is important that the Water Quality Control Commission not upgrade the designated use without appropriate evidence, because an existing use may not be removed, regardless of whether it remains attainable in the future.
Do you have any concerns about the process the department used to develop the primary contact EUA?
Yes, the primary contact existing use analysis was developed without any input from permittees, the public, or other stakeholders like San Juan Water Commission. Based on San Juan Water Commission's participation in the last triennial, NMED has had 7 years notice about San Juan Water Commission's concerns and the type of evidence San Juan Water Commission believes is required to prove primary contact is an existing use. The Water Quality Control Commission adopted San Juan Water Commission's position during the last triennial. But NMED never contacted San Juan Water Commission when it was developing the format of its existing use analysis. Nor did it share any information about the EUA until May of this year. The public and the parties to this triennial have had only 2 months to digest the EUA and prepare a response to the Commission. This definitely was not a collaborative or transparent process. Also, as Ms. Aranda noted, there are 4 NPDES permit treatment plants that will be impacted because they have E. coli discharge limits greater than the primary contact numeric criteria. According to NMED testimony, permittees were not notified until January of this year, and my understanding is that they were never given a copy of the draft EUA. If San Juan Water Commission and other interested persons had been involved in the process, concerns may have been resolved well before the triennial review hearing, and other parties may even have provided evidence of primary contact uses, if it exists.
How does the San Juan Water Commission believe your concerns could be addressed going forward? And how do you believe your concerns could be addressed going forward?
San Juan Water Commission agrees with Llano's witnesses, Dr. Meyerhoff and Mr. Gallegos, that a formal EUA procedure should be developed and should undergo a thorough vetting process, including stakeholder and public input, and final approval by the Commission. The only way to ensure that future Water Quality Control Commission existing use decisions are consistent is to adopt a formal EUA process, including a description of the types of new evidence required based on the 2008 EPA guidance letter.
Were you present this morning during the Commission's cross-examination of the department's witnesses?
Yes, I was.
And did you hear the exchange between Commissioner Dominguez and Ms. Fulham concerning when the EUA analysis in Exhibit 56 was provided during this proceeding?
Yes, I did.
And Ms. Fulham stated that the department had preliminary data for the existing use analysis at the time the petition was filed in August 2020, but did not release it because it wasn't yet ready for public review. Did you request a copy of that EUA during a stakeholder meeting in November?
In November 2020, I did participate, and when Ms. Fulham mentioned about the EUA, I had asked about whether it was available, and she said it was not.
Did the failure of the department to provide a copy of the draft EUA with its petition impede your ability to prepare for this triennial review?
Yes. The reason why it was I didn't get the EUA until May, and it is very unlike the New Mexico Environment Department to not provide something ahead of time. Is an example through the 2013 triennial, they had provided public discussion drafts on not only the proposed changes, but also the support for those proposed changes then. There was even a public discussion draft for the UAA that was provided there. And those are in exhibits, San Juan Water Commission Exhibit 2B. And so it was just kind of surprising. So I didn't think that we were going to get that far along with this EUA. And then May 3rd, here it was.
And in fact, May 3rd is the date you had to provide your written direct testimony. Is that correct?
Correct. I submitted it, and then the next day we saw Environment Department's proposal.
Do you have any further testimony you would like to give concerning 20.6.4 10B NMAC or the existing use analysis for primary contact?
No, I do not.
Mr. Hearing Officer, I have no further questions.
Are there any parties that want to cross-examine this witness?
Mr. Hearing
Are there
Officer?
any commission? Sorry?
Mr. Hearing Officer, I don't know if you could not see me. I was raising my hand to indicate I did indeed have questions.
Okay. I expected you would, and then I didn't see you and I didn't hear you. So yes, are there any other parties besides the department? Mr. Verheuel, please proceed.
Thank you. Mr. Rose-Bamman, are you aware that the department contacted the permittees whose permits would be impacted by these proposed amendments, upgrading from secondary to primary contact?
I saw your exhibit 58, and it was from January of 2021. I saw the email that was sent. It didn't look like the EUA was attached.
But you're aware that the department contacted the permittees whose permits would be affected, is that right?
According to your exhibit 58, that's how I was aware.
Okay. Do you know what the result was of that communication?
According to the testimony, they said they received one contact from one of the parties, one of the permittees.
And did the permittees have any issues or concerns regarding this proposed change?
I don't think lack of response from permittees is necessarily a fact that they don't have a concern. I think they may not have even seen the email, but the fact that you sent the email is there.
Okay.
And the fact that you documented one of your conversations, which was good. I mean, you did get confirmation from Fort Sumner.
Great. So there's no confirmation that you can see anywhere that any permittee had any issues or concerns with this proposed amendment. Is that right?
That is correct from your exhibits.
Thanks. Are you aware of any evidence anywhere other than in our exhibits that would indicate to you that any permittee had an issue?
I have not talked to the permittees, no.
So that's a no.
That would be a no.
Okay. Would any data later than November 28, 1975, would that be applicable for developing an existing use?
It could be.
Would there be any limiting factors that you're aware of to determine when data is not usable in terms of when it was collected?
No, but when you look at the language in 131.20A, they specifically say that when you're looking to evaluate whether a section 101A2 use has not been adopted, whether it needs to be adopted, you're supposed to look at any new information, or the regulatory authority is supposed to look at any new information. So from that perspective, new information would be anything new from any time after the last decision was made about that use.
Do the federal regulations or does EPA provide anything as to when data is too old to establish the lowest protectable water quality necessary to uphold the goals of the Clean Water Act?
Not that I'm aware of.
Okay, I have no further questions for this witness on this topic. Thank you.
Are there any commissioners that have cross-examination for the San Juan Water Commission witness? Are there any members of the public who have cross-examination? Ms. McCaleb, do you have any redirect on the questions Mr. Verheuel asked?
Yes, sir, I do.
Please proceed.
Thank you. Mr. Rose-Bamman, has the department provided any evidence concerning what the water quality was when the WQCC originally assigned the secondary contact designated use?
Not that I'm aware of.
Is it possible that at the time the Water Quality Control Commission elected to assign the secondary contact use, that the water quality actually met primary contact criteria?
Yes, it is possible.
Has the department provided any evidence that the water quality in these segments has improved from secondary to primary contact criteria since the secondary designated use was assigned?
Would you repeat that?
Sure. Has the department provided any evidence that the water quality in these segments has improved from secondary contact criteria to primary contact criteria since the secondary contact designated use was originally assigned?
There's no.
Thank you. I have no further questions.
Okay, Mr. Verheuel, who is presenting the department's witness on issue 6?
Mr. Hearing Officer, this is going to be a split matter. I'm going to call Ms. Jennifer Fulham, after which Ms. Maxfield will call Chris Barrios, and after that, I will bring up Diana Aranda.
Are they going to stand for cross on a panel?
Yes.
Okay, please proceed.
Good afternoon, Ms. Fulham. You have been sworn in, that's correct?
That's correct.
Can you briefly describe the department's proposed amendments to section 900H6 regarding the designated aquatic life use for marginal warm water?
The department's proposing to incorporate the maximum temperature criterion from the definition for marginal warm water aquatic life to the criteria section in 20.6.4.
Can you briefly describe the reasoning for this?
Because the criteria for designated uses are codified in section 900, the numeric criterion in the definition of marginal warm water is not applicable for use for assessment of waters with a marginal warm water aquatic life use. So in order to apply the temperature criterion as appropriate, the criterion must be identified in section 900. This proposed amendment is intended to ensure the appropriate temperature criterion is applied for the designated marginal warm water aquatic life use.
Did any party object to this?
No.
All right, I'm gonna move along to the department's proposed amendments to section 900I regarding the hardness-based aquatic life criteria for zinc. Can you describe that?
The department originally proposed to adopt new hardness-based acute and chronic aquatic life criteria for zinc.
Does the department still propose this amendment?
No.
Why did we withdraw that?
Upon further review, it was determined that EPA's recommended criteria was based off of older studies in comparison to the state's current zinc criteria. So the department determined that the current criteria is more appropriate until it can be investigated further. Therefore, the department decided to rescind the proposed amendment accordingly.
Did any party object to that?
No.
Okay, I'm going to stay in section 900I, but if you could now describe our proposed amendments to the hardness-based aquatic life criteria for cadmium.
So the department is proposing to update the hardness-based acute and chronic aquatic life criteria for cadmium, and that is to be aligned with EPA's 2016 recommended aquatic life criteria.
And can you describe the reasoning for that?
Well, the department did not originally propose updates to the hardness-based aquatic life criteria for cadmium. However, based on comments received from the San Juan Water Commission, we noted that the state's acute and chronic hardness-based cadmium criteria were not equivalent with EPA's 304A aquatic life criteria for cadmium. EPA updated the criteria in 2016, which was based on more recent studies. So in accordance with 40 CFR 131.20, where the state must adopt EPA's recommended criteria or provide reasoning for not adopting. At this time, the department doesn't have a reason not to adopt, so it's been included as a proposed amendment for this triennial review.
Did any party object to that?
No.
Okay. I'm going to move along now to section 900J1, and this is with respect to numeric aquatic life criteria for dissolved aluminum. Could you describe that proposed amendment?
The department's proposing to reestablish the acute and chronic numeric criteria aquatic life criteria for dissolved aluminum for waters with a pH outside the applicable range for the hardness-based aquatic life total recoverable aluminum criteria.
And can you describe the reasoning behind that?
When the state adopted its hardness-based aquatic life criteria for total recoverable aluminum, it intended to replace the numeric criteria for dissolved aluminum. So the numeric acute and chronic aquatic life dissolved aluminum criteria were removed as part of the same action. However, when EPA reviewed the proposed criteria after it had already been made effective for state purposes through a rulemaking process, EPA only approved the hardness-based aquatic life total recoverable aluminum criteria for waters with a pH between 6.5 and 9, not all the pH ranges. EPA asserted that since the hardness-based criteria only applied to a particular pH range, the former numeric criteria was removed from the standards inappropriately without supporting evidence. Therefore, EPA still applies the numeric aquatic life criteria for dissolved aluminum for purposes of the Clean Water Act for any waters with a pH outside that approved hardness-based pH range. The intent of this amendment is to reestablish the numeric aquatic life criteria for dissolved aluminum for waters with a pH range outside the approved range for the hardness-based criteria, so the implementable standards under the Clean Water Act are equivalent to those standards codified in 20.6.4 NMAC.
Okay, I understand that Triad and DOE objected to these amendments. Can you explain the reasoning behind that objection?
Triad and DOE object with the assertion that EPA's 1988 ambient water quality criteria for aluminum is not applicable beyond a pH range of 6.5 to 9. Given the proposed amendment would reestablish the acute and chronic aquatic life criteria for dissolved aluminum beyond this range, Triad and DOE find it inappropriate and inconsistent with EPA's guidance.
Does EPA's recommended criteria have limits on the pH range to which it is applicable?
Yes. EPA's 1988 recommended aquatic life criteria for aluminum does discuss a pH range of 6.5 to 9.
Did the state adopt the criteria as found in that 1988 EPA guidance?
No, the state appears to have adopted a modified version of EPA's 1988 recommended aquatic life criteria without a prescribed pH range, as allowed for under 40 CFR 131.11. These criteria without defined pH ranges were approved by EPA.
Was there an established pH range for the state's numeric aquatic life criteria for dissolved aluminum when it was adopted?
No, although EPA's recommended criteria has a pH range, like I previously stated, the state did not clarify or limit the range to which the numeric aquatic life criteria for dissolved aluminum applied. So technically, the numeric aquatic life criteria for dissolved aluminum applied to all waters with an aquatic life use with numeric criteria, regardless of the pH.
Couldn't the pH range just be extended for the hardness-based criteria instead?
No, although the hardness-based aluminum criteria were originally adopted in 20.6.4 NMAC to not have a pH range, EPA disapproved the hardness-based range outside 6.5 to 9. So as a result of this action, there was a gap for applicable aluminum criteria for waters outside that approved hardness-based pH range. EPA has therefore been applying the former aquatic life use numeric criteria for any waters outside the approved hardness-based range.
Does this proposed amendment change the implementation of the criteria?
Not to my knowledge, because EPA disapproved the hardness-based criteria outside of that pH range, the applicable acute and chronic dissolved aluminum criteria for purposes of the Clean Water Act are and would remain 750 and 87 micrograms per liter respectively. The proposed amendment is just reestablishing the criteria under 20.6.4 NMAC as EPA has been implementing it.
What would happen if this proposal is not adopted?
The implementation by EPA would remain the same as it's been, but this would continue to lead to confusion given the state regulations do not reflect the implementable criteria for purposes of the Clean Water Act.
Okay, great. I'm going to direct you now towards the footnote that's under section 900J2. Can you describe the department's proposed amendments to that footnote regarding the applicability of the aquatic life dissolved aluminum criteria?
So as part of reintroducing the acute and chronic dissolved aluminum criteria, the department is also proposing to add a footnote to the numeric criteria table, and that's to provide guidance of when acute and chronic hardness-based aquatic life total recoverable aluminum criteria is applicable, and when the acute and chronic numeric aquatic life dissolved aluminum criteria is applicable.
And can you describe the reasoning behind that proposal?
Because there are two types of applicable aquatic life criteria for aluminum, one being the total recoverable hardness-based aluminum criteria for water with a pH between 6.5 and 9, and the other being the numeric criteria for dissolved aluminum outside of that hardness-based pH range. Adding clarification of when the criteria are applicable is critical for proper implementation of the standards.
Did any party object to this?
Not directly. The objections are predominantly associated with the reestablishment of the acute and chronic numeric aquatic life criteria for dissolved aluminum.
What is the department's response to that indirect objection?
It's my understanding, based on EPA's technical support document for the 2017 Triennial Review, that the numeric criteria for dissolved aluminum are already applied for purposes of the Clean Water Act for any waters with a pH outside the range that EPA approved for the hardness-based aquatic life aluminum criteria. So the objection by Triad and DOE is mostly unfounded.
Okay, gonna move you along to, or I should say back to section 900I, and this has to do with aluminum criteria and removing EPA disapproval. Can you describe those proposed amendments?
Yeah, the department is proposing to remove the language in section 900I, which is regarding EPA's disapproval of the hardness-based aquatic life criteria for total recoverable aluminum.
And can you describe the reasoning for that?
Based on the reestablishment of the acute and chronic numeric aquatic life criteria for dissolved aluminum for pH ranges outside of those approved for the hardness base, EPA's disapproval language would no longer be needed.
Did any party object to this?
Not directly. Again, the objections were mostly associated with the reestablishment of the acute and chronic numeric aquatic life criteria for dissolved aluminum.
If the acute and chronic numeric aquatic life criteria for dissolved aluminum in section 900J1 are not reestablished, would the removal of EPA's disapproval be appropriate?
No. The disapproval would be required to remain to direct individuals to EPA's approved standards for New Mexico, which still includes the acute and chronic dissolved aluminum criteria for waters that have a pH outside of the 6.5 to 9 range.
Does keeping the disapproval language change the implementable criteria for either total recoverable or dissolved aluminum as it pertains to the Clean Water Act?
Again, no, because the old numeric criteria, let me clarify. The old numeric aquatic life dissolved aluminum criteria, as initially adopted by the state, was applicable for all pH ranges, and the new hardness-based total recoverable aluminum criteria is limited in its application based on pH. The implementable aluminum criteria, as it pertains to the purposes of the Clean Water Act, still includes acute and chronic dissolved aluminum. So until such a time that the state adopts acceptable hardness-based criteria that can be applied beyond the currently approved pH range or provide reasoning satisfactory to EPA that the hardness-based criteria is protective, that numeric aquatic life dissolved aluminum criteria will remain as the implementable criteria for waters with a pH outside of 6.5 to 9.
Okay, Ms. Fulham, I'm going to move you now to section 900H7. And can you describe the department's proposed amendments to that section regarding the designated aquatic life use for limited aquatic life?
Sure. The department is proposing to consistently reference the term toxic pollutant throughout 20.6.4 NMAC to reduce confusion and aid in implementation. In order to accomplish this, the word toxic was added to the proposed language for the limited aquatic life designated use in section 900 H7.
And can you describe the reasoning for that?
Really is about maintaining consistency with language throughout the standards, which will aid in proper implementation.
Did any party object to this?
No.
Okay, just a couple more questions. In section 900J2, can you describe the department's proposed amendments regarding the reference to persistent toxic pollutant?
Similar to the previous proposed amendment, the department's proposing to consistently reference the term toxic pollutant in order to reduce confusion and aid in implementation. So in order to accomplish this, again, we added the term toxic pollutant to complete the description of persistent toxic pollutants in the abbreviations for the numeric criteria table in section J2D.
And what was the reasoning for that?
Again, maintaining consistency with language throughout the standards aids in proper implementation of the standards.
Was there any objection?
No.
Okay, Mr. Hearing Officer, I have no further questions for this witness on this topic at this time. I would hand it off to my colleague, Ms. Maxfield.
And before you do that, Mr. Verheuvel, I received an email that I asked Ms. Jones to forward to the court reporter, and I'd like to make sure that she has now exhibit number 140.
Let me check. Yes, I do.
Okay. Are there any objections from any party to the admission into evidence of New Mexico Environment Department's exhibit 140?
Mr. Hearing Officer, Lanel doesn't object to the admission. It had a question for Mr. Verheuvel. It looks like the email string he provided in exhibit 140 dates from July 6th. And I think the question originally was whether in Mr. Nelson's letter referred to a request for a preliminary review. Just wanted to make sure that in fact what we have was the complete record of that request. And it looks like since the email string starts July 3rd, 3 days before the letter from Mr. Nelson, I mean, I suppose it could be the initial request, but it doesn't appear to be.
Mr. Verheuvel?
The request that I understood from Mr. Rose earlier today was what was it that elicited the letter from EPA Region 6 that was filed and admitted as NMED Exhibit 139. And so I've provided that email exchange. I guess I would ask Mr. Rose to perhaps frame his query in a different way if there's something else that he's looking for. And perhaps if he could do that in writing.
Mr. Hearing Officer, we certainly will, but my request referenced the letter, and the letter says, in response to your request for preliminary review, what I was asking for is that request. And I thought it was pretty clear at the time that that's what we were looking for, so that this letter could be viewed in context with the request itself. The UAA is an exhibit. What we don't have is the request that accompanied the UAA, if there was one, that was submitted to EPA.
Mr. Verheuvel, are you affirming that the email exchange that you provided that is now exhibit 140 is the document that is referenced in exhibit 139?
I am going to have to check with my witnesses on that, Mr. Hearing Officer. So that's going to have to come during a break or something.
Okay, wonderful. Okay, so actually, Ms. Arguin, we're not going to admit exhibit 140 at this time until we can get some further clarification on it, okay?
Okay.
All right. Ms. Maxfield, are you conducting the examination of the next two witnesses?
The next witness, Mr. Hearing Officer, and so I would like to recall Chris Barrios to the witness stand, the figurative witness stand here. Good afternoon, Mr. Barrios.
Good afternoon.
I'm going to continue to talk to you here about proposed amendments to Section 900. Can you briefly describe the department's proposed amendments to Section 900D regarding primary contact recreational criteria?
Yes, the department proposes to adopt EPA's 2019 numeric criteria for microcysteines and cylindrospermopsin. These are toxins associated with harmful algal blooms for the state's primary contact recreational use.
Could you briefly describe the reasoning behind those proposed amendments?
In accordance with 40 CFR 131.11, which is NMED Exhibit 25, states must adopt those water quality criteria that protect designated uses. States must base numeric criteria on either Clean Water Act Section 304A guidance, 304A guidance modified to reflect site-specific conditions, or other scientifically defensible methods. Adding these criteria for waters for primary contact designated use will enhance protections directly associated with human health.
Did any party object to those amendments?
Yes, the San Juan Water Commission and Ms. Jane DeRose-Bauman's technical testimony filed as SJWC2 requested clarification regarding the interpretation of exceedance counts.
And is it your understanding that the San Juan Water Commission has now withdrawn its objection to this proposed amendment?
Yes.
All right, thank you. Moving on, can you briefly describe NMED's proposed amendments to Section 900I regarding hardness-based metals criteria calculations?
The New Mexico Mining Association and David Gratson's testimony filed as NMMA Exhibit 1.
And Mr. Barrios?
Yes.
I'm just going to interrupt you right there because I asked this question incorrectly. I asked you about NMED's proposed amendments when I meant to ask about the New Mexico Mining Association's proposed amendments. You were answering the question correctly, but I just wanted to note that. Go ahead with your answer.
Thank you. So in MMA, as I said in David Gratson's testimony, proposes amendments to address the treatment of significant figures and the rounding of numeric criteria in Section 900. In MMA proposes that the numeric criteria be limited to 2 or 3 significant figures, and that the addition of a prescription for adjusting numeric criteria to reported laboratory precision.
And can you then briefly describe the department's proposed amendments as a response to the New Mexico Mining Association?
Yes, the department proposed amendments in NMED Exhibit 110 to the hardness-based table values in Section 900I3 to reflect appropriate significant figures, and as well as adding a narrative addition to Section 900I prescribing the treatment of significant figures and rounding for calculated hardness-based criteria.
Can you briefly describe the reasoning behind NMED proposing those amendments?
Yes, the department determined that it is appropriate to report the numeric criteria table values in Section 900I3 at 3 significant figures, given that the precision of 3 significant figures is the maximum resolution available for hardness calculated from dissolved calcium and magnesium reported using EPA method 200.7. The exceptions are hardness-based acute criteria calculated for silver, as that formula includes a conversion factor with only 2 significant figures. The department's proposed updates are consistent with guidance for treating significant figures and rounding provided in the standard methods for the examination of water and wastewater 23rd edition. The department also believes that adding a narrative prescribing mathematical treatment of calculated criteria adds consistency for regulators and the regulated community.
Did any parties comment on the New Mexico Mining Association's proposed amendments?
Yes, CCW GRIP commented in the testimony of James Kuipers, filed as CCW GRIP Exhibit 10.
And after that, did the parties reach an agreement about the proposed amendments to Section 900I relating to significant figures?
Yes, the parties filed a joint stipulation on significant figures on July 13th, 2021 with the Office of Public Facilitation. Based on this stipulation, the parties agreed to the department's proposed amendments to section 900I and 900I3 regarding rounding and significant figures.
Okay, now I'm going to direct your attention to criteria for aluminum. Can you briefly describe the department's actions regarding aluminum criteria?
The department proposes that the commission retain the current hardness-based water quality standard instead of adopting EPA's recommended 2018 acute and chronic aquatic life criteria.
Now, why is the department discussing this topic during the triennial review when it's not proposing an amendment?
As part of the triennial review, and according to 40 CFR 131.20, if a state does not adopt new or revised criteria for parameters for which EPA has published new or updated Clean Water Act Section 304A criteria recommendations, then the state must provide its reasoning when it submits the results of its triennial review to the regional administrator. Adding this topic as a part of the triennial review hearing ensures that the matter is conducted as part of the public record.
Could you briefly describe the reasoning behind the department's position?
As detailed in my direct testimony filed as NMED Exhibit 2, EPA based its recommended criteria, filed as NMED Exhibit 42, on a multiple linear regression, or MLR in short, model that considers the effects of ambient water quality on the bioavailability of aluminum to freshwater aquatic life. The MLR model uses inputs of pH, hardness, and dissolved organic carbon, or DOC, to calculate an instantaneous water quality criterion. However, as described in my direct testimony filed as NMED Exhibit 2, the department cannot effectively implement the MLR model since the department cannot determine the MLR model input value of DOC with confidence.
What are the factors that limit the department's ability to use dissolved organic carbon?
At present, the New Mexico Department of Health Scientific Laboratory Division, or SLD, cannot analyze DOC, and the department does not have the resources for contract laboratory assistance given the volume of samples needed. The department finds that EPA based its recommended ecoregional DOC values, which could be used in place of instantaneous values, on a limited data set that does not capture the variability of observed DOC in New Mexico's water bodies. The use of ecoregional values would likely lead to incorrect assessments.
Is the department taking any actions towards the adoption of EPA's recommended aluminum criteria?
Yes, the department is working with SLD to develop the capacity for DOC analysis. The department expects that DOC analysis will begin later this year. The department is also updating its quality assurance and quality control documentation to allow the collection of DOC and its use in assessments.
Did any parties object to the department's recommendation?
Yes, Mr. DeForest, in oral testimony presented during this hearing, recommended the Commission adopt EPA's 2018 aluminum criteria.
And what's the department's response to Mr. DeForest's testimony?
For the reasons I discussed earlier and are presented in my testimony, direct testimony, the department finds the adoption of EPA's 2018 recommended aluminum criteria for aquatic life is premature.
Is that direct testimony that you referenced filed as NMED Exhibit 2?
Yes, it is.
Okay, I'm now going to turn your attention to EPA's copper, selenium, arsenic, and manganese criteria. And could you please briefly describe the actions regarding that copper, selenium, arsenic, and manganese criteria?
The department proposes that the Commission retain the current water quality standards instead of adopting EPA's recommended criteria for copper, selenium, arsenic, and manganese.
Can you briefly describe the reasoning behind the department's position regarding copper?
Yes. EPA's 2007 recommended copper criterion uses the biotic ligand model, or BLM, to consider the various ambient factors that affect copper bioavailability. Although the BLM provides a more accurate determination of copper bioavailability, than the New Mexico's hardness-based criteria calculation, it requires the input of 10 coincident water quality parameters, some of which are not commonly available, in addition to copper. And these are used to calculate an instantaneous water quality criterion. EPA recognizes that data scarcity is an issue and recommends retaining hardness-based criteria and adopting the BLM standard on a targeted basis where data allow. The department will continue to evaluate the implementation of the BLM for copper on a segment-specific basis.
Did any parties object to the department's recommendation on that topic?
No.
And can you briefly describe the reasoning behind the department's position regarding selenium?
EPA's 2016 recommended selenium criterion incorporates an instantaneous fish tissue criterion, either egg ovary or whole muscle tissue, and a 30-day average water quality criterion. The department is reluctant to invest already constricted resources for collecting fish tissue or 30 consecutive daily water body samples to assess a single site. The department will further evaluate the revised selenium criterion once EPA publishes implementation guidance, which may include methods to translate the 30-day average water quality criterion to alternative assessment periods.
Did any party object to the department's recommendation on that topic?
No.
Can you now please briefly describe the reasoning behind the department's position regarding arsenic?
The state adopted a New Mexico-specific criterion using arsenic water column and fish tissue concentration from the Rio Grande, as detailed in the Statement of Reason from the 2005 Triennial Review, filed as Nmed Exhibit 48. The department reviewed arsenic results from 2010 to 2018 as part of this Triennial Review and found that undeveloped areas in New Mexico frequently exceed EPA's recommended human health criterion. Since human health organism-only criteria cannot be modified for natural background per Section 10E in MAC, adopting the more stringent criterion is not practical.
Did any parties object to the department's recommendation on that topic?
No.
And can you briefly describe the reasoning behind the department's position regarding manganese?
EPA based its recommended human health criterion on manganese's organoleptic effects, including objectionable taste and laundry staining. For application in New Mexico, as defined in Section 7H2, human health organism only, quote, means the health of humans who ingest fish or other organisms from waters that contain pollutants, close quote. Since the EPA criterion does not meet the definition of protecting human health, the department does not support its adoption.
Did any parties object to the department's recommendation on that topic?
No.
All right, Mr. Barrios, I'm now going to turn your attention to numeric criteria. Could you please briefly describe the department's proposed amendments to Section 900J1 regarding numeric criteria?
The department proposes the adoption of recommended EPA criteria in the table of numeric criteria in Section 900J1, the correction of the spelling of several substances, and an update of missing chemical abstract service numbers, or CAS numbers.
Can you briefly describe the reasoning behind those proposed amendments?
Yes, in accordance with 40 CFR 131.20, Nmed Exhibit 21, a state must adopt new or revised criteria for parameters for which EPA has published new or updated Clean Water Act Section 304A criteria recommendations. Otherwise, the state must provide an explanation when it submits its triennial review to the regional administrator. The correct spelling of chemical names and correct CAS numbers ensure that the criteria apply to the appropriate substances.
Did any party object to these proposed amendments?
Yes, the New Mexico Mining Association, in proposed non-technical testimony, objected to the adoption of total iron chronic aquatic life criteria.
Is it your understanding that the New Mexico Mining Association has withdrawn its objection to this proposed amendment?
Yes.
Did any parties comment on these proposed amendments?
Yes, the San Juan Water Commission and Triad DOE provided comments.
What was the substance of the San Juan Water Commission's comment?
The San Juan Water Commission, in testimony filed as SJWC2, that was Mr. Rose Bauman's testimony, requested the addition of the CAS number or analytical reference for tributyltin.
What's the department's response to the San Juan Water Commission's comment?
Objection.
State your objection, please.
Mr. Hearing Officer, Ms. DeRose Bamman addressed this issue only in her written direct testimony. The department provided no response in their rebuttal testimony, and therefore this cannot even, and Ms. DeRose Bamman did not raise it again in her rebuttal. So the department has provided no evidence on this topic.
So, Ms. McCall, let me make sure I understand your objection. Are you saying basically that the department has waived its objection because it did not provide rebuttal testimony to your witness's testimony?
Yes, that is correct.
Okay. All right. And what do you have to say about that, Ms. Maxfield?
Mr. Hearing Officer, I think the department here is responding more than rebutting the San Juan Water Commission's testimony on this topic.
Ms. Maxfield, didn't you have the opportunity to respond to San Juan's witness's direct testimony in your filed rebuttal testimony?
Yes, Mr. Hearing Officer, but this is more just a response to it and a comment on it rather than a rebuttal is how we would characterize that.
I'm going to sustain the objection. If you want to rephrase your question so that it's not a rebuttal sort of answer, then I leave it open to you.
Okay, thank you. In the interest of time, Mr. Hearing Officer, I'm going to move on here. Mr. Barrios, you had also mentioned a minute ago that Triad and DOE commented on this topic as well. Could you describe that, please? What their comment was?
Yes, Triad DOE in Dr. Dale's rebuttal testimony filed as Lanel Exhibit 61 documents outreach conducted with analytical laboratories to determine the capacities and reporting limits for the substances in the department's proposed amendment. Dr. Dale states the 28 compounds have minimum detection levels above EPA's recommended criteria.
And is that the case?
Yes, it is.
Could you explain why TBT does not have just one CAS number?
Yes, in EPA's recommended criteria for TBT, they identify TBT as comprised of various compounds, 4 of which were used in the development of the criterion, the 4 compounds, TBT compounds with toxic criteria that were used in the development of the criterion. Each of those have CAS numbers and they are available in EPA's recommended criteria.
So would it be premature to include them at this point?
They could be included. There would be 4 CAS numbers identified, and those 4 substances do have analytical methods, EPA approved analytical methods associated with them.
Okay, I'm going to turn your attention to NMED's proposed amendments to section 900 regarding the terms irrigation and irrigation storage. Could you please briefly describe the department's proposed amendments on that topic?
Yes, the department proposes correction of the header abbreviation in table in section 900J1 from IRR to IRR/IRR storage, and the replacement of or with and between irrigation and irrigation storage in section 900 J2D.
Could you briefly describe the reasoning behind those proposed amendments?
The table header incorrectly lists irrigation, abbreviated as IRR, only. However, the criteria apply to both uses, and as described in section 900 J2D, the term and is appropriate since the criteria in section 900 J1 apply to both uses.
Did any party object to those proposed amendments?
No.
All right, thank you, Mr. Barrios. Mr. Hearing Officer, I have no additional questions for this witness at this time, and I will turn it back over to Mr. Verheuel to call another NMED witness.
Thank you, Ms. Maxfield. The Environment Department at this time recalls Diana Aranda. And I see you're here, Ms. Aranda. So very briefly, I just have a few questions. Can you describe the department's proposed amendments to section 900I regarding the hardness dependent criteria?
The department proposes to amend the values in the acute and chronic hardness-based metals criteria table to be located in section 900I3 to be consistent with the hardness-dependent equations for acute and chronic aquatic life criteria contained in 900I1 and 2.
Can you describe the reasoning for this?
As part of the triennial review process, the department verified the calculations for the hardness-based table values and found that some calculations were in error. The proposed amendments reflect the corrected values.
So what equation was used for this verification?
For the acute aquatic life criteria for metals, the equation is in 900I1, and for the chronic aquatic life criteria for metals, that one is in 900I2. And these equations have not been changed. So the proposed values reflect the verified accurate calculation.
Did any party object to this?
No.
Okay, I'm going to direct your attention now to section 900K, L, and M. This is regarding the numeric criteria for ammonia. Could you describe those proposed amendments?
These proposed amendments would update the criteria to be consistent with the federal aquatic life ambient water quality criteria for total ammonia, which includes acute and chronic aquatic life criteria for total ammonia nitrogen, also known as TAN.
And what is the reasoning behind these proposed amendments?
So these updates are required by 40 CFR section 131.11, which requires that the states adopt the EPA's recommended criteria based on section 304A of the Clean Water Act.
Did the department receive any comment from the public regarding this proposal?
The department did not receive any public comment regarding this amendment. EPA, however, did make some language recommendations, which we implemented and now are part of the proposal and reflected in NMED Exhibit 110.
Did any party object to these amendments?
No.
Okay, I have no further questions for this witness on this topic at this time. Mr. Hearing Officer, I think our panel is ready to sit for cross-examination.
Agreed. Would any party like to cross-examine the panel of department witnesses on issue number 6, criteria?
Mr. Hearing Officer, I would like to cross-examine if that's appropriate, when appropriate.
It's your opportunity to do so. Are there any other parties besides Mr. Rose? Okay, Mr. Rose.
Thank you, Mr. Hearing Officer. And my question's directed at Ms. Fulham, but any of the panelists can answer as appropriate. In regards to Ms. Fulham's testimony here, as I understood it, you said that when the commission adopted the 1988 aluminum criteria, that it intended to not just adopt EPA's criteria, but also extend it to pH ranges beyond that which the EPA recommended criteria applied to. Did I understand that testimony correctly?
I'm going to phrase it instead of just saying yes or no, just to caveat what I think you said. When it was originally adopted, the state did adopt a modified version of EPA's 1988 aluminum criteria. The 88 criteria has a pH range boundary, whereas the states did not. And that adopted criteria was approved by EPA and has been implemented up until the point we had the hardness-based criteria.
And the question I was going to ask you was, what documents did you review in reaching that opinion?
When we do standards amendments, we do look back to NMAC as far as, especially given COVID, as far as back as we have records. And so I think I went back to at least 1991, which would have aligned with the 1988 aluminum criteria guidance.
And could you identify what specific documents you believe or that you relied on to reach your conclusion?
This is probably a conclusion that came from EPA more so than myself, when EPA disapproved the full range of pH for the hardness-based aluminum criteria.
Did you find in your review of the records the commission's adoption of the 88 criteria and the submittal of that adoption to EPA for approval? Are there any documents still left that the department could review in reaching that, evaluating what the commission's intention was back when they adopted the criteria?
I did not.
Okay. And then I thought I heard you testify, and correct me if I'm wrong, that EPA has applied the dissolved criteria outside of pH ranges 6.5 to 9. Did I understand your testimony correctly?
Their statement has been that they would apply the dissolved aluminum criteria for any waters outside that pH range and for purposes of the Clean Water Act, correct?
And do you know whether in fact they have applied those, the dissolved criteria in New Mexico outside of those ranges?
No, I do not.
And with respect to EPA's advice to you that they would, is that in writing anywhere or is that just an oral communication?
EPA has it on their website for what the applicable water quality criteria are. And that has been reiterated several times in writing from EPA as well.
Okay, thank you, Ms. Fulham. That concludes my question.
It seems that we have a member of the public that wants to cross-examine one of the witnesses. Let me figure out which member of the public it is first. Ms. Jones?
Mr. or actually R. Nelson, you're still on.
Mr. Hearing Officer, I'm Russell
Yes, sir.
Nelson. I'm the Regional Water Quality Standards Coordinator at EPA Region 6.
Okay, and are you asking a question within the subject matter of one of these witnesses today?
Yes, sir.
Okay, which witness is this question directed at?
I'd like to direct the question to Ms. Fulham.
Ms. Fulham, okay. What is your question, sir?
Ms. Fulham, in the history of our work in the preliminary activity in revising state water quality standards, is it typical that that the department request informal comments on use attainability analysis and other supporting documents well in advance of these hearings?
Yes, it is.
Then with that, would it be unusual that that given EPA's workload, at times EPA cannot respond in a timely manner?
Yes, that would be true.
Thank you. That concludes my question, Mr. Hearing Officer.
Mr. Nelson, would you state your full name for me again, please?
Russell Nelson.
Thank you.
And Mr. Nelson, before you go, are you the author of the letter that was the subject of Exhibit 139?
Yes, I am.
Okay. Okay, thank you, Mr. Nelson. Do any of the parties have a follow-up question to Mr. Nelson's question? Okay. I see a commissioner who would like to ask a cross-examination question of the department's witnesses.
Yes, this is Commissioner Thompson.
Please.
This is a question for Mr. Barrios, and it involves significant figures. So I understand that you and some of the participants, I believe it was the New Mexico Mining Association, agreed that you would report the standards to 3 significant figures. Is that correct?
Commissioner Thompson, that is correct for calculated criteria based on the hardness-based criteria calculations.
Yes.
Excuse me, Mr. Barrios, your audio is very low.
How about that?
Much better, thank you.
Okay, apologize. Do I need to repeat the answer?
Might be a good idea.
Okay. Yes, we agreed that an update to the significant figures would be advisable for the hardness-based calculated criteria.
Right. And that was based in part on the precision that is suggested in standard methods for the examination of water and wastewater?
There is a section that's provided as an exhibit. I would have to go look it up again, but I believe it is just 1 page or 2 pages from the latest edition of the standard methods that describes the appropriate treatment of significant figures and rounding.
Yes, I'm quite familiar with it. However, so that standard methods refers to analytical methods, water samples which are submitted to a laboratory and analyzed in the laboratory. The Environment Department provided a number of documents. I think most of them were EPA documents describing how the standards were developed for aquatic organisms. And some of them had hundreds of references. So my question is, if you took the results of those hundreds of different studies, would you also come up with an aquatic life criteria, a standard for aquatic life with the same level of precision, 3 significant figures?
No.
I agree. And so I think using 3 significant figures in a water quality standard implies a level of precision that is not justified by the scientific information. Thank you, Mr. Hearing Officer. I have no further questions.
Thank you, Commissioner Thompson. Are there any other commissioners with cross-examination questions for these witnesses?
This is Commissioner Patton. I've just got a couple questions.
Yes, Commissioner Patton, please proceed.
So I'm looking at 900K, I believe, which is, I guess, set to be deleted and then replaced with a different table later on. And the deleted version talks about the presence or absence of salmonids. And then the new tables have the caption that says when Oncorhynchus species are present or absent. Why did the department move away from salmonids, which would include all trout in the state, and just limit it to Oncorhynchus, which are cutthroat and rainbow trout?
Yes, Commissioner Patton, thank you for the question. The new criteria did not include those species and were not included in the studies. I mean, they were included, but the range of species was for the most sensitive species, and it just did not include those salmonoids. And I tried to contact EPA regarding just keeping the salmonoids that we had in the past, but I did not get a response. And so therefore, I didn't want to include a species that was not appropriate to the new criteria, if I'm explaining myself.
Okay.
It just didn't get that sensitivity that the studies had.
Okay, thank you.
Are there any other commissioners? Are there any members of the public? Ms. Maxfield or Mr. Verheuel, are there any redirect questions for these witnesses before we excuse them?
I have a single redirect question for Ms. Fulham. Ms. Fulham, are you aware of whether or not prior or historical?
No, those are clean.
I'm sorry? Okay. Ms. Fulham, are you aware of whether or not prior or historical versions of the New Mexico Administrative Code would indicate whether or not there was a pH restriction for the dissolved aluminum criteria?
My review of former NMAX does not provide a pH restriction in any of the versions that I've looked at. So unless there was a pH restriction, that would be the only time you would see it.
Okay, thank you. No further redirect questions.
Okay, continuing on topic 6, criteria. Does Amigos Bravos have, it looks like Amigos Bravos, Mr. Rose, do you have any witnesses you are presenting?
Yes, Mr. Hearing Officer, we have 2 witnesses who hopefully their combined testimony here will take less than 10 minutes, and we'll put them up for cross-examination as a panel.
And is that Dr. Toll and Mr. Meyerhoff?
No, it's Dr. Toll and Dr. Dale.
Oh, okay. I also have Mr. Meyerhoff listed here as well.
Under topic 6, no. For topic 7, he's on, and he was on for topic 5.
Okay, so Dr. Dale and Dr. Toll. Okay, and are they going to stand as a panel for cross-exam?
Yes. Yes.
Okay, thank you. Please proceed.
Dr. Toll, could you please summarize your direct and rebuttal testimony?
I only had rebuttal testimony on this, and it was pertaining to the copper criteria issue. And commissioners and Mr. Hearing Officer, it's nice to go out. This is my last time on the stand. It's nice to go out with good news, and that is that LANL is not opposed to EPA's adoption of, or not adopting the 2007 recommended aquatic life copper criteria statewide. But that's in the context of Mr. Barrios's full testimony, and so I wanted to highlight that it was based upon other elements of his testimony, specifically that the department is looking at applying the criteria on a site-specific basis, and we have been working for a long time with Nmed on this issue. We've been collecting data since 2005. We have a database from 2005 to 2019 from 8 different canyons and something on the order of 500 samples that we've used to develop site-specific copper criteria using the EPA 2007 recommended water quality criteria method. We've produced a work plan for a demonstration report for that and a demonstration report. One correction to my rebuttal testimony is that the rebuttal testimony says that the demonstration report has been delivered to EPA and NMED, and in fact it's imminent, but it wasn't delivered before the hearing. But they both had the opportunity to review the work plan, which was not a requirement, but we produced one. And they'll both have the opportunity to review the demonstration report, and we're looking forward to going into a public involvement process. We've actually started with that, and we're planning on petitioning for a hearing sometime in the not too distant future on this issue of site-specific copper criteria.
Thank you. Dr. Toll, does that complete your?
It does.
Dr. Dale, could you sort of move into the camera here?
Sure.
Do you have any, do you need to, or would you like to summarize your rebuttal testimony on this topic?
I can do so briefly. My rebuttal in topic number 5, subpart 900 criteria adoption. I'd like to acknowledge Chris Barrios's testimony, NMED exhibit number 2, as a welcome feature of explaining non-adoption or adoption of criteria that was, I think, absent in prior triennial reviews, at least as far as I can recall. So in the interest of transparency, we'd certainly like to encourage early and often discussions with the regulated community such that we can address questions that I mentioned in my rebuttal regarding ability for us to be able to measure new low-level organic toxics. I think this is a subject matter that addresses both our ability and also the states through their scientific laboratory division. Thank you.
I have no further questions, Mr. Hearing Officer, and would make both Dr. Toll and Dr. Dale available for cross-examination.
Are there any parties that wish to do so? Are there any commissioners that wish to do so? Are there any members of the public? Well, thank you, Dr. Toll, for your testifying.
You're welcome.
Thank you, Mr. Hearing.
Mr. Hearing.
Thank you, Mr. Hearing Officer. That completes Lannel's presentation on topic number 6.
And it looks like we move to Amigos Bravos, but I see, and maybe I'm not reading this right, Miss Fox, was Dr. Khan offered for rebuttal only on 5 or also on 6?
On 5 and 7, Mr. Hearing Officer.
Okay, so you have no witnesses for 6.
Correct, thank you.
Oh, thank you. San Juan?
Thank you, Mr. Hearing Officer. San Juan Water Commission calls Ms. Jane DeRose Bamman. Ms. DeRose Bamman, could you please summarize the San Juan Water Commission's objection to the department's proposal to add numeric criteria to the table of use-specific numeric criteria at 20.6.4.900 J1 NMAC?
Yes, the department proposes to add numerous numeric criteria for acute and chronic aquatic life pollutants. One of those pollutants is tributyltin. This will be the first time numeric criteria for a tributyltin has been contained in the water quality standards. The table at 900J1 NMAC has a column for the chemical abstract system, or CAS number, and that number is very helpful, useful for permittees or anyone who's trying to collect information about that, to make sure that they can name the variations for chemical substances and that the correct analytical methods are requested for compliance with the water quality criteria. And so permittees need to know that in order to monitor appropriately. So for tributyltin, however, NMED has only specified various for the CAS number. And so the lack of that number creates uncertainty about which analyses need to be run to determine compliance with a particular water quality criterion. So SJWC therefore request that NMED provide a specific CAS number for tributyltin or provide more information about which analytical method would be needed to be used to ensure compliance.
And in its written or direct rebuttal testimony, did the department provide any information addressing San Juan Water Commission's concerns?
No, I wasn't able to find any response to San Juan Water Commission's concern in the rebuttal testimony filed by the department.
And therefore, what is the position of San Juan Water Commission?
So San Juan Water Commission's request that the commission reject the proposed designation of numeric criteria for tributyltin until it specifies the appropriate CAS number.
Do you have any further testimony you would like to give on this topic?
No, this concludes my testimony on this topic.
Thank you. Mr. Hearing Officer, I have no further questions.
Are there any parties that would like to cross-examine this witness? Ms. Maxfield?
Thank you, Mr. Hearing Officer. Briefly, Mr. Osbaman, is there a single CAS number for tributylin?
No, there isn't. But since there are multiple parameters that could be covered under that, but only a subset of those were used to develop the criterion, I think it's important to identify which ones would be necessary for compliance purposes.
Would you like multiple CAS numbers in the table? Is that what you're proposing?
Whatever is appropriate to prove compliance with the criterion.
What would those CAS numbers be if we provided multiple ones in the table?
I don't have them right now. I mean, certainly we could work together to figure that out, but that's not part of the hearing record at this point, so I don't have that information.
All right, thank you. I have no further questions.
Are there any other parties that wish to cross-examine this witness? Are there any commissioners that would like to cross-examine this witness? Or members of the public? Ms. McCaleb, is there a redirect on that one question that Ms. Maxfield asked?
No, sir, I have none.
Okay. Is that your only witness on this topic?
Yes, sir. San Juan Water Commission has no other witness on this topic.
Okay, let me look at something here. I see a witness named.
I think this is the only issue that the New Mexico Mining Association has a witness on, and I think we are the only remaining party to this issue.
Is the witness named Gratson?
He is.
Marvelous. And I don't think he's under oath, is he?
No, he's on the call.
No. Has he been sworn in?
Oh, no, he is not under oath. Sorry, I misheard.
I don't see him. Do you see him?
I think he is the blurry background.
Yeah, I apologize. I'm trying to, suddenly it was working earlier. See if this works. Well, I apologize.
Mr. Gratson, while you're working on your video, Mr. DeSalen, are there any witnesses from CCW on this topic?
No, Mr. Hearing Officer, not on this topic.
I just want to make sure we're not missing anyone. Okay, Mr. Gratson, we can see you, so you're going to be sworn in and then you'll give your testimony.
Very good.
Would you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Good afternoon, Mr. Gratson.
Good afternoon.
Will you please state your name for the record?
My name is David Gratson.
And what is your current employment position?
I'm a senior technical chemist with Environmental Standards Incorporated.
Can you please describe your educational and professional qualifications?
Sure, I have a Bachelor's of Science degree in biology from Allegheny College and a Master's of Science degree in Environmental Science and Engineering from the Colorado School of Mines. Since 2004, I've been a certified environmental analytical chemist with the National Registry of Certified Chemists. I provide technical chemistry and environmental data quality consulting, done so for more than 20 years. Prior to entering the consulting field, I worked in environmental laboratories, including those at the U.S. Department of Energy and National Aeronautics and Space Administration.
Thank you, Mr. Gratson. A copy of your resume has been provided as New Mexico Mining Association Exhibit 2. Is that correct?
That is correct.
And you have submitted pre-filed direct written technical testimony in this proceeding, which has been provided as New Mexico Mining Association Exhibit 1. Is that correct?
Yes, that is correct.
Do you have any changes to your direct pre-filed written testimony?
No, I do not.
Thank you, Mr. Gratson. Do you adopt your pre-filed direct written testimony here today?
I do. Yes.
Thank you. For the record, I'd just like to note that these exhibits have already been admitted into evidence at the beginning of the hearing. Mr. Gratson, what is the general purpose of your direct written testimony in this proceeding?
So that the general purpose of my pre-filed direct written testimony is regarding the significant figures or numerical limits as set forth in 20.6.4.900 NMAC of NMED's proposed rules as reflected in NMED Exhibit 9. Numeric criteria and standards for interstate and intrastate waters are in most cases noted to contain 3 or fewer significant figures. Numeric criteria at or above 1,000 milligrams or micrograms per liter are shown with no more than 2 non-zero digits until the standards employ accounting for water quality parameters such as alkalinity, hardness, and dissolved organic carbon. Use of more than 3 significant figures is noted starting in 900 NMAC, specifically in 900 NMAC I, where hardness-dependent criteria for metals in the proposed tables of numeric criteria exceed 3 significant figures. In 900 I3 NMAC, the table contains selected values of calculated acute and chronic criteria in units of micrograms per liter. Many of these with more than 3 significant figures. Manganese is an example where basically all the criteria for manganese contain more than 3 significant figures. These values are calculated based on the equations provided in 900 I1 and 900 I2 NMAC, where the factors have up to 5 significant figures. Some of these additional digits were carried through the calculation.
Excuse me, we cannot hear you. You're still on mute.
I think you're still mute, Christina.
I guess it automatically mutes you. I apologize. Do you have any concerns or issues with the use of more than 3 significant figures for the numerical limits as originally set forth in NMED Exhibit 9?
And excuse me 1 second. Ms. Sheehan, there is background when you are not muted. So if you would mute, that would help when the witness is speaking.
Absolutely.
Thank you.
I do. Commercial analytical laboratories that perform the measurements of constituents found in this table have prescriptive reporting requirements that define the number of significant figures to be reported with each parameter. Most commercial laboratories limit the significant figures to either 2 or 3 values. Using 3 significant figures adds more than 3 significant figures adds uncertainty to the reported values. The New Mexico Mining Association is concerned the use of more than 3 significant figures in the standards will result in the inability to compare laboratory reported data with the numeric criteria.
Mr. Gratson, have you reviewed Chris Barria's written rebuttal testimony, which is labeled NMED Exhibit 110?
Yes, I have.
And do you have any rebuttal to this testimony?
I do.
Do NMED's changes to 20.6.4.900 NMAC as set forth in NMED Exhibit 10 address the concerns raised in your direct written testimony?
Yes, they do.
And why is that?
Essentially, they have addressed both of my concerns and comments. They reduced the number of significant figures in 900I3 to no more than 3 significant figures. And they provided a appropriate reference for an equation to round significant figures is the standard methods that was discussed earlier.
Thank you, Mr. Wilson. Just to clarify, you are in agreement with NMED's proposed revisions to clarify the issues you raised regarding 20.6.4.900 NMAC as presented in NMED Exhibit 110.
Yes, I am.
Mr. Gratson, would you recommend that the Commission adopt NMED's proposed revisions to 20.6.4.900 NMAC as set forth in NMED Exhibit 110?
Yes, I do.
Thank you. Does that conclude your testimony at this hearing?
Yes, it does.
Thank you. Mr. Hearing Officer, the New Mexico Mining Association tenders this witness for cross-examination at this point in time.
Are there any parties that wish to do so? Are there any commissioners that wish to do so? Are there any members of the public? Mr. Gratson, thanks for your testimony.
Thank you.
Ms. Sheehan, is that the last witness that you have for this proceeding?
It is.
Okay, all right. All right, thank you for that clarification. I think we are done with topic 6. Does any party disagree with that assessment? Then I think let's deal with the question revolving around Exhibit 140, which is not in evidence. Mr. Rose, I'm not sure if that witness was speaking to your objection over the evidence, but where are we with the evidence now?
If I could interject, Mr. Hearing Officer, in the ensuing time, since Mr. Rose and I discussed this in front of everyone, my witness has provided me with an earlier email, which I will mark and circulate shortly to all the parties.
So that will be Exhibit 140?
It will be 141 to avoid any confusion, but I understand that 140, whether it's accepted or not, it perhaps completes the record. However, I don't know that that's what Mr. Rose was looking for.
Mr. Hearing Officer, we'll have to look at what Mr. Verheul has found. 140 wasn't what I was looking for, but we have no objections to its admission, if that's a question. So,
well, it's not in evidence, so I guess what I'm trying to do is keep this clean. So in my my request is either to mark it as amended 140 or as 140. So what do you prefer, Mr. Verheul?
Well, I'm going to have to remark it either way. So I suppose I will do it just as 140.
Okay, wonderful.
Okay.
Okay, and Mr. Verheul, it looks like we're on exhibit or issue 7 now. Are you ready to proceed with your witness, Fulham?
I could, Mr. Hearing Officer. However, well, first, Mr. DeSalen appears to have a question.
Thank you, Mr. Verheul. Thank you, Mr. Hearing Officer. I was wondering if this would be a good time for us to put on our last witness, Ms. Sanchez.
It may be. Let me get an answer to, let me see what Mr. Verheul was about to say about having one witness for number 7. Is that not correct?
Well, we are prepared to put on our witness for topic 7. However, the department feels that there's a much better chance that we could get through the entirety of topic 8 were we to move to topic 8. Topic 7 being land all waters, rather than perhaps doing some testimony on that today and then some testimony at some future date, maybe we want to keep that all together.
I understand. Are there any
Yes, there is a strenuous objection by Lanel. We believe that all of our witnesses, and we have 3, can present well within the time frame that the hearing officer has specified. This is the most important issue to Lanel. And topic 8 is grammatical corrections and typos. So we would strongly request that the hearing officer permit the topic 7 to go forward. And in fact, Mr. DeSalen, apologies in advance, but we would like to see topic 7 go forward as the next topic. And we believe we would still provide ample time for Mr. DeSalen's witness to occur after that.
Okay, so let me understand what Mr. Verheul was suggesting. Mr. Verheul, I understand that you believe that topic 8 is an easy one, and we would easily get through that today. In light of Ms. McIntosh's assertion that their witnesses on topic 7 would be timely concluded, what is your concern at this point?
Well, as long as her remarks regarding getting through topic 7 also include all cross-examination of witnesses, as long as she's including that, if she believes that we can get through topic 7, which, as she's already indicated, is a very important topic to her client and is quite contentious, I don't challenge that assertion if she wants to move ahead with it.
Okay, thank you, sir. Mr. DeSalen, what sort of a time frame are we looking for your witness Sanchez?
Approximately 15 minutes, Mr. Hearing Officer.
Let's take Miss. Is it Miss or Mr. Sanchez?
Ms.
Sanchez. Let's take Miss Sanchez now, and so we're done with Miss Sanchez.
Thank you, Mr. Hearing Officer. Communities for Clean Water and Gila Resources Information Project now call Ms. Kathy Juanpovi Sanchez.
And is she under oath, sir?
She is not.
Court reporter?
I do not see her.
I don't either.
Kathy? I know she was here earlier. It shows that she's here on the screen.
Shall we take a 5-minute break?
I think that would be helpful, Mr. Hearing Officer. Thank you.
You're welcome. Let's take a 5-minute break and go off the record until 2:51, and then we will move on to Los Alamos witnesses in issue number 7. Thank you. We are back on the record. It is 2:51 on the 16th of July. We are in topic 7. However, we have agreed to take Ms. Sanchez out of order for CCW. And have you found your witness? And we can't hear you, sir.
She's having internet connection problems, Mr. Hearing Officer.
Okay. We will.
I apologize.
Mr. DeSalen, not to worry, sir. We will make sure to get her today. Okay?
Thank you.
Don't stress. Don't stress, but we're going to go to Lanel now. We're going to let them put on their 3 witnesses for topic 7. So Ms. McIntosh, are you presenting?
Mr. Hearing Officer, Ms. McIntosh will be presenting, but I believe that NMED has 1 witness on this topic and they would present first.
Okay.
Excuse me, who is speaking?
Maxine McReynolds is speaking.
Thank you.
Okay, Mr. Verheul, are you presenting?
I am. The department recalls Ms. Jennifer Fulham, and Ms. Fulham has been sworn in. Ms. Fulham, can you briefly describe Triad and DOE's proposed amendments to segment 126?
Sure. Triad and DOE's proposed amendments consist of adding language to section 126 to classify all perennial waters within them.
And what is your understanding of the reasoning behind those proposals?
Triad and DOE assert that all perennial waters should be classified in section 126.
Did the department originally propose something to this effect?
Yes. In the department's petition in this matter, we did initially propose to include perennial portions of DP Canyon, Lower Ancho Canyon, from the Rio Grande to Ancho Spring, and then perennial portions of Water Canyon into section 126.
When our petition was initially filed in August of 2020, did the department believe it was going to evaluate designated uses for perennial waters within LANL?
Yes. The intent was to conduct an analysis on these waters. However, given the time constraints and limited resources available to amend the designated recreational use from secondary contact to primary contact through the development of a UAA, the department ended up having to redirect resources to ensure the obligations of the joint stipulation regarding proposed changes to section 128 were able to be fulfilled first.
So the joint stipulation you just referenced, and we've talked about it before, it's NMED Exhibit 72. Does it discuss perennial waters at all?
No, the joint stipulation only discusses work towards determining the appropriate designated uses for the non-perennial waters classified in section 128.
Why do you believe that Triad and DOE are proposing this amendment now that the department has rescinded its proposal?
Triad and DOE have expressed that they want all perennial waters within LANL to be classified.
And what is the definition of a classified water?
A classified water, as defined in section 7C3, means a surface water of the state or a reach of a surface water of the state for which the commission has adopted a segment description somewhere in sections 101 to 899.
And what is an unclassified water then?
Was currently described in section 11H, unclassified waters are those surface waters of the state not identified in sections 101 through 899. And these waters are presumed to support the uses of section 101A2 of the Federal Clean Water Act, as they're subject to the designated uses in segment 99 if perennial and segment 98 if they're non-perennial.
And what is the description of the classified waters in segment 126?
Was already read by Dr. Meyerhoff this morning. The waters in section 126 include perennial portions of Canyon de Valle, Sandia Canyon, Pajarito Canyon, and Water Canyon.
Are other perennial waters within LANL classified in segment 126?
No.
What is the description of classified waters in segment 128?
Section 128 only describes certain ephemeral and intermittent waters within LANL.
Are any perennial waters within LANL classified in segment 128?
No, the plain language of section 128 is limited to only ephemeral and intermittent waters within LANL.
Are any other waters within LANL described elsewhere in sections 101 through 899?
No, the only place waters within LANL are described at present are in sections 126 and 128.
And when were these waters that are within LANL, when were those classified?
Those waters were classified through rulemaking in 2005.
Were all the waters within LANL classified at that time?
No.
Did the evidence that supported this 2005 rulemaking include surveys demonstrating that there were or were not other perennial waters?
Not to my knowledge. The evidence appeared to be based on best professional judgment at the time.
So are all the waters within LANL now classified?
No, based on the hydrology protocol surveys conducted between 2016 and 2019 within LANL, there's several perennial waters within LANL that are not currently classified.
What happens when a water that was previously believed to be classified, but then is later determined not to be classified?
Well, as described earlier, in accordance with section 11H, an unclassified surface water of the state is subject to section 99 if it's perennial and section 98 if it's non-perennial.
Even if it was previously thought to be classified?
Yeah, yes. Even if it was previously thought to be classified, per the definition in section 7C3, if it is not described in sections 101 through 899, then it's not a classified water.
Is this considered changing a designated use?
No, because the descriptions in the classified sections in 20.6.4 NMAC do not provide for the water to be classified, there's no moving or changing of a designated use.
Is there a process for this?
Yes, the description of how this is determined and applied is actually detailed in the water quality standard section of the state's approved water quality management plan and continuing planning process, or WQMP CPP. The WQMP CPP is a state document and it's required by 40 CFR 130.5 and 130.6, and it's approved by both this commission and by EPA. And we filed the sections of it relevant to this proceeding as Nmed Exhibit 64.
So how does the WQMP CPP address this?
Well, for this scenario, the process is described in section 2, page 6. And these determinations do not require a UAA or a hearing because they do not change the designated uses or criteria, but merely allow for the applicable uses to be properly identified. This process is also illustrated in the flow chart in section 2, page 8. And I believe Lionel referred to the flow chart as an example in his testimony this morning.
Has this type of action been applied before?
Yes.
Where?
Doggett Creek is one example. The department did not assess this tributary until a discharge permit renewal application was submitted. And at that time, it was determined that Doggett Creek was not described in any of the classified sections. So Doggett Creek was assessed thereafter with the designated uses in section 99. Just recently, though, Doggett Creek was classified in section 318 to accommodate for a temporary standard. Now, once that temporary standard expires, Doggett Creek will remain a classified water of the state since now it's described in sections 101 through 899. Another example is Dry Blue Creek. It was thought to be a classified water in section 603 until the department realized it was not a tributary of the San Francisco, and this water is now therefore unclassified and protected under the designated uses in section 99.
Are there other ways to classify these unclassified perennial waters?
Not really, unless the designated uses are the same, but that would still require rulemaking to incorporate the language to describe it somewhere in section 101 to 899. So for those waters which are designated, which the designated use would be amended, there's essentially 3 mechanisms to amend a designated use, and all of them require some kind of demonstration that the use is appropriate. For a use that's a Clean Water Act section 101A2 use, and it's proposed to be amended to a use with less stringent criteria, a UAA is the only mechanism available.
Are there protections for these unclassified perennial waters within LANL?
Yes, as defined in section 11H, unclassified perennial waters have the protections in section 99.
What are the designated uses in section 99?
There's warm water aquatic life, livestock watering, wildlife habitat, and primary contact.
And what are the designated uses in section 126?
That has cold water aquatic life, livestock watering, wildlife habitat, and secondary contact.
So what are the differences in designated uses between section 99 and section 126?
The aquatic life use in section 126 has more stringent criteria than section 99. Both have livestock watering and wildlife habitat uses, so those are equivalent. And the recreational use for section 126 has criteria which is less stringent than section 99.
Can designated uses or criteria be amended without a demonstration, whether it be to one with more stringent criteria or less stringent criteria?
No, although the demonstration to amend a designated use with more stringent criteria does not have to meet all the requirements in 40 CFR 131.10G, like a designated use amendment with less stringent criteria does. EPA and the Commission must have some basis for adopting the use, so a demonstration of some kind would be needed in either case.
Does the department believe that the aquatic life use in section 99 is the highest attainable use?
Based on the conclusions from the Luskin-McRae study, which we filed as NMED Exhibit 135, it's likely that these waters have an existing aquatic life use with more stringent criteria than the warm water aquatic life use in section 99.
And so then what would be needed in order to amend the designated use from warm water to cold water as found in section 126?
Well, in accordance with either 40 CFR 131.20 or 40 CFR 131.10I, a demonstration which presents information of why the designated use is believed to attain a designated use with more stringent criteria, or a study likely similar to the one done for waters with secondary contact being proposed in this triennial, would be needed. Basically, something that demonstrates the amendment to the designated use is warranted and what information that determination was based on. So the Commission and EPA have something to base their decision on.
Okay, so if the aquatic life use in section 126 has more stringent criteria than in section 99, would a UAA still be required to classify these perennial waters in section 126?
Yes, because not because of the aquatic life use. A UAA is required because the recreational use in section 126 is secondary contact with less stringent criteria, whereas section 99 has primary contact with more stringent criteria. Per section 15, the Commission can adopt subcategories of a use requiring less stringent criteria only if a UAA demonstrates that attaining the use with more stringent criteria is not feasible based on one of the factors in 40 CFR 131.10G.
What if the water quality meets the primary contact criteria, but there is no evidence the water is being used for primary contact? Is the existing recreational use still required to be protected?
Yes, as expressed in the Smithy Letter, if water quality is sufficient to support the use is attained, the use must be protected, even if it's not currently being used in that manner. So although primary contact through swimming may be limited due to volume or access issues, it's not impractical or outside the protective obligations of the state to ensure water quality is sufficient for primary contact. Primary contact is not limited to just swimming, but it covers activities that would provide for prolonged and intimate contact with the water, including those associated with cultural, religious, or ceremonial purposes. So unless it can be demonstrated that primary contact is not an existing use and it's not attainable due to one of the 6 factors in 40 CFR 131.10G, the designated recreational primary contact use is the appropriate and applicable use.
Has a UAA been developed to support LANL's proposed amendment?
Not to my knowledge. Even if a UAA was developed by some party other than the department, that party would have to submit a work plan for the department's review and approval before developing the UAA.
If the recreational designated uses for unclassified perennial waters can't be amended without a UAA, and a UAA has not been developed, can the department support the amendments to include all perennial waters in section 126 as proposed by LANL?
No.
What has EPA said in regard to amending designated uses for these waters?
As provided in comments to the draft amendments, which was NMED Exhibit 88, EPA states that because these unclassified perennial waters have not been previously described in a regulatory section, they are unclassified and a UAA would be required to establish secondary contact as the recreational use.
Does the department agree with EPA?
Yes.
Does the department believe more work is necessary in order to determine the appropriate designated uses to adequately protect the unclassified perennial waters within LANL?
Yes.
And is any of that work mature enough at this time to present to the Commission as part of this triennial review?
Fortunately, no.
Okay, want to shift gears here for a second to section 140. Can you briefly describe the department's proposed amendments to section 140?
The department's proposing to amend the aquatic life designated use from limited aquatic life to marginal warm water aquatic life for portions of 3 intermittent tributaries within Llano. And these include Effluent Canyon from its confluence with Mortendad to its headwaters, S-Site Canyon from Llano's monitoring well MSC 1606293 to Martin Spring, and 2 Mile Canyon from its confluence with Pajarito Canyon to its confluence with Upper 2 Mile Canyon.
And can you describe the reasoning for those proposed amendments?
Hydrology protocol surveys were conducted pursuant to the joint stipulation regarding proposed changes to section 128. The proposed amendments were prepared in accordance with 40 CFR 131.10I and 20.6.4.10B and MAC. The demonstration supporting the proposed amendment was filed as Nmed Exhibit 73, and then a revised version was filed as Nmed Exhibit 124.
Any party object to those amendments?
Yes.
What were the bases for those objections?
There were 2 objections. The first is based predominantly on process, not the proposed amendment itself. And this objection was brought forward by Triad and DOE and San Juan Water Commission. The second objection brought forward by Triad and DOE, in which they present new data that was not previously provided or evaluated, but is being presented to demonstrate that Effluent Canyon is not attaining the dissolved oxygen and pH criteria for marginal warm water. Triad and DOE also object to the terminus for the reach of 2 Mile Canyon. The department has testified it would be at the confluence with Pajarito Canyon, while Triad and DOE assert the terminus to be at the gauge where the hydrology protocol survey took place.
Were these concerns addressed in your direct or rebuttal testimony?
The reasoning behind the process and the terminus for the reach for 2 Mile Canyon was discussed in both my direct and rebuttal testimony. However, the information being presented on Effluent Canyon was just provided in Triad and DOE's rebuttal, so I was unable to respond in direct or rebuttal testimony.
And what new data did Triad and DOE present in rebuttal testimony?
Triad and DOE present water quality data for Effluent Canyon. It is Triad and DOE's argument that this water quality data demonstrates the water quality as it pertains to dissolved oxygen and pH are outside the criteria range for marginal warm water aquatic life, and therefore negate the department's assertion that Effluent Canyon is able to support the marginal warm water aquatic life use.
Why didn't the department include or address this water quality data for Effluent Canyon?
The supplemental data provided by Triad and DOE in the rebuttal testimony were not provided to us until that time. The data that the department relied upon were independently extracted from the Intellis database based on several potential queries. Without the knowledge of where the data resided or the exact query that would have produced them, the department inadvertently overlooked the available data to use in the analysis.
And would this data have been valuable for determining the existing uses for Effluent Canyon?
As with all the chemistry data that was used in the analysis, the information would have been used as supplemental information supporting the presence of water. The fact that there was water sufficient to sample supported the findings of the hydrology protocol surveys, which demonstrate that at least chronic protections for aquatic life are warranted based on persistent exposure. So although it would have been helpful, it was not the determining factor in and of itself. The water quality really indicates the level of contamination that may be occurring, especially if it's adjacent to a tributary that is able to meet the criteria.
Are there sources of contamination for Effluent Canyon that may be affecting the water quality?
Well, as demonstrated in the existing use analysis, because the water quality in Mortendad Canyon is able to meet the criteria for the marginal warm water aquatic life use, the department finds it difficult not to consider anthropogenic sources for the degraded water quality in Effluent Canyon.
Does the fact that flow in Effluent Canyon is offset with permitted discharges affect what the appropriate designated use should be?
Not really. It's true that a designated use may be amended if it's not an existing use, if it can be demonstrated that low flow conditions prevent attainment, so long as these conditions are unable to be offset by permitted discharges. And given the water quality can be attained through enforceable measures, the demonstration that flows in Effluent Canyon are not meeting the criteria for marginal warm water would not prevent the designated use from being marginal warm water. This tributary was found to be intermittent in nature, supporting the reasoning that persistent exposure is probable for aquatic life. This suggests at the very least the marginal warm water aquatic life use is appropriate.
For Effluent Canyon, I'm sorry? Okay. For Effluent Canyon, does the new data presented negate the findings of the hydrology protocol survey?
No, the water quality data for this analysis was really evaluated as supplemental evidence, not the primary line of evidence. This tributary was found to be supporting an intermittent hydrologic regime, which supports the reasoning that persistent exposure is probable for aquatic life. Given that the limited aquatic life has limited protections for chronic exposure and marginal warm water is the designated use with the least stringent criteria that protects for chronic exposures, the findings from the department's existing use analysis are still applicable. At a minimum, marginal warm water aquatic life use is the appropriate use for Effluent Canyon.
Can a designated use be amended even if the water quality for some of the criteria are not fully supporting that use?
Yes, and the regulations support this. Federal regulations require the state to amend a designated use to one with criteria with at least as stringent, with criteria that are at least as stringent as the existing use. That doesn't mean that the criteria have to be attaining, all of them. The fact that Effluent Canyon has anthropogenic causes preventing attainment of pH and dissolved oxygen doesn't preclude it from having marginal warm water aquatic life use. So even if it's not able to meet two of the criteria, it must still protect for the chronic exposures to the contaminants in Section 900. There's no designated use with less stringent criteria than marginal warm water that includes chronic exposures. Therefore, marginal warm water aquatic life use is the appropriate use for Effluent Canyon.
Does the data presented by LANL present any changes to the department's findings for existing use on Effluent Canyon?
No, the persistence of water long enough for chronic exposure dictates the appropriate use of at least marginal warm water. This doesn't change based on the data presented by Triad and DOE.
What about the inability to attain pH and dissolved oxygen in Effluent Canyon?
Well, based on the adjacent tributary, there is no natural cause believed to be preventing attainment of the dissolved oxygen criteria for Effluent Canyon. The existing use analysis concluded that the designated use for Effluent Canyon is at least marginal warm water, even if it's not meeting pH or dissolved oxygen criteria for this use, and that remains the department's position.
So how can the water quality in Mortondad Canyon be used to demonstrate what would be an attainable use in Effluent Canyon?
First, the hydrology protocol surveys were conducted in Effluent Canyon, not Mortondad Canyon. So there was no proxy for the hydrology protocol surveys in Effluent Canyon. And it was those surveys that served as the primary piece of evidence in determining the existing uses for these waters was at least marginal warm water, given that this is the next level of protections above limited aquatic life. Additional water quality data was evaluated to determine if there was any additional evidence to support a designated use with more stringent criteria than marginal warm water. Given the data was indeterminate at this time, and given the sources of water to Effluent Canyon are effluent discharges, thus the name, it's a logical assertion that Mortondad Canyon is an appropriate proxy for determining achievable water quality in Effluent Canyon.
Okay, so let's talk about Triad and DOE's concerns about the process that the department undertook. Did the joint stipulation that we entered into back in 2015 regarding proposed changes to Section 128, did that joint stipulation provide a process for amending the designated uses once there was consensus between the parties?
No, the only process in the joint stipulation was the establishment of the dates to provide data and come to an agreement. Upon agreement, the joint stipulation simply states that the department was responsible for petitioning the commission as to the agreed upon changes.
And what What data was required to be provided in the joint stipulation? Or what was the date that data was supposed to be provided by?
It was supposed to be provided by December 2015.
Was all the data necessary to evaluate appropriate designated uses obtained by this date?
No, the data was still being gathered and evaluated up through March of 2021.
When were the parties supposed to determine if agreement could be reached?
By September of 2016.
When was agreement reached, in your opinion, for the 3 sections that are being proposed as part of this hearing?
Up until Triad and DOE's rebuttal testimony, the department thought an agreement had been reached in December of 2020.
In your opinion, did the existing use analysis circumvent the joint stipulation?
No, the existing use analysis was directly in line with the language in the joint stipulation. Triad and DOE's assertions that perennial waters were included in the joint stipulation and that the process was circumvented directly contradict what the joint stipulation actually required. Perennial waters were not mentioned in the joint stipulation, and the department is obligated to petition for a designated use amendment based on one of the 3 federal regulatory mechanisms. The evidence provided by the department aligns with the requirements of 40 CFR 131.10I, which requires a designated use be amended based on an existing use with more stringent criteria. This is the path the department took in order to fulfill the final obligation of the joint stipulation, which was to petition the commission with any agreed upon changes.
Is the establishment of a designated use based on an existing use with more stringent criteria, is that a new process as asserted by Triad and DOE?
No, there are federal and state regulations that require the state to adopt a designated use with criteria at least as stringent as the existing use. 40 CFR 131.10I is the federal regulation, while Section 10B in MAC is the state equivalent. As provided in Amigos Bravos' testimony, there's precedent for establishing designated uses based on existing use with more stringent criteria dating back to at least 2005. The amendment of the recreational use in the Guyanis River near the Montezuma Hot Springs is one of those examples. So existing uses can be established based on either a demonstration of the use or on the water quality that would protect for a use. The process complained by Triad is not new.
Is more work necessary to determine the appropriate designated uses to adequately protect the classified non-perennial waters within LANL?
Yes, and the department intends to continue to work on evaluating available information and data to determine what those protections are.
Okay, I just have one more question. The proposed amendments in Section 140, do the proposed amendments to Section 140 require additional amendments in the case that the Commission adopts the proposed designated use amendments for the intermittent portions of Effluent Canyon, S-Site Canyon, and 2 Mile Canyon?
Yes, the department is also proposing to include reference language in Section 128 if the Commission chooses to adopt the designated use amendments for Effluent Canyon, S-Site Canyon, and 2 Mile Canyon.
And did any party object to those amendments?
No.
Okay, thank you. Mr. Hearing Officer, I have no further questions for this witness on this topic at this time, and she is available for cross-examination.
Are there any parties that wish to cross-examine this witness?
Yes, Mr. Hearing Officer.
Ms. McIntosh, before you begin, I just wanted to make sure that I got everyone who wants to cross-examine. Okay, and I think I do, so please go ahead.
Good afternoon, Ms. Fulham. You've referenced the joint stipulated agreement a number of times. What was the purpose of the joint stipulated agreement?
To my knowledge, the purpose of the joint stipulation was to determine the appropriate designated uses for ephemeral and intermittent waters within LANL.
So the evaluations were done on Section 128 waters, correct?
Actually, the evaluations were done on as many waters within LANL that we could evaluate.
And the purpose of those evaluations was to determine whether ephemeral or intermittent waters could be protected with a higher designated use. Is that correct?
I think that's a fair summary.
And isn't it true that by extending certain, well, by applying the designated uses in section 126 would provide a higher level of protection than current 128 designated uses?
I would disagree. Well, in comparison to section 128, it would.
Yes.
It would give a higher aquatic life protection.
And in terms of the recreational use, 128 recreational use is secondary contact, correct?
That is correct.
And section 126 recreational use is also secondary contact. Is that correct?
That is correct.
So it would require no change to move a current section 128 water to 126 in the recreational use, right?
That would rephrase. Could you rephrase that? I missed the first part.
If both section 126 and section 128 have secondary contact as the recreational use, there is no change in the recreational use by moving a 128 to a 126. Is that correct?
There would be no change in the designated uses, but it would not be permitted without a demonstration to the commission to classify it in 126.
Well, wasn't it the commission in the first instance that designated the recreational use as secondary contact in both 128 and 126 waters?
The commission did adopt secondary contact for classified waters in 126 and 128.
And did NMED, isn't it true that NMED presented no new information in conjunction with this triennial review to support a change in recreational use within Lannel waters?
I think if I understand your question correctly, that would be correct.
Now, Ms. Fulham, does a change in a designated use require a commission decision?
A change in a designated use does, yes.
So the department cannot make a change in a designated use just on its own. Is that right?
A change has to come before the commission.
So if the, as you're asserting, certain waters that were classified as section 128 waters are now 99 waters, how did that process occur if not by department determination?
We did not change the designated use. They were believed to be classified waters, but upon the information found through the hydrology protocols, they were never classified. So we did not change a designated use.
So when did that change occur?
That occurred when we were conducting the hydrology protocol surveys. And we followed the procedure in the WQMP.
So when was that announced to the public or to Lannel or any other stakeholder?
I think Lannel was involved with the hydrology protocols from the beginning, so they were aware of these waters being perennial, and we did the surveys together. So they were there the day that we conducted the surveys. We had meetings, we talked about the results of those surveys. So they were aware of this through the entire process. They were updated in our database once we had confirmation with LANL on what the extents are. There are several other tributaries to which LANL has not concurred, and we have not updated our database accordingly, but hope to do so soon.
When was LANL advised that the department had designated these waters as classified as or unclassified in 99?
I think that there was an email exchange with LANL. I believe we filed it as an exhibit, and it was between Chris Barrios and Robert Gallegos talking about the delineation of the perennial waters within LANL.
And when was that?
I would have to pull up the exhibit. I can try and find it for you.
While you're doing that, when was the commission advised that classified 128 waters were 99?
Could you ask that again? I was looking for your exhibit.
When was the commission advised that the department had determined that classified 128 waters were going to be, quote, updated in your database as unclassified 99 waters?
I think there's a correction to how that was phrased. These were never classified waters.
Okay. How was the unclassified nature of those waters? When was that unclassified nature of the waters identified in any public record?
I think the updates on our database, which is available for the public through a GIS interface, those were done this spring. It was sometime after December. Actually, it was probably after March when Chris Barrios and Robert Gallegos were communicating on the actual delineation of the perennial reaches of 3. I think there was 5 that we found, but there was 3 in particular that we all agreed to be perennial and delineated the upstream and downstream boundaries for. So it was probably sometime after March. I don't know the database though.
Excuse me. Is it your testimony that the starting point and terminus point for each of these unclassified waters is known to LANL and is posted and mapped and identified to the public and the commission?
Yes.
What is the specific mapping mapping database? Is that the Open Enviro map?
Yes.
What you're referring to? And it's your testimony that on Open Enviro map that the unclassified nature of perennial waters at LANL are identified by specific starting and ending point.
That is my understanding from what we have provided to our IT department.
Ms. Fulham, do you recall the testimony in your direct, in your rebuttal written testimony stating that there is a with sufficient evidence, there is a regulatory mechanism, and I'm reading from NMED Exhibit 109, page 38, starting at line 13, that a designated use for a water may be amended, and if there is an established section in 20.6.4 NMAC that has the appropriate designated uses within the applicable geographic location, the water may be listed in that classified section of 20.6.4 NMAC. Do you recall that testimony?
I do. But can you give me the page and line number again?
It's page 38 of exhibit NMED Exhibit 109, starting at line 13. Would you agree with me that the perennial waters identified at LANL in section 128, that I believe you testified that they would qualify for cold water aquatic. Is that correct?
They would qualify for what?
A cold water aquatic designated use.
We would have to determine that, but I don't, based on the information that we do know through Luskin and McRae, I would not suspect that cold water would not be attainable. We have not
So
evaluated
that-
high quality cold water though.
So that was that you suspect that cold water aquatic would be attainable?
It may be. High quality cold water may also be attainable. I'd have to evaluate these waters.
And isn't it true that there is an established section in 20.6.4 NMAC of section 126 in the same geographic region or area as these waters that you recently identified as perennial?
I would disagree with that statement.
And on what basis?
126 has specific delineations with the upstream and downstream boundaries of those waters. And so it's not within the same geographical location.
Well, your testimony is not same geographic location. What you said was within the applicable geographic location. And it's the applicable would a geographic location that is directly contiguous be applicable in your opinion?
Not as it's currently written in 126, no.
How would you define applicable geographic location if not directly contiguous?
It would have to include the upstream or the downstream boundary that was contiguous. At this point, it does not include that language. And these are not waters in 128, they're unclassified waters in 99. So we would need to do some work to go through that rulemaking process and demonstration of why secondary contact doesn't apply.
Ms. Fulham, isn't it true that to change a designated use, you just need some supporting evidence presented to the commission, and then the commission needs to make the decision whether that designated use amendment is appropriate? Is that correct?
In some cases, that is, not in all cases.
And are you familiar with the exhibits that were included with Lano's pre-filed direct testimony that provided evidence, not only HP1 protocols, but HP2 surveys, temperature DO, and gauge data information supporting that, providing some supporting evidence as required by 20.6.410 NMAC to change the designated use of those perennial reaches to in fact be section 126. Are you familiar with that evidence?
I'm familiar with the data that was submitted, yes.
And would that constitute supporting evidence in your opinion?
For aquatic life use, it could be used. If it was in a demonstration, I could see how the aquatic life use data may be applicable.
And isn't it also true that the triennial review process itself is a rulemaking process wherein the commission can make a decision about changing a designated use?
Yes.
Shifting gears to the section 140 proposal by the department. The information regarding Effluent Canyon was existing information. In other words, it existed before the EUA was developed. Is that correct?
To my knowledge, yes.
So that information could have been discussed and shared and evaluated by NMED and LANL had there been a consultative process in the development of the EUA. Would you agree with that?
There was a consultative process in the development of this, and that could have been brought up.
The information and data that was relied on by NMED for the EUA, was that presented presented to LANL before the EUA was presented in conjunction with the filing of the pre-filed direct testimony?
There was discussion of what data could be used in the development of a demonstration.
But the department did not provide LANL a copy of the EUA before it was presented in the direct pre-filed testimony, did it?
No, it did not.
So there was no ability on LANL's part to consider or consult with the department as to the merit or validity of those data for Effluent Canyon, was there? Those that were included in the EUA.
There was still data and conversation and collaboration with LANL up until I think it was February or March. And so the time frame to actually write the demonstration to get it into the triennial review was limited. So you're correct. There wasn't a time that was given to LANL prior to filing.
And Ms. Fulham, the recommendation that the department is making for the inclusion of Effluent Canyon as into the new section 140, that is based on a hydrology protocol survey, correct?
It's based on several hydrology. Oh, for Effluent Canyon, yes.
Yes. In other words, the department is relying on the flow regime and the fact that that the hydrology protocol survey showed intermittent waters for making the recommendation. Is that correct?
That is the primary line of evidence.
Thank you, Mr. Hearing Officer. I have no further questions.
Were there any other parties that wish to cross-examine Ms. Fulham? Were there any commissioners that wanted to cross-examine Ms. Fulham? Are there any members of the public? Mr. Verheuel, is there any redirect on the questions that were asked?
There is a very brief redirect, Your Honor. Thank you. Ms. Fulham, do you have NMED Exhibit 110 in front of you? And can you go to section 128, please?
Let me get it up. You said 128?
Yeah.
Yes, I have it up now.
Can you read the existing language of section 128? Just tell me what it says. Just the first paragraph. You don't have to go down to subparagraphs A and B.
Ephemeral and intermittent waters within LANLs managed by U.S. Department of Energy, DOE, with LANL, including but not limited to Mortendad Canyon, Cañada de Buey, Ancho Canyon, Chiquehue Canyon, Indio Canyon, Fence Canyon, Portillo Canyon, and portions of Canyon de Valle, Los Alamos Canyon, Sandia Canyon, Pajarito Canyon, and Water Canyon, not specifically identified in 126 NMAC.
Do you see any perennial waters described in that segment?
No.
Why not?
Because these were only ephemeral and intermittent waters within LANL, as described in the language.
Okay. So waters that are described in 128 or that are classified in 128, those are not perennial, is that right?
That is correct.
The joint stipulation and that was regarding the waters that were in segment 128. Were the waters in there, or the waters that were found to be perennial as a result of the work under that joint stipulation, those were previously assumed to have been in section 128, but then new information indicated that they were perennial and therefore not classified in 128. Is that right?
That is correct.
Did Lanwell at any point provide E. coli data as supporting evidence to determine secondary contact use?
No.
Okay, no further questions for this witness at this time.
Okay, Ms. McIntosh, are you ready to present your evidence on issue 7?
We are, Mr. Hearing Officer. At this
Who
time,
would you like to call first?
Dr. Meyerhoff.
And will you be presenting these 3 witnesses as a panel for cross-examination?
Yes, we will, Mr. Hearing Officer.
Okay. Please proceed. And Mr. Meyerhoff, you're still under oath.
And excuse me, Dr. Meyerhoff, would you just kind of speak up for me? You're a little soft-spoken.
Yes, ma'am, I certainly will.
Thank you.
Dr. Meyerhoff, did you present direct and rebuttal written testimony pre-filed regarding topic 7?
Yes, I did.
Could you please summarize that testimony?
Yes, I'd be happy to share the screen. I have a very brief PowerPoint that I will speak to. My testimony here, I'm going to focus on the history of the adoption of the classified waters on landfill property in sections 126 and 128. I actually participated in that Triennial review hearing before this commission at that time. So I was actively involved in discussions around the classification of these waters. We've heard a number of times about a U.S. Fish and Wildlife study that was completed. The date on the document's 2002. It provided some of the fundamental basis for decisions that were made in the Triennial review completed in 2005. That study started actually in the late 1990s and then incorporated quite a few years of information. The outcome was a recommendation to classify specific perennial waters. At the time, it was section 121A that became 126, and also classify a group of waters as ephemeral and intermittent as 121C, which we now know as 128. And we've been discussing the various uses that apply to those waters. After the Triennial review is completed, of course, the commission makes their decision. They package the materials and they send it to EPA to do their responsible review under the Clean Water Act. And in actually December of 2006, they notified the state via letter that a use attainability analysis was needed to support the designations of secondary contact and limited aquatic life uses on 126 or 128. The department did prepare that UAA, provided it by August of 2007, and the EPA subsequently approved it on August 31 of 2007 and notified the state that they were approving sections 126 and 128 classifications based on the findings of that use attainability analysis. Next slide. I should mention, well, in the way the basis for the recreational uses, secondary contact was based on low flow conditions and the inability to immerse in the water such that there was not considered a high risk of ingestion. So thus, secondary contact definition. There have been 2 Triennial reviews, of course, since that 2005 completion. One is the 2009 Triennial review. In EPA's record of decision, they reaffirmed their previous decision. In fact, they kind of basically restate what was in their 2007 letter and just restate that there had been a UAAs provided to the EPA. And then, of course, the 2013 Triennial review, after discussions about appropriate uses, there was an agreement reached that we've been talking about, the joint stipulation agreement, that set the stage for working on appropriate protections for section 128 waters. Since then, we've been talking about, there's been work going on collaboratively to implement the stipulation. Next. So the original classification was based again on this sustainability and EPA's ultimate approval of that. So in this Triennial review, we've talked about here a proposal to move selected section 128 waters to a new section 140, and that is one aspect, and also will be discussed is a proposal to take some portions that are adjacent or contiguous with 126 waters and extend the protections under 126 to those reaches. And the basis for these reclassifications are the work completed under joint stipulation. As we just talked about, there's a variety of data in the record, and of course the existing use analysis we've been talking about through these proceedings. So in the remainder of my testimony, I'm going to address a few items relevant to my testimony.
Yes, first, Dr. Meyerhoff, obviously, well, did you hear the rebuttal testimony? Sorry, did you hear the testimony of Ms. Fulham regarding Lana Waters just now?
Yes, I did.
And have you also reviewed Ms. Fulham's direct and rebuttal testimony in, most particularly, NMED Exhibit 109?
Yes, I did.
And do you have responses or comments to that Fulham rebuttal testimony?
Yes. Just several items I want to speak to. First, there seemed to be some concern in the use of language in my direct testimony regarding moving or reclassifying, or the use of the word reclassification in my direct testimony. And I want to reiterate that the use of those terms was in the context, for example, of reclassifying waters that are currently in 128 to 140. We use that term simply on the basis of general usage of the term classification, simply meaning that to assign to a different class or category. So there is nothing special about the use of the word. But the note here about federal regulations, we did note that EPA itself, in its own handbook, when it talks about removal of designated uses, actually uses the word reclassification in the discussion of its process. There was a comment made about NMED disputes that LANL has regularly evaluated the appropriateness of secondary contact. And there's been testimony in previous Triennial review hearings that was provided in exhibits that LANL does conduct these regularly, and that there is, to this date, we have found no contrary new information that's been provided. We also wanted to note that until new information is provided, the original findings of the 2007 UAA still remain as the primary information that's in the record. There was a comment made that EPA did not approve the 2007 use attainability analysis, and probably the simplest way, we have several places where we use as our basis for that, but the most important one is Exhibit 26, which is the EPA's record of decision on the 2009 Triennial review. It's a 2011 letter. And to put it in their words, they said that EPA approved this UAA on August 31, 2007. So I stand by my original testimony that EPA did approve the use attainability analysis.
And Dr. Meyerhoff, not only did Ms. Lemon in her rebuttal testimony in Exhibit 106, Ms. Fulham in her rebuttal testimony at NMED Exhibit 109, but also Ms. Fulham's testimony here this afternoon, NMED contends that all waters at LANL are not classified. Do you agree with that?
No, I don't. And there's several reasons why I disagree with that statement. Probably first and foremost is a review of the use attainability analysis actually shows that all waters for Section 1 that were being designated, proposed for designation for 126 and 128, the document that was sent to EPA to justify the secondary contact and limited aquatic life uses, Exhibit 18, has a map. And this is a department map that they prepared that shows every water body within the boundaries of LANL property, either 126 or 128. There is nothing shown as unclassified. We also have to consider that EPA in its approval of the UAA would use that as its basis for deciding whether or not the classification of water bodies with those designated uses met the requirements of the Clean Water Act, and there's nothing in their letter that indicates they had any questions or indications about what was classified or not. But also interestingly, the direct testimony at the person who provided the direct testimony on behalf of LANL in the 2003 Triennial Review, Dr. Frederick Fisher, I went back and looked at that, and it's our Exhibit 23. And he actually went through and described the proposals as they were. So picture a Triennial Review hearing 18 years ago, and he's testifying what's in his testimony. And so in the written testimony, he says that both proposals, and he's referring to the department's proposal and LANL's proposal at that time, divide the water bodies on LANL property into 3 groups based on designated uses. And those 3 groups that he goes on to define, because at that time there were 3 segments being proposed. One was, at that time, 121A, which became 126. Those were defined as perennial. The second grouping was upstream of Los Alamos Laboratory National Property, and those 121B became 127. And then the third, the text of the testimony says the third group consists of the remaining 80 miles of ephemeral and intermittent waters within the laboratory. I went and actually looked at the transcript, because direct file written testimony versus what was said in the hearing may be important. And the transcript actually shows that Dr. Fisher essentially repeated, though he adjusted it to 85 miles by the time the hearing was held. And I found in the record no evidence during cross-examination by the department or any other party that that was disputed, that these 3 groupings were not the basis for the proposal. Between that testimony plus the map and what was submitted to EPA to demonstrate what was covered by 126 and 128, I have to conclude, my recollection is correct from that time when I was there, the intent was that all waters on LANL property were being classified under these 2 sections.
And NMED supported the classification in those 2 classifications of 128 and 126 for all waters. Is that your understanding?
That's my understanding, and so did the commission approve the same.
And hearing the testimony this afternoon, is modifying well, let me back up and ask you, by virtue of the classification of 128 waters, that classification is accompanied by designated uses. Is that not correct?
That is correct.
And so to amend any of those designated uses, Ms. Fulham testified that that would require a commission decision. Is that your understanding?
That is my understanding, yes.
So in your opinion, would it be appropriate for classified waters with designated uses to be declassified to 99 without any commission involvement?
No, that makes no sense.
Now, did you also hear Ms. Fulham's testimony and response to my questions about her written rebuttal testimony at page 38, starting at line 13, where she said that there is a mechanism to amend a designated use if there's an established section in 20.6.4 NMAC that has the appropriate designated uses within the applicable geographic location. The water may be listed in that classified section of 20.6.4 NMAC.
Yes, I did hear that.
And is it your opinion that what LANL is proposing for the classified section 128 waters that based on HP surveys were found to be perennial, that the mechanism she described in her written testimony would be appropriate to move those waters to section 126?
Absolutely. And the fact that they're contiguous makes it even more sense why you would just simply join them effectively and put them with 126. With regards to the uses, there's no expectation that something that's contiguous, and so by that we mean the flows are connected, would be any different. The original use sustainability analysis for secondary contact, for example, was based on low flow conditions. You would not expect something contiguous to be any different now between the two portions that you're combining together.
And would contiguous waters, in your opinion, be in the same applicable geographical location?
Absolutely.
Would the process that you testified about earlier today, had a process such as that been applied in the context of the Section 140 EUA, in your opinion, obviated the data issues that Ms. Vullum explained?
Yes, very much so. As I've testified, the first step in that process was to develop, I called it a work plan. And that's when you work with the stakeholders to evaluate how you're going to do the site-specific study on these given water bodies. What kind of data are you going to use? How are you going to collect it? And the like. And in fact, it's not unusual in discussions of uses and water bodies with stakeholders. You might even talk about what are potential regulatory outcomes. So some thought ahead of time could have been used here in process, deciding which data you were going to apply. And then the next step of actually collecting the data, you would have had a good sense of what you needed to do.
And data quality and data validation and data relevance discussions.
Absolutely, all those things would apply at that time to determine what's the minimum threshold for making a decision.
Thank you, Dr. Meyerhoff. Do you have any additional comments to make about Lanol waters on topic 7 at this time?
I do not.
At this time, Mr. Hearing Officer, we would call Mr. Gallegos.
Please. I believe he's also still under oath. I think it's only Mr. Goring who has not been sworn in yet.
Yes, Mr. Hearing Officer, that's correct.
No,
Well, he's correct that you have not been sworn in.
No, I'm not saying that he hasn't been sworn in. I was saying that Mr. Goring has not been sworn in.
Yes, well, let's start over. Mr. Goring has actually been sworn in.
Oh.
He has just not given his background and credentials.
Oh, I see.
So, all right.
Then just to be clear, all 3 of your witnesses have been sworn in.
Yes, Mr. Hearing Officer.
Okay, marvelous. Thank you.
Okay, so Mr. Gallegos, did you provide direct and rebuttal testimony regarding topic 7, Lanol waters?
Yes, I did.
And did you have any corrections that you would like to make at the outset to that pre-filed testimony?
Yes, I do. I have a couple of clarifications on the number of miles of perennial and intermittent waters that I referred to in my direct testimony. With respect to the number of miles of perennial waters at Lanol, I indicated in my direct testimony that there were 10 miles of perennial waters. And I want to clarify that based on our analysis and based on the HPs that we did, we believe that there potentially could be up to 10 miles of perennial waters. Certainly, there are more perennial waters at the laboratory that would warrant increased protection. So I want to verify that we currently don't have 10 miles of perennial waters that have been classified in that manner. The other correction I'd like to make is that for the intermittent waters, roughly the same issue is that when we went out and did the hydrology protocols, we found a number of areas where there are intermittent waters based on the hydrology protocol, and those waters could potentially be up to 20 additional miles where increased protections from the current classification 140 could be placed into more protective uses. So
Thank you, Mr. Gallegos. Did you have any other corrections?
No, not at this time.
Then at this time, could you please summarize for the commission what your direct and rebuttal testimony is regarding land and waters?
First slide, please. So this first slide deals with the basic proposals and recommendations that LANL has today. One, you've heard about our discussion about adding approximately a mile of perennial waters into the cold water aquatic life use for more protective uses. We also recommend that the commission establish a new regulatory section in 20.6.14 to add protections in portions of 2 Mile Canyon and portions of S-Site Canyon. LANL is also recommending that 20.6.4.126 be amended to provide greater flexibility so that as studies and information becomes available, if warranted, that additional waters could be placed into perennial waters could be placed into 126 by adding the language in 126 to including but not limited to. Some discussion has been held about effluent canyon, which LANL had previously agreed to and determined that 140 uses were attainable, but upon review of additional evidence, we determined that it's maybe not ready at this time, but that further study would be required. Mr. Gehring will talk more about that issue. Next slide, please. This is a map that I showed you earlier this morning, and I just want to reiterate that all waters within the laboratory are classified. Again, the red being perennial and 126, and the green being 128, and the green being 128 ephemeral intermittent. Next slide, please. So we talked about the joint stipulated agreement this morning, and I won't go over this again other than just to say that the parties agreed in the last triennial review to look at what the appropriate uses for 128 waters were. And just to indicate that the work that was completed was with Nmed and to a lesser extent Amigos Bravos, but 117 hydrology protocol surveys were conducted, and 32 level 2 hydrology protocols were conducted, and a number of documents and data and information was shared. Nmed participated on approximately 50% of the surveys over a 5-year period. Next slide, please. This particular slide, I would just like to show again the work that was completed under the stipulated agreement. The red triangles show the sites where the hydrology protocols were conducted. The red triangles represent the hydrology protocols that were conducted jointly with Nmed and LANL, and to a certain extent Amigos Bravos. The western part of the laboratory is where we'll focus on, where you see some of the yellow and some of the green, and I'll go to the next slide. As I indicated, the current number of perennial waters at LANL that are identified in 20.6.4.126 are 4.8 miles, and the intermittent ephemeral waters at LANL are, as designated in water quality segment 128, are approximately 75 miles. With the proposal before you today, we're looking to add an additional mile, expand the current perennial waters additional mile, and expand intermittent waters an additional 2 miles, both resulting in increased protections for currently classified 128 waters. The remainder of the waters at LANL will remain in the ephemeral intermittent category in 128, and as new information becomes available, there's a possibility that those will get moved into more protective uses. Next slide, please. This is a close-up of the map that I just showed you, and then to the north you see this is called 2 Mile Canyon. You see the orange yellow color there. That is 2 Mile Canyon, and
the triangles are where the hydrology protocols were conducted. We recommend that area be upgraded to 140, as well as in the southern portion of this map, down closer to S-Site Canyon, below Martin Spring, that small stretch down below that was previously described, we also believe warrants increased protections into Category 140. Now, in the center of the map, where you see the words Stammer's Gulch, Arroyo de Delph, this is Padito Canyon and tributaries to Padito Canyon, and the red is currently classified waters under 126 with the cold water aquatic life use. We're looking to expand this or connect currently perennial waters, connect and expand up Padito Canyon to Homestead Spring, to the side tributary of Arroyo de Delph, include those perennial waters there, and then approximately a half mile below what we call Arroyo de Delph, below that gauge E242.5, a half mile down, extend the perennial reaches down to that area. And in the next map, I will show kind of an expanded version of this particular area. Next slide, please. So NMED, as we previously testified, is purporting to default classified waters in 128 to unclassified waters. This would provide less protections than what the 126 category would provide. This is in contradiction to the joint stipulated agreement, where the joint stipulated agreement called for seeking increased protections for waters. No additional evidence has been provided by NMED that would warrant anything other than secondary contact at this time. The figures at the bottom of this on the left show again the current perennial reach, and on the right shows the expansion or continuation of continuing waters that we are proposing, both up Padito Canyon and down Padito Canyon and up into the tributary of Arroyo de Delph. Next slide, please. With this slide, again, back to the same slide, I'd just like to point out the area. In the next couple of slides, I have some photographs where Homestead Spring, if I could just have the mouse for 1 second, if I can point those out, thank you. So I'm going to show a photograph of Homestead Spring just so that you can see the area. And then I'll show a photograph of Upper 2 Mile Canyon showing the intermittent conditions in this area. And then finally, I'll show a photograph of the terminus, where we think the terminus of E244 should, where the 140 protections would end at E244.
Well, you're showing the map, and there is a disagreement between NMED's proposal and LANL's proposal as to the terminus of Section 140 waters. Can you point that out and describe it?
Yes. So we propose that the 140 protective reaches go from the upper confluence with Upper 2 Mile, which is in this area, down to what we call gauge E244. It's one of our flow gauges that's been around for many years, and we believe that the terminus should stop at this point right here, approximately 0.2 miles above the confluence with Padito Canyon.
And you're relying on the HP data for that decision?
Yes, we're relying on the HP data and supplemental information that we collected under the HP2 information, as well as flow data from the gauge. The other thing I should point out while I have this map up is that we had originally agreed that Effluent Canyon should receive 140 protections, but based on additional information that we've looked at with regards to pH and DO and some other things that Mr. Guerin will talk about, we don't think it's ready at this point until we are able to gather additional information. So this slide, as I indicated, is right below Homestead Spring. And the things that I just want to show in it is that there is a healthy riparian habitat around the water, around the stream. And there's while there's a small volume or a low volume of flow in this stream, the water is persistent enough that it supports a healthy community of aquatic life or wildlife. While we didn't note them on the during the site visit, our wildlife biologist at the laboratory indicates that salamanders and frogs also exist within this area.
And Mr. Gallegos, before you move on to 140, in conjunction with your direct pre-filed testimony exhibit 3, did you also present several exhibits detailing the supporting evidence for the expansion of section 126 protections for the recommended stretches of currently section 128 waters?
Yes, we did. So for this particular area and for the others that we showed you previously, we have data consisting of temperature and dissolved oxygen and pH data, as well as flow data from some of the gauges that we have in this area.
And I would just reference exhibits 37, 38, and 39, which included the HP evaluations. Is that correct?
That's correct.
Thank you.
Next slide, please. So this is the upper reach of 2 Mile Canyon, right below the confluence with upper 2 Mile Canyon. The figure on the left shows a reach a little bit higher in the canyon, and the reach on the right is a little bit lower. But again, the takeaway message from here is that the riparian habitat may not be as robust as it was in the perennial reaches. Both photographs kind of are typical of the area. The water again the volumes are low, but the volumes are persistent enough to sustain an aquatic life community. Although the populations and the numbers are somewhat less than what we normally see what we saw in the perennial waters, aquatic life occurs in these areas. And again, speaking with our wildlife biologists, we have salamanders and amphibians also occur in both of these areas. Next slide, please. So the figure on the left, I just want to point out 3 families of benthic macroinvertebrates that occurred really in all the waters, all the areas where we have persistent water. And the upper left is the stonefly, and the upper right is mayfly, and then the bottom 2 photographs show caddisfly casings, and in one case you can see the caddisfly larvae in there. These were found. These represent where these organisms are found. We see persistent water is usually required to sustain them, and also are indicative of where good or improving water quality is also present. The photograph on the right is the gauge at E2 is the E244 gauge, which is located near the terminus, which is located near the end of 2 Mile Canyon. But this is the site where we propose that the protections, 140 protections, terminate at this point right here.
And the basis for that?
And the basis for that is, so we conducted, on this particular day, we conducted 4 hydrology protocols from top to bottom of the reach. And in this particular reach, the scores were 10.5, which does score according to the protocol in the intermittent range, but further data collected during the hydrology 2 portion of the field survey indicated no water again, as you can see, no water now. No benthic organisms were observed, or we were even able to collect them. And when we applied the methods of the HP2, we just didn't find any further evidence that we should extend the protections beyond this point.
And again, that evidence is included with your direct pre-filed testimony of Exhibit 3, Lanel Exhibit 3, as Lanel Exhibit 40, 41, and 42. Is that correct?
That's correct. So finally, again, back to the original slide, in that we're proposing the expansion of 126 waters by about a mile. We're also recommending that the commission adopt the new regulatory section 140. Both of these in support of the work that has occurred since the last triennial review and institute and adoption of the execution of the joint stipulated agreement. We also are recommending a change to 20.6.4.126 that would add the language, including but not limited to, so that as new evidence becomes available, we can move as appropriate additional perennial waters into 126. And while Effluent Canyon may qualify for 140 protections, additional study is required.
Mr. Gallegos, did you hear Ms. Fulham's testimony in response to a question from Mr. Verheuvel that section 126, no, excuse me, that section 128 does not include a reference to perennial waters?
I did.
And the ability to provide flexibility of moving 128 into section 126 would be addressed by that language of including but not limited to, in order to not identify specific segments in section 126. Is that correct?
That's correct.
Turning to the respond to the testimony of Nmed in written rebuttal and then in oral testimony today. Mr. Gallegos, you understand that Nmed disputes that all landfill waters are classified and asserts that those waters that were identified to be perennial by HP surveys over the last couple of years are unclassified. Do you agree with that assertion?
No, I do not.
And what is the basis for Lano's position?
So there's a couple of reasons here, and Dr. Meyerhoff spoke to the issue of the 2007 UAA and showed you the map of all waters, showed you the map indicating waters within the boundaries of Los Alamos Laboratory are classified. Mike Saladin in the 2014 Triennial Review provided rebuttal testimony to that effect, and he provided an affidavit also indicating that this is the case for that all waters within LANL are classified. I'd also point out that NMED asserts that with respect to LANL unclassified water, NMED has already updated the appropriate classification in the department's Surface Water Quality Information Database. It's called SQUID, and I believe this is incorrect.
And Ms. Fulham testified to that was updated in Open EnviroMap this afternoon. Did you hear that testimony?
Yes, I did. She indicated that.
And when you say it's incorrect, what is the basis for your statement?
So the next slide, please. So this is a screenshot from the SQUID database or SQUID mapping tool, and indicates, so you can see this is the area, and this yellow area right here is the area below Homestead Spring that is currently classified as 128. And this map shows that the key here shows that it's in water quality segment 128. So the map has not been updated, and this is the area where we believe that it should go from 128 to 126. And if I could see the next slide, please. The next slide shows the example on the lower reach that we're proposing to extend into perennial waters below Arroyo de Del for about approximately a half a mile. And again, the map shows and the coverage shows that this is still contained in water quality segment 128.
And Ms. Fulham testified that the department notified Lanol or communicated with Lanol that waters had been unclassified. Did you hear that testimony?
I did hear that testimony.
Was Lanol ever informed of the specific starting point and ending point of these alleged unclassified waters?
Lanol was not informed, but we did. So let me back up. So classifications or hydrology protocols work has been conducted since the joint stipulated agreement was put in place. So hydrology protocols were conducted in 2015 and 2016. We had some interruptions in 2017 and 2018, but even back in those years, the first waters that we looked, the first 128 waters we looked at, because we all had some evidence by sharing information at that time, that there were some areas of the laboratory where there may be more persistent waters. So we went to those areas. Those areas, in some cases, scored in the perennial reach, and we were not, we were out in the field. We all understood that the hydrology may be perennial, but there was never any discussion back in those days that these waters would somehow default or be unclassified in any way. That had never happened. And so we continued with the work in 2019 primarily, again, going up to these areas where we know, prioritized areas where we know that there may be water out in the field. We understood together jointly that in some of these cases, the hydrology may be perennial, but again, this was never discussed in the field that these waters were unclassified. It wasn't until approximately sometime in January of 2021 where in one of our monthly meetings where this issue came up. But the department has never notified us, but they did ask us to provide the bounds of the hydrology protocol perennial reaches that we had previously agreed on, and we emphatically told them that we disagree with them on this 99 unclassified waters, but that we will provide them the information that they were seeking. And so the information that they were seeking I would assume would have been used to update this map, but as you can see, this has not been updated.
Now, you also heard, next slide, you also heard testimony that the department considered amending to add section 126 protection as outside the scope of the 2015 joint stipulation. Actually, that was in NMED's Exhibit 109 written testimony. Do you agree with that assertion?
No, again, waters at the laboratory were either 126 or 128. We were looking at the 128 waters. When we went to these waters jointly, we realized through the application of the hydrology protocol that they had perennial characteristics. And so 126 waters maybe not mentioned in the hydrology protocol, but they, at the time that we were looking at this, these were all 128 classified waters.
And if the commission adopts Lano's proposal to extend section 126 protections to certain currently designated 128 waters, these waters would be, in other words, Lano is fighting to increase the level of protection that would be afforded to these waters. Isn't that correct?
That's correct, just as the joint stipulated agreement asked us to do.
Ms. McIntosh?
Yes.
I just wanted to give you a courtesy 3-minute warning.
Okay, thank you, Mr. Hearing Officer. The data that you have addressed in terms of the data generated under the joint stipulated agreement Has all of that been provided or made available to NMED?
All the data, including the preliminary data provided back in 2015, and throughout this process, all this data has been provided to NMED. Gauge data, HP data, benthic macroinvertebrate data, riparian habitat data.
Thank you, Mr. Gallegos. Did you hear the testimony, or did you read the testimony from Ms. Fulham in Exhibit 109 that where she asserted that there was no mechanism to assert the designated uses for these perennial waters other than treating them as classified?
I did.
And is it your opinion that the triennial review and this process is such a mechanism?
Yes, the Triennial Review provides that mechanism. Again, under the joint stipulated agreement, we were tasked with coming up with the data and trying to reach agreement. And this is the exact setting where the standards and the rules should be adopted.
And did you also read Ms. Fulham's testimony that a designated use may be amended by listing a water in an existing classified section? And that testimony being in the written Exhibit 109?
Yes, I did.
And do you have an opinion as to whether LANL's proposal conforms to that mechanism?
I believe it does. We're looking at an area for extending the protections and refining the protections of one that was protections that were established by the Commission in the 2003 Triennial Review. We want to extend these and refine these extensions into current 126 waters.
And again, to avoid this sort of dispute in future triennials, is LANL proposing to increase flexibility for the Commission by including that language, including but not limited to?
Yes, we're requesting that the Commission add that language.
Are there any changes that LANL would recommend to section 20.6.4.128 in conjunction with the ability to identify and properly protect perennial flow waters or waters with perennial characteristics that are currently classified as section 128? Yes.
I'm just looking at this. Yes, that's correct.
And that would be done, the recommendation is that that would be done by deleting the word specifically?
Correct. So if we were able to delete, if the Commission deleted the word specifically, this would provide more clarity to the water quality standards.
And that concludes our testimony from Mr. Gallegos. At this time, Mr. Hearing Officer, we need to make a quick switch for Mr. Gehring's testimony, and then we will sit with all three for cross-examination.
Okay, and it is 4:30 now.
How about a 5-minute break at least?
5 minutes is fine.
Thank you.
Thank you. Break.
Excuse me, I was not back yet. Okay, 1 second. All right.
Are you ready?
Yes, thank you.
It is still 4:35. We are back from a 5-minute break. On day 4 of the Triennial Review, I understand that we have 2 members of the public that would like to speak at about 5 o'clock. So what we'll do is we're going to take this third Los Alamos National Laboratory witness, Mr. Gehring. Then we will go to the 2 public members, and then we will also discuss possibly rescheduling for another day to conclude the Triennial Review, and then we can start cross-examination. Oh, wait a second, though. We do have a witness from CCW named Sanchez, who we will get in before 6 o'clock. All right. So Miss McIntosh, are you conducting the examination?
She is not, Mr. Hearing Officer. My name is Alexander Arnsberg. That last name is spelled A-R-E-N-S-B as in boy, E-R-G. I'm with the law firm of Squire, Patton, Boggs. I'm appearing for the first time today on Friday on behalf of Triad National Security, and I'll be presenting our next witness, Mr. Timothy Gehring, who has already been sworn in.
Welcome, both of you, and please proceed.
Triad National Security calls Mr. Timothy Gehring. Mr. Gehring, could you please state your full name and spell it for the record?
My name is Timothy J. Gehring, and the last name is spelled G-O-E-R-I-N-G.
Mr. Gehring, could you please briefly summarize your educational experience?
Yes, I have a Bachelor of Arts degree from Environmental Science from the University of Virginia and a Master of Science degree in Hydrology and Water Resources from the University of Arizona.
And what is your current employment?
I'm currently employed as an environmental professional in the Environmental Protection and Compliance Group at Triad National Securities.
And when did you start working at Los Alamos National Laboratory?
I started at Los Alamos National Laboratory in 2007, and from 2007 until 2015, I was the technical lead for the interim facility-wide groundwater monitoring program.
And what are your current responsibilities at the laboratory?
I currently provide technical support on a variety of activities, including the groundwater discharge permit program and activities related to Clean Water Act activities and standards for surface water for our surface waters within LANL.
Do you have before you what have been marked as LANL Exhibits 4 and LANL Exhibit 60?
I do.
Are LANL Exhibits 4 and 60 your pre-filed direct and rebuttal technical testimony?
They are.
Respectively, that were filed in this matter?
Yes, sir, they are.
Were LANL Exhibits 4 and 60 drafted by you or under your supervision?
Yes, they were.
Do you have any corrections that you would like to make to your pre-filed direct technical testimony as reflected in LANL Exhibit 4?
Yes, actually, there was a typographic error on page 15 of my pre-filed direct testimony, line 4, and the text currently says the existing section 128 reach in Starmer's Gulch. It should have said the existing section 126 reach in Starmer's Gulch. So that typo is the only one I found.
Do you have any corrections to your pre-filed rebuttal technical testimony that as reflected in LANL Exhibit 60?
No, I have no corrections on that.
Your pre-filed direct and rebuttal testimonies are presented in question and answer format. If you were asked the same questions today, would you provide the same answers under oath?
I would.
Therefore, do you affirm and adopt that the information contained in LANL Exhibits 4 and 60 is true and accurate to the best of your knowledge and belief?
I do.
Could you please describe generally what issues you addressed in your pre-filed technical testimony?
My testimony pertained to technical data and support for classifications of LANL waters under the proposed provisions 20.6.4.126 NMAC, 20.6.4.128 NMAC, and 20.6.4.140 NMAC.
Keeping in mind that the Commission and other parties have already reviewed your pre-filed testimony, could you please briefly summarize the scope of your testimony and recommendations?
Yes. Next slide, please. LANL supports making refinements to the surface water segments classified under 20.6.4.128 NMAC, referred to as Section 128, and 20.6.4.126 NMAC, referred to as Section 126. LANL regularly collects high-quality data relevant to surface water and stream characteristics. These data include hydrology protocol, level 1 and level 2 evaluations, stream gauge flow data, precipitation data, temperature, pH, and dissolved oxygen data, macroinvertebrate and benthic data, and also general field observations and photographs. Based on the data, there is a strong technical basis to support classification of the following sections under 126 rather than section 128. Pajarito Canyon from 0.5 miles below Arroyo de la Delfe upstream to Homestead Spring, and Arroyo de la Delfe from Pajarito Canyon upstream to Keeling Spring. Supporting data include, again, stream gauge flow data, hydrology protocol data, temperature, pH, and DO data, and benthic and macroinvertebrate data, and field observations and photographs. The map I show on the exhibit is LANL Exhibit 38, page 1. And this map highlights LANL's proposed section 126 reaches. The existing 126 perennial waters are shown in red up Upper Pajarito Canyon and then up to Starmer's Gulch. However, there are additional perennial waters that are contiguous with these that merit additional protections under 126. These are shown in blue on the map, and this includes the stretch upstream from the confluence with Starmer's Gulch to Homestead Spring, and also up Arroyo de la Delfe to Keeling Spring, and half a mile below the confluence with Arroyo de la Delfe. We are proposing an expansion of the 126 reaches to provide additional protections and a higher aquatic life use for these contiguous areas. Next slide, please. Actually, previous slide. I forgot to point out on this map, there are circles with X's indicating our stormwater, our gauges and these are located across the laboratory, but I will speak specifically to 3 gauges, E241, E242, and E242.5, and our analysis of the stream gauge data. Next slide. This table is presented as LANL Exhibit 38, page 10, and this table summarizes the flow statistics at the gauges I pointed out on the previous map. Now, the hydrology protocol recommends use of stream gauge data, if available, to provide a better understanding of the flow characteristics of the reaches, whether it's ephemeral, intermittent, or perennial. So I reviewed the gauge data from these gauges for a multiple year period, and gauge data are important because it's more than just a snapshot of flow. It shows long-term flow over a period. And the general rule of thumb for Western streams is if a reach is flowing 80 to 100% of the time, that is perennial characteristics, and 10 to 80% is intermittent characteristics. And so based on my review of the data, these gauges, E242 is in the 126 classified reach. E241 is upstream below Homestead Spring and above Starmer's, and E242.5. These show perennial characteristics approximately on the 80% flow statistics. And this is over the period from 2000 to 2009. After that time, these gauges were lost in a flooding event. Next slide, please. Presented is LANL Exhibit 38, page 12. And this is a hydrologic diagram of the Pajarito-fed spring reaches. Upper Pajarito Canyon is characterized by 10 springs that flow, discharge into Upper Pajarito Canyon, and also the tributaries, South Starmer Gulch, which is shown here as South Fork Pajarito Canyon, and Arroyo de la Delfe, which is shown on this block diagram as North Anchor East Basin. The existing 126 perennial reach extends below Starmer Spring in the middle lobe there, down Pajarito Canyon to the confluence with Arroyo de la Delfe. These springs are one of the primary factors for the perennial characteristics of these tributaries and this reach. And we propose to add the additional protections, additional aquatic life protections under 126 to the tributary Arroyo de la Delfe, and also up Pajarito Canyon to Homestead Spring, up to Homestead Spring. Again, these springs are one of the key factors why these are all recommended for 126. Next slide, please. In addition to my review of 126 data, I evaluated other data for the section 140 reaches, and their data do support proposed section 140 reaches. Based on the data, there is a strong technical basis to support classification of the following segments under proposed 20.6.4 140 NMAC, or section 140, rather than section 128. This would provide additional protections to these reaches. The two reaches we recommend is 2 Mile Canyon from Lannel Stream Gauge E244 upstream to its confluence with Upper 2 Mile Canyon, and S-Site Canyon from alluvial groundwater well MSC 1606293 upstream to Martin Spring. Again, supporting data for these recommendations include stream gauge flow data from E244, hydrology protocol level 1 and 2 evaluations as discussed by Mr. Gallegos, temperature, pH, and DO data, benthic and macroinvertebrate data, and general field observations and photographs. Projected now is Lannel Exhibit 38, page 1. This map shows Lannel's proposed section 140 reaches. On the south part of the map is a short segment for S-Site Canyon from Martin Spring down to the monitoring well 1606293. And then in the upper part of the map is the proposed 2 Mile section from the confluence with Upper 2 Mile Canyon down 2 Mile all the way to E244. We recommend the gauge at E244 on the southeast side of that reach as the terminus for the proposed 140 water, rather than extending it the additional 0.2 miles down to Pajarito Canyon. And I will explain a little bit of rationale for that recommendation next. Next slide, please. The attached hydrographs are from gauge station E244, our proposed terminus. And we believe these are one of the lines of evidence why this location is a logical terminus for the 140 reach. Now, the stream gauge data here, this shows 5 years of record, relatively recent years, from 2015 to 2019 of hydrographs for E244. And the blue pulses you see are the increased stage levels following spring runoff or spring thaw events. When you see long-term pulses like that, these are indicative of intermittent reaches. And so for 2017 and 2019, we do see behavior which is consistent with intermittent reaches. However, 3 of the years, 2015, 16, and 18, show very ephemeral characteristics. We do not see any prolonged pulse like that, suggesting direct connection with groundwater as in the definition. This is Lannel Exhibit 42, page 12. Next slide, please. Regarding Effluent Canyon, I initially recommended in my pre-filed direct testimony that the commission classify Effluent Canyon from its confluence with Morton-Dead Canyon to its headwaters under proposed section 140. However, based on my evaluation of additional data in response to the Environment Department's direct testimony regarding section 140, the proposed classification of the stream reach in Effluent Canyon under section 140 is premature and requires additional study. Next slide. The map presented here is Lannel Exhibit 79, page 2, and this provides the location of Effluent Canyon with respect to Upper Morton-Dead Canyon. Effluent Canyon is shown in the middle of the map, and it has three sampling locations for surface water, shown with the green dots and the sampling locator numbers. Effluent Canyon has a confluence with Upper Morton-Dead Canyon, and then Upper Morton-Dead extends up and off the chart to the northwest. Below the confluence of Effluent Canyon is a gauge, E200, which is also a sampling location. One of my concerns, which I brought up in my rebuttal, is that the Environment Department utilized data from E200, which is really commingled data from both Effluent Canyon and flow from Upper Mortondad Canyon to characterize flow in Effluent Canyon. And in my opinion, this was not representative. There were already data available within Effluent Canyon from the locations I've pointed out above. Next slide, please. Additionally, another concern regarding 140 for Effluent Canyon is that the dissolved oxygen concentrations measured at the 3 locations that I pointed out on the map are virtually all below the 5 milligram per liter marginal warm water aquatic life minimum listed in 20.6.4900H for marginal warm water. So dissolved oxygen in Effluent Canyon does not meet the marginal warm water aquatic life minimum. Next slide, please.
And Mr. Gehring, just before we move on to the next slide, this chart is from Lannel Exhibit 81, page 1, is that correct?
Yes, that is correct.
Please continue.
And similarly, this next chart is from Lannel Exhibit 81, page 2. It's the following page. Dissolved oxygen is certainly problematic. pH is also raises some concerns. The pH levels in one of the 3 locations in Effluent Canyon do not meet the marginal warm water aquatic life minimum of a pH of 6.6. And that's shown by the dashed line across the middle there. And you can see the pH values. I might note that these data are all from around 2005 to 2010. Next slide. I mentioned concerns regarding use of non-representative data by the Environment Department in their existing use analysis. They base some of their analysis for classification of certain segments under Section 140 on non-representative data. For example, Effluent Canyon, again, I discussed the use of proxy data from E200 located below the confluence in Upper Mortondad Canyon to characterize parameters from inflow within Effluent Canyon. And my concern is this is commingled data. It includes water from Effluent Canyon, but also it includes an element from Upper Mortondad Canyon, which extends for quite a significant, a longer distance and greater area up to the northwest. Similarly, the Environment Department relied on estimates of flow from grab samples from a location in Effluent Canyon to make assumptions regarding the hydrologic flow regime. Now, when grab samples are collected, we typically make an estimate of flow, but this is hardly strong data to make assumptions regarding the hydrologic regime. So I'm concerned about that. I don't believe that's the representative data. And then over in S-Site Canyon, also proposed for 140, data from a carbon filtration treatment system was used by the Environment Department to characterize temperature, pH, and dissolved oxygen at Martin Spring. In the past, there was a pilot study with a carbon filtration treatment unit adjacent to Martin Spring, and samples from this treatment system were mixed with samples from the spring in the analysis conducted by the Environment Department, and I'm concerned about the representativeness of those data as well. Next slide. In summary, despite the Environment Department's use of non-representative data, there are reliable data that support the proposed classification under Section 140 for the following 2 stream reaches. 2 Mile Canyon from Lannel Stream Gauge E244 upstream to its confluence with Upper 2 Mile Canyon, and S-Site Canyon from alluvial groundwater well MSC 16-06293 upstream to Martin Spring. However, there is insufficient data to support the Environment Department's proposal to classify Effluent Canyon to Section 140 water, and further study is needed. If Lannel had had the opportunity to review the Effluent Canyon data with the NMED, both parties would likely have agreed that further study was needed. This concludes my summary of my testimony.
Thank you, Mr. Gehring. I'd now like to briefly turn to your rebuttal testimony. Did you review the pre-filed rebuttal testimony filed by Ms. Jennifer Fulham on behalf of NMED in this matter?
I did.
And were you also present for her testimony earlier today regarding NMED's proposed section 140?
I was.
With respect to proposed section 140, I believe you testified in your testimony that the reach of 2 Mile Canyon to be classified under section 140 should terminate at Lannel Stream Gauge E244. Is that accurate?
This is accurate, yes.
And Ms. Fulham objects to E244 being the terminus for that proposed section 140. Do you recall that?
I do recall that.
What is your response to Ms. Fulham's rebuttal testimony on this issue?
I disagree with Ms. Fulham's testimony on this issue. I believe E244 is the logical terminus for the proposed 140 section reach. As I went through with the hydrograph from 5 recent years of data, this location is effectively at a transition point between ephemeral and intermittent based on the flow characteristics and the flow seen in those 5 years of data at that gauge. Similarly, as Mr. Gallegos testified, the hydrology level 1 data from that location showed consistently that this is a transition point between intermittent and ephemeral, and the H2 level 2 analysis. They were unable to find amphibians, bivalves, or benthics. In fact, there were insufficient flow in the reach to even collect benthics. So I think there are a variety of lines of evidence that suggest that termination of the proposed 140 reach should end at E244.
Do you have any other rebuttal testimony you would like to offer the commission?
No, I have no other.
Mr. Hearing Officer, at this time, we have concluded Mr. Gehring's summary of his testimony, and I guess we would have tendered our all 3 of Lannel's witnesses on this topic for cross, unless we'd like to take public comment.
Sure. Can you unshare your screen for a moment?
Yes.
Thank you. Okay, we will get to the cross-examination in just a bit. I have been communicating with some different people, and we are going to wrap this up today at 6 o'clock. Now, I say that because you may choose that you want to have all the cross-examination done on the next day that we reconvene. Hopefully it'll be next week. We'll find out from the commissioners when they're available and when the court reporter is available, etc. We do have 2 members of the public who would like to address, and then we have a witness from CCW that we have promised to take today. So let's start out with the decision on when we are going to reconvene this hearing. Ms. Jones, would you take a poll from the commissioners to see what day next week they're available?
Yes, Mr. Hearing Officer, there are a couple that we will have to reach through email because they are not on the meeting. They had asked to be gone this week, so I can reach out to them after the meeting. But let's start with Commissioner Certain. Are you available next week, and when?
So I think the only bad day for me is Thursday.
Mornings and afternoons are okay for you?
Yes.
Except for Thursday.
Yes.
Thank you. Commissioner Dominguez. Okay, while he thinks, let's move on to Commissioner McWilliams. Do you have availability next week?
I see Mr. Dominguez.
Oh, okay. Well, let's go back to Commissioner Dominguez first.
Sorry, Pam, couldn't get to the meeting.
It's okay. I was going to get back to you.
I'm open pretty much every day next week, with the exception of Tuesday.
So no Tuesday, but mornings and afternoons the rest of the week.
With the exception, potentially Friday afternoon. I may have a conflict. I would have to get back to you on that.
Okay, thank you. Commissioner McWilliams, what's your availability?
I'm open Monday morning. I'm not open Monday afternoon. I'm not open Tuesday. I'm open Wednesday afternoon. Pretty free on Thursday and Friday.
Okay, could you say that again, Commissioner? I'm sorry, you were kind of low, your audio.
Sorry, I'm open on Monday morning, Wednesday afternoon, Thursday and Friday.
Pam,
Yes,
I
sir.
think it would be easier just to ask when the commissioners are not available.
I am not available Monday afternoon or Tuesday.
I have that. Or Wednesday morning, you said.
That's right.
Okay, I'm writing it down too.
Okay, and I do have that Commissioner Certain is not available Thursday.
Right, I have
Commissioner
that.
Dominguez is not available Tuesday and possibly not available Friday afternoon. I am getting some chats. So I saw Commissioner Rader, you wrote to me, as did Commissioner Cipher. So I'm going to skip calling on you right now, and I'll read your chat in a sec. Commissioner Modi, when are you not available next week? Okay, we'll come back to Commissioner Modi. How about Commissioner Patton?
I am not available on Monday and Tuesday.
Thank you. Okay, and I did see a text from Chair Stringer, Commissioner Rader, and Commissioner Cipher. Commissioner Thompson?
I am not available Monday morning, and I'm not available Thursday.
Okay, thank you. Commissioner Timmons, I don't think has been at the hearing, so I will reach out to Commissioner Timmons. Commissioner Vigil, what is your non-availability?
I can make myself available at any time next week, so.
Thank you. Appreciate your flexibility. Vice Chair Wade?
I am not available Monday and Wednesday.
Okay. Thank you. Mr. Hearing Officer?
Yes, I don't know what Commissioner Rader or Cipher secretly sent you in the chat. So could you tell us?
Yes, I'm going there right now.
Thank you.
Let's see, Commissioner Cipher is not available. I mean, excuse me, Commissioner Rader is not available Monday or Friday.
Okay.
Chair Stringer is not available Friday.
Okay.
Commissioner Rader is also not available, hold on, Tuesday, or not available Tuesday until noon. And it looks like Commissioner Cipher, correct me if I'm wrong, I'm reading your message, and you're available Wednesday and Friday, so that must mean you're not available Monday, Tuesday, Thursday.
So
Hearing
far,
Officer Shakavan,
yes.
this is Council Sanchez. Chair
sir.
Stringer and Hearing Officer Shakavan, I will not be or would not be available all day, workday Monday or Thursday. And while we're having this conversation, let me remind the commission that the recessing and reconvening of the triennial review hearing would have to comply with paragraph 3 of the Water Quality Control Commission's Open Meetings Act annual resolution. And when we get to the point where that's relevant, I'll be glad to discuss that with the commission.
Mr. Sanchez, are you saying that there's a certain amount of notice that has to be given before we can reconvene?
There's a certain type of notice, more than amount, yes.
Okay, so we're not worried about, Okay, we're not worried about the amount of notice, it's the type of notice.
Well, no, we're not concerned, so much concerned about the timing of the notice as the fact of notice. I looked at the applicable notice rule in 20.1.6 governing rulemaking proceedings. I don't think we have to be concerned with those requirements. We simply have to comply with, again, paragraph 3 of the OMA resolution.
By my calculations, if we had it on Monday, we would not have Commissioner McWilliams in the afternoon. We would not have Commissioner Rader or Commissioner Patton or Commissioner Thompson or Commissioner Wade. So Monday's obviously out.
And don't forget, Mr. Hearing Officer, we've got
Right.
3 commissioners who haven't weighed in yet.
I understand. I'm just going by what I know. So that's all I can do right now. If we had it Tuesday, we would not have Commissioners Dominguez, McWilliams, Patton. So I don't think Tuesday is going to work either. Wednesday looks like a possibility. We would not have McWilliams in the morning or Wade all day. Vice Chair Wade?
I might be able to make time. I have to double check, but all day for now.
Okay. Well, we would, that so far is the best day so far is Wednesday. Thursday, we wouldn't have Commissioners Certain or Thompson. Maybe that's a better day. Maybe that's a better day. Friday doesn't look good at all. We would not have Commissioners Dominguez, Rader, Stringer, our chair. So
Council.
Sorry.
Board council couldn't, commission council couldn't be with us on Thursday. Is that correct?
That's correct. Would not be able to be with you.
Okay.
So Chair Stringer, does that give you any information to help reschedule this?
We need to have a quorum in order to continue the hearing. And it sounds like the numbers are going to be tight. I think the commissioners who are absent already have missed a significant portion and can still review the record. And so can you tell me what Wednesday looked like again? How many we might have on Wednesday?
Sure. For sure, we won't have Commissioners McWilliams in the morning, and we won't have Vice Chair Wade all day. That's all I see as a conflict so far for Wednesday.
So that seems like the day we would have the most commissioners available. And I believe that would still give us a quorum. Is that correct, Pam? You're muted.
Yes, I was already I guess I was unmuted. Yes, I think so. And then pending the other 3 that are out that might potentially be able to join us on Wednesday.
Okay. So it sounds to me like a late morning start. I'm kind of anticipating or guessing based on where we are that we could finish within a half a day. So that's an assumption I'm working under. So I feel like a 10 o'clock or 1 o'clock start on Wednesday would be our best available option given the data information we have right now.
Chair Stringer, this is Council Sanchez. Couple of questions. Do we know whether all counsel of a record would be available on those dates, on that date rather, and that time frame, and also whether their pertinent witnesses would be available to testify? I'm sorry to complicate things here, but.
Oh, I know that was the next place I was going to go once we figured out the commissioner's availability would be to seek input from all of the parties to, perhaps have the need to spread it over 2 days. So with that, I guess if we could start with NMED's availability on Wednesday. And
Madam Chair, sorry, Madam Chair, I have a meeting that would be very difficult to reschedule from 11 to 12:30 on Wednesday, but my co-counsel, Ms. Maxfield, is available. So I think if need be, we could do it. And our witnesses are all available. Thank you.
Thank you. Let's see, the next, I don't see any other parties up on my screen, but perhaps if we could hear, I saw Tanis Fox, Ms. Fox, just a moment ago. If you could give us, there's Lano. Ms. Fox, why don't you go ahead first?
Thank you, Madam Chair, and hello. I'm available, and Ms. Khan has some remaining testimony, and she is available on Wednesday. And we can make ourselves available any day of the week, actually next week, just for your information.
Very good to know. Thank you. Lano, DOE representative?
Yes, Madam Chair, Council, and some of the witnesses will be available all next week, with the exception of Dr. Meyerhoff, who's available on Monday and then Wednesday afternoon. He has a personal matter to attend to during the week and will not be available outside of those times. One option, I suppose, timing wise, if we wanted to complete, or if we could complete cross-examination of him today, that will, in that sense, we will not have an impediment to any time on Wednesday.
Okay, and that might be the easier question, actually. Does anyone object to having it on Wednesday?
So Pam, this is Silas Roma. I don't object. I just want to go on the record that I will not be available, but
Excuse me one second.
Yoakum.
Excuse me. Please repeat your name and your statement.
This is Silas Roma for DOE NNSA. I will not be available, but my co-counsel, Mr. Yoakum, will be available, and DOE NNSA has no objection to proceeding on Wednesday.
Thank you.
Okay. Not hearing any other objections, it sounds like we should schedule the completion of the hearing on Wednesday. Do I need to motion for that? Do I need a motion to schedule that on Wednesday from a commissioner? Sorry for my newness to this and not fully knowing the rules.
I would suggest, Council Stringer, that you have a motion, a second, and a roll call, and then we'll proceed with the OPA requirements.
Okay, thank you. Do I have a motion to reconvene the triennial hearing on Wednesday at 1 o'clock?
Chair Stringer?
Yes.
This is David Cipher. I would so move.
Okay, thank you.
I will second that. This is Commissioner McWilliams.
Commissioner McWilliams, I didn't hear the first thing you said.
I will second that motion.
Okay, that's what I figured, but I just wanted to make sure everyone else heard.
Chair Stringer, now that you have a motion and a second, I'll throw this in as discussion on the motion. Do all the parties believe that 4 hours will complete everything? And my question is based around, it's always safer to build in extra time than being in a situation like we are today. So, not to complicate things, but that's why I pose that more as a question of, does everybody believe it can be wrapped up in Wednesday afternoon?
Commissioner Dominguez, I can't speak for all the parties, but the Environment Department has I think, the bulk of topic 8, and we think we can get through that really quickly. And we don't have particularly lengthy cross-examination on topic 7 for the Lanel witnesses. I guess that means that we're hopeful we could do that in half a day. Yes, Commissioner.
This is Commissioner Vigil. This is Commissioner Vigil. And I'm with Larry. I think, if he started at 10 o'clock, that would give us plenty of time to go ahead and hopefully finish it on Wednesday. But like I said, if we start at 10 o'clock, took a short lunch, and then, go ahead and go till 5 or 6, I think we could finish it up. But that's just my opinion.
Do I have an amendment to the motion? To start at
I would
go ahead.
I would amend the motion to start at 10 o'clock.
Do I have a second?
Chair Stringer, I think that's a friendly amendment. You would need to check with the maker of the original motion whether he will accept that friendly amendment.
I do accept the friendly amendment. Thank you.
Thank you, sir.
Did we have a second for the amended motion?
I'll second that, Commissioner Dominguez.
Thank you, Commissioner. All in favor?
Needs to be roll call.
Okay, I didn't know if I had to ask that first and then go into the roll call. I'll have this down by the end of it. Pam, can we get a roll call vote, please?
Of course. So the roll call on the amended motion, which is to meet next Wednesday beginning at 10 a.m. Commissioner Candelaria, who's not with us. Commissioner Certain.
Yes.
Commissioner Dominguez.
Yes.
Commissioner McWilliams.
Yes.
Commissioner Modi. Commissioner Musharafi. Commissioner Patton.
Yes.
Commissioner Rader.
Yes.
Commissioner Cipher.
Yes.
Commissioner Thompson.
Yes.
Commissioner Timmons is not with us. Commissioner Vigil.
Yes.
Vice Chair Wade.
Yes, and I can make the afternoon, so I will only miss a couple hours in the morning.
Good. And Chair Stringer.
Yes.
Madam Chair, you have 10 commissioners that are able to make it. That's more than a quorum. And then you have 4 that are not here. They are absent.
Okay. Well, thank you all. I appreciate your patience while I learn this process, and I believe we can get back to our regularly scheduled program.
Chair Stringer, if I could please, let's go ahead and deal with the OMA requirements. And I'm going to read verbatim from the current Water Quality Control Commission Open Meetings Act annual resolution. It's paragraph 3. If anyone wants to reference that, it's posted on the Water Quality Control Commission's website. But paragraph 3 reads, the commission may recess and reconvene a meeting to a day subsequent to that stated in the meeting notice if, and here's the requirements, prior to recessing, the commission specifies the date, time, and place of continuation of the meeting, and another requirement, immediately following the recess meeting posts or causes to be posted, notice of the date, time, and place of the reconvened meeting on the commission's website and in a public location at the Office of Public Facilitation, that's the NMED's Office of Public Facilitation, or such other place where the original meeting was held, and at least one other location appropriate to provide public notice of the continuation of the meeting.
Thank you.
So since Pam and I and Mada E are OPF, are Pam or Mada E available to post something on our door sometime soon?
Yep, I can take it there tonight if you'd like.
I know you would. And then there was one other place that Council Sanchez mentioned, and I didn't quite catch that part.
Well, the first one is the posting on the website.
I got that.
And then the second one is, as you've mentioned, a posting on the front door of the Office of Public Facilitation. And I would encourage, this is not required, let me be clear, by law or by the Open Meetings Act, but I would certainly invite the parties to post, as a matter of public interest, on their websites the date, time, and notice of the continuation of the hearing. The more we can get this information out to the public, I think the better our interests are served.
And Council Sanchez, we also have an e-distribution list that I can send to as well.
That'd be great. And if you have email addresses for the members of the public who have appeared thus far, if you can notify them as well, I think that'd be great.
Okay.
Okay, so I'm glad we got that taken care of. The next thing we should do is hear from the two public members that have been patiently waiting for us. Pam, would you please follow the first one?
Certainly. Miss Joni Ahrens, you're up. If you could unmute and turn your camera on, please.
Mr. Hearing Officer, I'm happy to wait until Wednesday if that's more convenient, so we could focus on the cross-examination.
Thank you. Yes, by all means, we will start at 10 o'clock, as you heard, and we will take public comment as soon as we begin. So Pam, if you could add that to your notice, that we will take, actually, we will just take public comment on Wednesday at various times throughout the meeting. So I'll keep calling it as we go through, okay?
Okay.
All right. Do we have the other member?
The other member is Logan Glassenap. I don't see him, but we do have one caller, one call-in, or actually there's two call-ins. If either of you are Logan Glassenap, please speak up.
Okay, we will come back to that. Let me ask Mr. DeSalen a question. Can you come back on, Mr. DeSalen?
Yes, Mr. Hearing Officer.
Is witness Sanchez available on Wednesday of next week? You knew I was going to ask that, didn't you?
Let me see if I have a response here.
And while you're getting a response, Los Alamos, I don't see you anymore.
We're here somewhere.
Somewhere, but I don't see you. There you are, Mr. Rose, I see you now. Do you prefer, since we're going to be reconvening on Wednesday, do you prefer to continue cross-examination or to begin cross-examination today, or do you want to wait till Wednesday?
Let me check. As I indicated before.
Oh, Meyerhoff, right.
His
Okay.
availabilities were limited on Wednesday.
Well, that's okay, Mr. Rose. We can do Meyerhoff today. We'll do Meyerhoff today.
Okay.
Let me find
Sure.
out what's happening with Miss Witness Sanchez. Mr. DeSalen, while you're checking that, we're going to start with the cross-exam because Dr. Meyerhoff has to leave, and we will come back to you in just a few minutes.
Okay, thank you.
Thank you. Which party would like to cross-examine Dr. Meyerhoff? I see you, Mr. Verheuel. So NMED, are there any others? Okay, Mr. Verheuel, please continue.
Thank you, Mr. Hearing Officer. I appreciate it. I only have a few questions for Dr. Meyerhoff. So when I'm through with my questions for him, would you like me to continue with my questions for Mr. Gallegos, or would you like to present Mr. Meyerhoff to the commission and to the members of the public?
That's what I'd like to do.
Okay, we'll do that then. Dr. Meyerhoff, I'm going to refer you back to, I believe it was your slide 18. Are you familiar with that slide, or can you have it somewhere where you can see it?
Yes, I have slide 18.
Great. Did you say, and I'm sorry, I can't recall now if it was a 2005 study or a 2007 study, but did you say that that study classified specific perennial waters within LANL?
No, I believe what I testified was that the 2002 study by Fish and Wildlife was used as the primary basis for deciding first what was perennial, because that's what they focused on mostly in that study, was identifying or studying specific perennial reaches. And then the remainders of the waters on LANL property were classified into 121C, which became 121-28.
I'm sorry, maybe it's my audio. I missed the last part of that. Could you just repeat the last sentence that you said?
And then waters that were not placed into 126 were considered then for 128. So the remaining waters were proposed to be in 128.
Okay. Based on your testimony that you've just provided, you've indicated that Triad and DOE, or I'll just say generically LANL, conduct regular evaluations of waters to determine if designated uses are appropriate. Did I understand that correctly?
Yes, I had a bullet in the slide. My indication that is based on my review of previous testimony provided for this commission, and also just as part of the preparation and discussion amongst the team, I have believe they are regularly looking at uses, just simply doing the hydrology protocol. They are looking at amount of flow and such that's available.
Have Triad and DOE provided E. coli data gathered during any of these evaluations to the Environment Department or to the Commission?
I can only say I'm not aware of that.
Okay. Are you aware that water quality segments can change characteristics and be inconsistent over the course of their entire length?
When appraised over their entire length, yes, I would agree with that. It is possible.
Okay. I have no further cross-examination questions for this witness at this time. Thank you, Dr. Meyerhoff.
Thank you, Mr.
Are there any other parties with cross-examination for Dr. Meyerhoff? Are there any commissioners with cross-examination for this witness? Are there any members of the public? Are there any redirect questions, Ms. McIntosh, for Dr. Meyerhoff?
No, Mr. Hearing Officer.
Okay, then it looks like Mr. Meyerhoff, thank you very much for your testimony. May he be excused?
Yes, Mr. Hearing Officer. Would it be possible to initiate the cross-examination of the other two witnesses? And if Mr.
It would. Hold on one moment, though. I did promise Mr. DeSalen that we would get his witness Sanchez in today if they could not appear on Wednesday. So what is the story?
Mr. Hearing Officer, I'm very sorry to say that Ms. Sanchez has a dental appointment on Wednesday and does not think she'll be very articulate afterwards.
Then please produce your witness and let's have her summary of her testimony.
Thank you, Mr. Hearing Officer.
I don't think she's been sworn, has she?
She has not.
Okay.
Ms. Sanchez, would you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you so much.
Ms. Sanchez, could you state your name, please?
With your respectfulness, I shall state my name in my native Tewa language. The translation is, my name is Wempovi Kathy Sanchez.
And have you prepared rebuttal testimony for this proceeding?
Yes,
Did you adopt that testimony today?
yes.
Now, could you please describe your background?
I am a proud lifelong resident of San Ildefonso Pueblo. I am a potter and a community organizer. I am the Sayain project coordinator for Tewa Women United, which refers to our circle of wisdom keepers, the grandmothers or the elders. I am also the past director of Tewa Women United. Tewa Women United, based in Espanola, is a component organization of Communities for Clean Water. I'm also a commissioner on the New Mexico Mining Commission and a commissioner on the New Mexico Surface Mining Commission. I have a Bachelor of Science degree in Education, elementary, in Chemistry and Biology from the University of New Mexico. I have a Master of Arts degree in Special Education from the University of New Mexico. I am a fluent speaker of Tewa, and I come from a Maria and Julian Martinez lineage of potters. Being the fourth generation who works with the traditional clay, I was mentored through a communal process to make pottery with generational family members. Many of San Ildefonso's ancestral homelands, which contain the pits where we used to gather clay, are on the property of Los Alamos National Laboratory or in the neighboring Santa Fe National Forest. In collecting clays and other needed materials such as volcanic ash for my pottery work, I have gained a deep reverence and appreciation for land, water, plants, wildlife found on the Pajarito Plateau and the canyons that run down through it. As part of my work with Tewa Women United and Communities for Clean Water, I have been an active participant in the permitting of Llano discharges into nearby waters. I have urged the permitting agencies to issue strong permits to protect the quality of our waters.
Thank you, Ms. Sanchez. And could you please continue with the summary of your rebuttal testimony?
I am testifying today on behalf of Communities for Clean Water in rebuttal of some of the proposals of Triad National Security and the United States Department of Energy. Communities for Clean Water was founded in 2006. It is a coalition of several diverse organizations that have a strong interest in protecting the precious water resources of northern New Mexico, particularly from the threats posed by Llano. Communities for Clean Water is made up of Amigos Bravos, Tewa United, Honor Our Pueblo's Existence, Our Hope, Concerned Citizens for Nuclear Safety, the New Mexico Sequia Association, and the Partnership for Spirituality. Our mission is to ensure that community waters adversely affected by Llano are kept safe for drinking, agriculture, sacred ceremonies, and a sustainable future. I am the past director of Tewa Women United. Excuse me, I have to close my door. My family's coming home. Okay, I'm back. I am the past director of Tewa Women United. Tewa Women United is an independent, women-centered, Native women-run nonprofit organization located within the northern pueblos of New Mexico. Tewa Women United is dedicated to a vision of making our families and communities healthy and keeping them safe. Tewa Women United promotes efforts and activities that nurture and care for the well-being of our mutually shared Mother Earth. This includes work to keep land, air, water free from all chemical and radioactive contamination. I have read the direct testimony of Dr. John Toll in this proceeding. Dr. Toll presented testimony on behalf of Triad and DOE. As I understand his testimony, Triad and DOE are proposing to amend the state surface water regulations to limit water analysis that LANO is required to do. I understand that under this proposal, LANO would only be required to conduct analysis of its discharge for compliance using analytical methods that have been approved by the Environmental Protection Agency under its regulation. I understand that EPA has not approved an analytical method for detect Pfas under these regulations. I understand that EPA has not approved a precise analytical method for detecting PCBs under these regulations. I understand if these proposals are adopted, LANO would not be required to monitor for Pfas at all, and LANO would not be required to monitor for PCBs at levels low enough to determine compliance with state water quality standards. Finally, I understand that these chemicals are harmful to human, to fish, and wildlife. We find these proposals to be very, very disturbing. As Native people and as rural people, our rivers and streams are very important to us. Water makes life possible. We rely on our waters for drinking, for irrigation, for livestock watering, for recreation, and for ceremonial purposes. Plants and fish and wild animals also need water for their sustenance, and they are part of our collective history and our culture. We want and expect water to be clean and free of harmful chemical pollutants. These chemical pollutants discharged into our waters are harmful to the health and well-being of the people who live near Los Alamos and rely on local rivers and streams. They are harmful to the plants and animals that also rely on that water. They are particularly harmful to the most vulnerable among us, to pregnant women, to children, to the sick, to the elderly. And these chemical pollutants are particularly harmful to the many members of our communities who have spent or who will spend their entire lives here. More harmful because these pollutants have multiple pathways into our bodies and are exponentially cumulative over time. We have a right to know what chemical pollutants LANO is discharging into canyon streams that flow along and near Pueblo lands into Rio Grande. Our members and supporters are very interested in this sort of information. We need to know what pollutants have been discharged into our waters, at what levels, during what times, and in what locations. We need this information so that we can avoid using waters that may be polluted, or so that we can take mitigating measures. For example, my family and I no longer eat fish taken from certain streams around LANO because of potential contamination with PCBs. And it is also important for the Commission to consider that most of the people who live downstream and downwind of LANO are people of the land, Native peoples, Native Americans, Spanish Americans. According to a DOE analysis from 2020, the total population living within the area potentially affected by LANO operations is more than 418,000 people. Of this population, 56% are Spanish Americans, and at least 8% are surviving Native Americans. The total minority population is nearly 283,000, or 68%. And we believe that this DOE report significantly undercounts the number of Native people that live in the area. The DOE analysis also notes that the pueblos of San Ildefonso, Cochiti, Jemez, Sandia, Santa Clara, Okeowinge, San Felipe, Santo Domingo, Nmed, Picaries, Powaki, Taos, Tetsuki, Zia, and other parts of Hickory Apache Indian Reservation are within the area potentially affected by Llano operations.
Now, Ms. Sanchez, that DOE document that you're referring to, is that CCW GRIP Exhibit number 4?
Yes, it is.
Now, please conclude your summary of your testimony.
We strongly oppose the proposal of Triad and DOE to limit the analysis that the state can require of our waters. We respectfully urge this commission to reject these proposals.
Thank you, Ms. Sanchez. I have no further questions. The witness is available for cross-examination.
Are there any parties that wish to cross-examine Ms. Sanchez? Are there any commissioners that wish to cross-examine Ms. Sanchez? Are there any members of the public who want to cross-examine this witness? Ms. Sanchez, thank you for your testimony.
Good. Thank you.
Thank you, Mr. Hearing Officer.
Let's deal with Exhibit 140 that I think everyone has received. Are there any objections to 140 being offered into evidence? Mr. Rose, did you get a chance to look at Exhibit 140?
Mr. Rose is just arriving, but yes, we have reviewed 140 and we have no objections.
Excellent. So it is now admitted into evidence. Mr. Verhule, you labeled it as Exhibit 140, is that correct?
That is correct.
Wonderful. Okay, so let us continue with the cross-examination of Mr. Gehring and Mr. Gallegos.
Thank you, Mr. Hearing Officer. And I don't know if any other parties have any cross-examination questions for Mr. Gallegos, but I'll go right into them. Mr. Gallegos, did Triad and DOE provide evidence and supporting documentation in this triennial review to demonstrate that all perennial waters within the lab should be classified in segment 126?
The evidence that we provided for taking waters evaluated, 128 waters that were evaluated to move into 126 were predominantly the information and evidence that Mr. Goring provided in his testimony, including some temperature data, pH data, dissolved oxygen data, flow data.
Was there any formal demonstration like a UAA and EUA, anything like that?
No, just no.
And no E. coli data provided?
No E. coli data was provided.
Okay. I'm sorry to have to make you dig up an NMED exhibit, but I'm going to ask you if you could to dig out NMED exhibit 88. Let me know.
Yeah, I have it in front.
Okay.
I've
Can you go to page 12, please?
I'm there.
All right. I believe there's a statement there from EPA in comment form that a UAA would be necessary to classify waters in section 126 that are presently unclassified. Is that your understanding?
That's what the comment says from EPA.
Could you read the comment out loud?
Would you like me to read the whole section or just the part that pertains to the UAA?
Just the part that pertains to the UAA, thanks.
So in reference to the discussions about the perennial waters, the waters with perennial hydrology, this segment retains both the previously designated cold water aquatic life and secondary contact recreational uses. Since the perennial portions of DP Canyon, Ancho Canyon, and additional perennial portions of Water Canyon have not been previously described in a regulatory segment, the Nmed Surface Water Quality Bureau must provide a UAA supporting the secondary contact recreational use as required by 40 CFR 131.10.
Okay, great. And I'm done with that exhibit. Thank you for digging it out. Mr. Gallegos, is it your understanding that the protections afforded by the designated uses for unclassified waters in segment 99 are more stringent than those of segment 128?
Yes, I'm aware of that.
Okay. Mr. Gallegos, you've mentioned that, well, I believe the Triad DOE position is that the lower extent of the reach for 2 Mile Canyon should be approximately 160 yards from the confluence with Pajarito Canyon. Is that accurate?
I'm not sure if your description of the extent as you described in yards, I'm not sure if that's accurate. But I'm sorry.
How would you describe? Go ahead.
Sorry, I'm sorry, sir. Would you repeat the question? Sorry.
Sure. My understanding was that the LANL position as to the lower extent of the reach for 2 Mile Canyon was approximately 160 yards from the confluence with Pajarito Canyon. But if you want to clarify that, please go ahead.
So the reach between Pajarito Canyon and with the confluence of 2 Mile up to E244 is approximately 0.2 miles.
Okay. Can you tell me what geological or anthropogenic barriers cause the intermittency to end precisely there?
So I don't know if the intermittency necessarily ends there. What I'm advocating for, what we're advocating for our position is that the protections afforded to 140 waters not extend beyond that gauge, E244. So the hydrology protocol indicated that a score of 10.5, which falls within the range of intermittent waters as NMPD has developed that, we don't maybe disagree with that the waters may be intermittent potentially, but the protection should not extend beyond that point. And we didn't find any evidence when we looked at the level 2 information that warrants extending it beyond that point.
Okay. So speaking of the hydrology protocol, does the hydrology protocol survey methodology prohibit a determination of intermittent if benthic macroinvertebrates are absent?
It doesn't prohibit it, but the absence of macroinvertebrates reflects on the final score. And so it would have it carries a certain amount of weight when it comes to that.
Okay. I want to go back to the visual you had on the classifications that was from the Environment Department's EnviroMapper. And I don't know if you want to have that in front of you. I don't know if you need to answer this question. You tell me once I ask the question. Can you tell me what layer that data came from?
It came from the, it looks like it came from the Assessed Streams 2018 layer. If I'm referencing correctly.
That sounds right to me. So that doesn't necessarily reflect what's in EnviroMapper today, does it?
When I looked at EnviroMapper, this version was the most recent version that wasn't a draft version.
Can you tell me when, to the best of your recollection, you most recently looked at EnviroMapper?
Within the last couple of weeks. I don't remember this precise day.
Okay.
But it's very recent.
Okay. So the proposal here of LANL to reclassify these perennial waters in section 126. What happens if the commission agrees with your proposal and they in fact make that amendment, but then we submit those changes to EPA and they don't approve of it? What's the result then? Do you know?
Mr. Hearing Officer, I believe that's a legal question that would depend upon EPA's direct response as to why they did not approve it. So it either calls for a legal conclusion or speculation.
Mr. Verheul?
I don't think it does. I'm asking what this witness's understanding is of what effect that would have on what protections are afforded those perennial waters.
I'm going to sustain the objection. Why don't you rephrase your question? Or not?
I'm sorry, give me 1 second. I don't think I have a way to rephrase that question, Mr. Hearing Officer. So thank you. I have no further questions for either Mr. Gallegos or Dr. Goering at this time.
Thank you, Mr. Verheul. Are there any other parties that are going to want to cross-examine these two witnesses? Are there any commissioners that want to cross-examine these two witnesses? Are there any members of the public?
Yes.
Ms. Ahrens?
Yes. Thank you, Mr. Hearing Officer. Mr. Goering, in your slide, in your slide, I'm sorry. In your slide that showed the data from Effluent Canyon, that data was from 2005 to 2010. Is that correct?
Yes, that is correct.
And is there a reason that more current data is not available?
2010 is when these data were stopped being collected. I don't know the reason.
Thank you. Thank you, Mr. Hearing Officer.
Ms. McIntosh, do you have any redirect for these witnesses based on the questions Mr. Verheul and Ms. Ahrens asked?
Yes, Mr. Hearing Officer, but I will be very brief.
Okay.
Mr. Gallegos, Mr. Verheul asked you about evidence supporting the LANL's recommendation for perennial classification of the studied section 128 waters that we're talking about? And was there substantial supporting evidence that was included with your direct pre-file testimony, Lanel exhibit number 3?
Yes, there was.
And specific exhibits included 37, 38, and 39?
That's correct. That's correct.
Mr. Verheul also referenced you to NMED Exhibit 88, page 12, and asked you to read EPA's comments with regard to the certain perennial segments. But the segments that EPA commented about are not any of the sections in Starmers or Pajarito Canyon or Arroyo de la Delve, are they?
That's correct. They did not. They did not refer to those sections.
So EPA's comment had nothing to do with Lanel's recommendation concerning the 126 reclassification that is being proposed for the commission. Is that correct?
That's correct.
Now, Mr. Verheul also asked you if Section 99 was more protective than Section 128, but he was not specific about particular uses. Sorry, let me rephrase that. Section 90, he asked you about Section 99 being more protective. But isn't it also true that Lanel is recommending, instead of Section 99, classification into Section 126? And 126 is more protective for aquatic life uses than Section 99, is it not?
Yes, it is.
And then finally, with regard to the recommended terminus for the Section 140, new Section 140 classification of 2 Mile Canyon at gauge E244, below that gauge, did Lanel find any bivalves, any water, or any benthics to justify 140 classification?
No, we did not.
And did you hear the testimony of Amigos Bravos recommending specific geographic or locatable termini or terminus for a given classification?
Yes, I did.
And is the recommended terminus at gauge 244 responsive to that recommendation?
Yes, it is.
I have nothing further, Mr. Hearing Officer.
Thank you, Ms. McIntosh. Then I believe these 2 witnesses may be excused, and that leaves us with Section 8, if I'm not mistaken. And these,
I believe that's correct, Mr. Hearing Officer.
and I don't believe these witnesses are testifying in that section.
That is correct.
Mr. Hearing Officer,
Yes, Ms. Fox.
Ms. Khan has some testimony on this issue. Rebuttal
Marvelous.
testimony.
Marvelous, marvelous. So we will get to that on Wednesday morning. But these witnesses, I believe, can be excused. Mr. Sanchez, was there something you wanted to mention?
Yes, thank you, Hearing Officer Shakalan. I'd like to address a concern or a housekeeping item with Chair Stringer, please. Chair Stringer, this is kind of a version of what's good for the goose is good for the gander, insofar as the item 5, the triennial review hearing, is being held in the context or as part of the meeting, the WQCC meeting. You'll also need to go ahead and recess the meeting and note for the record that you're reconvening the meeting on Wednesday, July 21st at 10 o'clock in the morning.
Okay, I can do that after we've completed the day's business, correct?
Okay, I just wanted to make sure Hearing Officer Shakaden did his good night abruptly. Thank you.
Okay, thanks.
Thank you, Council Sanchez. All right. Is there anything else we want to address before we adjourn the meeting after Chair Stringer has her housekeeping? No. Okay. So on Wednesday at 10 a.m., we will reconvene with Amigos Bravos presenting its witness on issue number 7. And are there any other parties with witnesses on issue number 7? I don't hear any. So then we have one witness for issue 7, and then we do witness issue number 8. Okay, I hand the meeting over to Chair Stringer. Thank you. I'm going to sign off now.
Excuse me, Hearing Officer Shakaden, just before we leave,
Maybe
just
I'm
so we
not.
don't run afoul of paragraph 3 of the annual resolution, let's state for the record that the hearing will reconvene and be accessible on the same hyperlink that was posted on the meeting agenda. Thank you.
So you've said it. Do I need to say it?
No, I think that's
Okay.
probably sufficient.
Okay. Thank you, Council Sanchez.
And one last housekeeping item before we recess the WQCC meeting, which is to confirm that the court reporter has availability on Wednesday and can record the hearing.
I am unavailable on Wednesday. No, just kidding. I will make arrangements to be here.
Appreciate that you've kept your sense of humor through all of this. Okay, well, I think that covers everything. So I would like to recess the Water Quality Control Commission hearing, and we will reconvene next Wednesday, July 21st at 10 a.m. Thank you all. Have a wonderful weekend.